All right, all right, all right. Hey, what's up? It's your girl Neek, and you're tuned in to Neek at Night. Hopefully, my sound is coming through pretty good. Um, Hopefully, you guys have come here because you want to know what the motion for new trial says in its entirety. There has been several different news sites that have basically quoted what was said in the motion for new trial, summarized what was said in the motion for new trial, but I wanted to do a dedicated live where we went over everything. Now, the motion for new trial in Karmelo Anthony's case is 193 pages. Now, as I told you guys in my post outside of this, I submitted all of my correspondence with the court and things that I felt was pertinent for his defense team. I was put in contact with Karmelo's new defense team by Thelma from the Public Opinion Court. She put me in touch with Russell Wilson, his lead counsel, and I've been conversing with him ever since. They wanted to know about my experience with access to the trial and anything that I had that can help with the arguments that they were making in this new trial. Now, as the legal process was going on, I didn't want to say anything. I wanted to let the proceedings be filed, and then once they were filed, talk to you guys about the process of what has been going on. All right, so I submitted, I want to say in the filing, it is, my evidence starts at page 100 and it is exhibit 8. Okay, so they have from exhibit 8A through 8I is everything that I submitted to his counsel. We're going to be going over all of that as it's very important. Now, if you guys are listening to this on the replay and you're not catching this live, I do not speak fast, okay? There's a lot of people who, they read these things really quickly. They read them really fast. I'm not somebody who reads through these documents very fast. I take my time in reading through it. But if you're watching this on the replay, there is an option to speed me up, all right? So you go into your settings. You go to the playback speed, and this is only for the replay. Those of you guys who are here with me live, y'all got to just bear with it, and y'all just got to sit through. Okay, it is what it is. But the people who are watching on the replay, you can go to the settings, you can go to the playback speed, and you can make me talk as fast or as slow as you would like to get through, because like I said, we have 193 pages to go through of this motion. So let me pull up. I have like a little banner that I wanted to put up, but let's not worry about that. Let me pull up the document. Let's put my watermark up there. Okay. And let's do this like that. All right. So I'm going to read through this official filing for new trial for Karmelo Anthony. If you guys are watching, make sure you share the live. All right, we want everybody to be inside the building. Share the live, hit the like button. If you want to donate to the stream, you guys can donate down below. Neek at Night Media is my Cash App where you guys can you guys can donate to the stream, etc. So, am I coming through clearly? Can you guys hear me? Everything clear? Before we proceed, let me make sure you guys can hear. Oh, you said, Neek, may I please have my wrench back? Why don't you have it? Just remind me in a minute. Remind me in a minute. But okay. All right. So let's get into it. Make sure you hit the like button. Make sure you hit the share. For some reason, I'm shadow banned on YouTube. I've been shadow banned for quite some time. My videos are not going in the algorithm like they're supposed to. So I need you guys' help to push my content out there Share it on your pages. Don't steal my content now. There's a difference. Share my link. All right, share my link. All right, now let's get into it. So this is the first page of the filing, but we're going to go to page 100. All right, so let me go to where I am really quickly, just to show you guys that we ain't bullshit. You know what I'm saying? We keeping it trill. Let's go to page 100 just really quickly, and then we're going to go back to the top. So this right here is Exhibit 8, and these are these are the exhibits that I have that I handed over. So as you can see, it's 8A, 8B, C, D, E, F, G, H, all the way down to I of things that I provided. So in covering a trial, anytime that you are media, you can reach out and try to get access with your media credentials. And we were sent a media request intake form. Now, the intake form was first presented as if it was open to all media. It was presented as if the 9 slots that were given to the media was going to be fair, and it was going to be based on credentials and not based on just simply who covered in Collin County before. They gave us this intake form to fill out. I filled my credentials out on here, and they made us wait for quite some time to see if we were going to be able to cover the trial or not. In this intake form, they also told us that there would be an overflow room as well. And it said whether or not we wanted to have access to the overflow room or if we wanted to have access to the main courtroom, etc. And in the special comments is where you laid out, you know, your credentials, your requests, like anything that you wanted to put, etc., etc. You were to put it there. So I gave them that. Now, I also handed over email with the first PIO. Now, the first PIO on the case was a guy by the name of Derek. He was the one who first said that he was going to be taking our credentials, etc. And, you know, it went from me reaching out to Derek, getting blown off, and then it went to the PIO Steve, etc. So we're going to go over all of those in great lengths, but let's go back to the top. Okay, I just wanted to show y'all they're there. All right. But let's go back to the top and let's go in order, and we'll get there eventually. But I just wanted to show y'all that real quick because over on Facebook, there was a bunch of racist bigots who felt like I needed to lie about being in contact with Karmelo's legal team and act like I needed to lie about handing over emails in the motion. So I just wanted to get them out the way because I don't like racist bigots on my live, but I know there was a lot of them to try to see if I was lying or not. You guys can go now. This is a bigot-free zone, but because you guys are so obsessed with the Black community and so obsessed with us, I know that you will stay and watch. But I just wanted to get y'all out the way first. Now, let's go to the first page of the filing and let's read it. So it was filed and it says defendant's motion for new trial and brief in support. It says, to the honorable judge of said court comes now Karmelo Sincere Anthony by and through the undersigned counsel and pursuant to rules 21.1 through 21.9 of the Texas Rules of Appellate Procedure, moves the court to set aside the judgment of conviction and sentence and grants a new trial. The defendant moves for a new trial on 4 grounds. First, the court committed structural error when it materially restricted public access in violation of the right to a public trial. Second, the state's what does it say? Of the parties' unrecorded evidentiary agreement after the defense relied on it, coerced the waiver of Mr. Anthony's right to testify and denied him a complete defense in violation of his constitutional rights. Third, the trial court improperly instructed the jury on the appellate law. Fourth, the cumulative effect of these errors warrants a new trial in the interest of justice. So, as I told you guys, there was a lot of nefarious things going on in the trial. There was a lot of things that I had never seen done before, and it was very clear to anybody other than racist bigots that this was not a fair trial. Now, a lot of people think that when you are saying that he didn't get a fair trial, you're saying that he didn't do anything wrong and that things could not have been handled differently. That's not what us of sound mind and body are saying, or critical thinking skills that are absolved of bigotry and white supremacy. Those of us are saying that in America, you're supposed to have a fair trial, and whether or not you are guilty or innocent, the justice system should be just and fair, and the evidence should be presented correctly and before a court of law. And after that is done, then whatever happens after that is what it is. Okay. Nobody is saying that he should not go through a fair trial. We are saying the trial that he received was not fair. It was a kangaroo court. It was unjust, and only racist bigots think otherwise. Okay. So let's continue. So it says this case presents a structure. Hold on, let me make this bigger, y'all, child, so I can see. All right. So it says this case presents a structural public trial violation. The court had authority to manage courtroom security, decorum, and capacity, but once it adopted and administered restrictions that foreseeably excluded members of the public from a high-profile criminal trial, it was required to make record-supported findings and to consider reasonable alternatives to closure. The court did neither. The access regimen limited public attendance to a narrow daily admission period of a small number of seats and no continuing overflow or audio or video access after jury selection. Because that closure affected the trial proceedings themselves, and for the 3 additional grounds set out in this motion, defendant asked the court to set aside the judgment and grant a new trial in support of defendant. And then they show the following. Now, I'm going to pause again because people also think that people who are happy that they filed a motion, they think that we're ignorant to the judicial process. We're not ignorant to the fact that motions for new trials are hard to get granted. We're not ignorant to the fact that the appeals process takes time. We are well aware of that. Okay, somehow, some way, people feel like they need to educate you on how long an appeal takes, and they feel like they need to educate you on how often appeals are granted. We're not ignorant to those facts. However, these are procedural things that need to be done so that he can get a fair trial, and hopefully the justice system will see that there was critical errors made, and they will see that there needs to be a new, fair, just proceeding over Karmelo with an unbiased judge who is not clearly, trying to convict him based on his rulings and lack thereof. So I just wanted to say that as well, because on my last post, there was a lot of people who felt like, well, let me educate you because y'all don't even know. We know that we're in America. Okay. We know that. We know the judicial system has their roadblocks. We know that. However, with a dream team such as Karmelo has, hopefully they were able to accurately argue the facts and get Karmelo a fair trial. Okay? Because who y'all be thinking y'all talking to is what I want to know. I mean, look, what's going on? Let me know. I don't know. But let's go to page 2. All right. So it says factual background. The case and the verdict. This case arises from an altercation at a high school track meet. The defendant, Karmelo Sincere Anthony, was charged by indictment with the murder of Austin Metcalf, alleged to have been committed on or about April 2nd, 2025 in Collin County, Texas. The defendant pleaded not guilty. His defense at trial was self-defense, that he used force he reasonably believed immediately necessary to protect himself. The court's charge submitted to the offense of murder, the lesser included offense of manslaughter, and the law of self-defense, including the justified use of deadly force. The defendant did not testify. On June 9, 2026, the jury found defendant guilty of murder, and the court imposed a sentence of 35 years of confinement. These matters appear from the indictment, the court's written charge, and the judgment. The case drew national attention from the outset, and the court appointed public information officer to assist with media credentialing, communications and access, logistics and practice. Public and media access were administered through the process. Example 1, example 7. What follows is how the access, in fact, administered before trial and at the perimeter of the courthouse campus, at the courtroom door, and after the verdict. B, secrecy before trial. The gag order, chambers conferences, and no public pre-trial hearing. Now, if you guys remember, if you guys watched my coverage of this case, I kept being skeptical of what Mike Howard was doing because I was like, I don't know what was in the pre-trial motions. I said over and over again how I didn't see any of the prior rulings to know why he wasn't vigilant and zealously defending his client. Why wasn't he saying this? Why wasn't he bringing it back to self-defense? Why wasn't this going on? And I would always tell you guys, I don't know what the pretrial motions are. I don't know if there was something precluded. I even told you guys in my videos, I was like, they're not objecting. Like, he's hardly objecting to anything. And I told you guys how I'm like, I don't know if they already decided things, the reason why he's not objecting. I'm like, I'm not a lawyer, so I don't even know why this would be, And come to find out, after the trial concluded, there was a lot of lawyers who were lawyers and did have law degrees, and they talked about how that was not the way that the lawyer was supposed to proceed. They were talking about how they were supposed to be objecting to this and that and all of these things that I found out afterwards. Let's help the racists find somewhere and find some business. Hold on one second. Let's clean up house. Let's clean up house really quickly. Let's do some housekeeping because I don't know if my mods are not here, but let's do some let's see. All right, what should we do? Should we do subscribers for a month, a week, 2 weeks, 5 weeks? Let's see. Let's see if that cleans it up. If not, we'll do more. They're so obsessed with us. It's so crazy. Like, aren't they? Like, they love us so much. It's crazy. But let's continue to let's read through. All right. Somebody said 2 months. Oh, okay. A month or 2 months, because I did 5 weeks, but we can go more. Somebody said subscribers for a year. I know that's right. Let me know. Let's see if that cleans up the trash. If not, we can do more. So let's go on to page 3. And again, like I said, I'm taking my time reading through this. So, hey. All right. So it says, all right. Defendant's motion for new trial and brief in support. So it says evidence anticipated to be introduced at trial, or that I intend or is likely to influence public's opinion or potential jurors. Restrictions expressly applicable to any public medium, including traditional news outlets and social media, and enforceable by contempt fines, attorney discipline, or other remedies. Example, 1 attachment. Its findings were 3 sentences. The media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial. That alternative measures venue change, juror screening, sequestration would be inadequate alone, and that narrowly applied speech restrictions are necessary to protect juror impartiality. No evidence is recited. The other permitted only procedural announcements, etc., like hearings, schedules, and court filings and statements required by legal or ethical duty. A safe harbor that presupposed filings the public could see. By its terms, it would yield only the further written order of this court, and the amended order later reaffirmed it until the completion of the trial. In the 10 months it operated, no person was ever alleged to have violated it, so far as public record reflects. And if you've seen the behavior of these racist bigot influencers that covered the trial, they violated all kinds of things. They doxed people, they harassed people, they tried to intimidate and bully people. None of this stuff was reprimanded by the court. It was allowed to go on. The PI knew about this behavior. The court knew about the behavior. The judge, the sheriffs, all of them knew about the behavior, and they continued to keep this conduct up that can obviously affect the jury and them being impartial, etc. So hopefully we'll see what goes on. So let's see. It says the substantive pretrial work of the case was then conducted out of public view. The parties' pretrial conferences with the court, including a May 21st, 2026 conference in chambers at which the parties' evidentiary understanding was described to the court, and a May 29, 2026 meeting addressing trial security and scheduling occurred in chambers outside of open court. No reporter's record of them exists. A matter the hearing will confirm. No pretrial hearing was ever held on the access restrictions, and the register of actions reflects no such settings. Exhibit 2. The public docket discloses no motions in limine and none of the substantive pretrial litigation that in fact occurred. Filings that were hand-delivered rather than filed in the district clerk's public record. A member of the public who examined the docket before trial would have found no hearing to attend and nothing to read. C. The amended order, the written terms of access. On May 18, 2026, the court signed the amended order regulating trial proceedings, media access, security, and courtroom decorum, entered to govern all aspects of the trial proceedings. The order recited the directives of Waller v. Georgia and Shepard v. Maxwell, found that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial, and promised reasonable public access consistent with constitutional requirements. It says, next, defendant's motion for new trial and brief support. So let's go to page 4. And also, too, everybody, I'm going to break up the different parts in smaller videos. Right now, I'm just going to read through everything. And then those of you guys who only want to know about, like, I want to know about this part of the motion or that part of the motion, we'll break that down into smaller videos. All right. Who are y'all talking? Who's Shaquille? Do I need to go longer? Hold on, y'all. Or just ignore them. Like, just ignore them. They want attention, so just ignore them. Let's go to page 4. Anyways, oh, hold on, wait. Hold on. Where's Nita? She wanted me to make her a mod. Where's Nita? Hold on. Let me make Nita a mod real quick. Nita, comment so that I can make you a mod. Where's Nita? Where is Nita? Somebody said, make me a mod. It needs to be somebody that I know for sure that's not just gonna sabotage the chat, like that I've seen here multiple occasions. I don't see Nita in the chat. Maybe she ain't following. Nita, is you busted, girl? Are you not following me in the last 5 weeks, girl? Nita, girl. Cause where is you at? Where is you at, girl? In the meantime, we got Web Family. We got Web Family because, girl, not you busted. You busted, girl. All right. But I do recognize her from always being here, but let me find out she not all right. Okay, I see y'all. Okay, let me get back to it. Because I know y'all like, girl, how we on page 4 and it's already 30 minutes in. I know. All right, let's get down to business. Let me drink some more of my coffee and then let me just go. Let me get to it. All right, let's go. All right. So, all right, let's go back. Okay. So, defendant's motion for new trial and brief in support, it says number 8. Its operative term were these. The courtroom would open at 8:30 a.m. for media, at 8:40 a.m. for designated family members, and at 8:50 a.m. for the general public. No more than 9 members of the media would be admitted. Seating would be on a space available basis. The doors would close promptly at 9 a.m. Individuals arriving after that time would not be admitted until a recess, and no person who left could re-enter except at a recess. All persons attending were required to dress in appropriate business attire. Hats and caps were prohibited, and clothing or items displaying messages, logos, symbols, or images related to the case or otherwise distracting or potentially prejudicial were banned. The order appointed Steve Stoller, identified in the order only by personal email address and cell phone number, as the court-appointed public information officer, committed media credentialing to that office, and announced that the court will not intervene in or resolve disputes amongst members of the media regarding access or seatings. The order contained no provision for an overflow room, an audio feed, a video feed, or any other means of observation for members of the public turned away, and no mechanism by which a member of the public could be heard to object to any of it. The order also closed the courtroom grounds themselves. It placed the entire courthouse campus, including parking lots, sidewalks, green space, or any other designated area, under a nightly curfew from 11 p.m. to 6 a.m. beginning May 31st, 2026. It designated restricted zones on an attached exterior map, and it ordered the Collin County Sheriff's Office and other law enforcement personnel to ensure compliance with this order at all times during the trial. Under the order enforcement clause, any violation, including a citizen's presence in a courthouse parking lot or on the green space beside the courthouse before 6 a.m., expose the violator to immediate removal from the courtroom, courthouse, or courthouse grounds, and the imposition of sanctions, including contempt of court, and no warning is required prior to enforcement. No findings of any kind accompanied the curfew. So, as I told you guys, in my experience, I was coming to the court at 6 a.m. on June 1st, 3rd, and the 4th. I got there at 5:58. Up until the 4th, they were enforcing the 6 a.m. curfew, right? So on June 1st and June 3rd, during jury selection, they told people who came before 6 a.m. that they had to leave out of the parking lot and not enter in the parking lot until 6 a.m. On Thursday, June 4th, I arrived at the court and I got off of the exit at 5:50. My uncle was following behind me. He had met me at my hotel and we got off of the exit at 5:50. Because all of the other days they had been enforcing this no attendance before 6 a.m., I drove up the block, came back around, and then drove around. And then when I came back up, it was 5:58. I started to see cars already turning into the parking lot. So at 5:58, I turned into the parking lot because all of the other days I was extremely cautious of not violating this ban. I did not want any reason for them to throw me out of the court. When I pulled into the parking lot at 5:58 on June 4th, there was no restriction of the parking lot prior to that. There was about 15 members of Austin Metcalf's family who the sheriffs had instructed to arrive earlier before the curfew ban. They were already in line at the front. When I arrived out of my car, I was number 27 in line that day. Okay? There was 26 people not getting out of their car, not walking to the line. There was 26 people already in line at the front of the courthouse, already lined up in order. All right. Now, I know Miss Liar told you guys that people cut her. She's a fucking liar. And she arrived well after. She failed to mention how 15 members of Austin Metcalf's family arrived and were in line prior to 6 a.m. because she had a narrative and an agenda to impose. And she wasn't there to see that because she's a fucking liar. But I arrived and they had, like I said, had gave Austin Metcalf's family the jump on the line. They were already lined up. It was about 15 of them already in the line, and the sheriffs did not honor the same 6 a.m. ban before that day that they were honoring once the trial officially started. So after that, people started to arrive even earlier because they were allowing news media to sneak on the premises at 4:30, and they were allowing Austin Metcalf's family to enter the premises at 5:30. They were allowing his family early access. So it caused this frenzy that was happening at the court. I spoke to you guys about this on previous lives, and this is part of what they're talking about, where there was no findings of any violations of this because they did not impose it. Because if they imposed it, then they would have to impose it for Austin Metcalf's family. They would have to impose it for the racist bigot that was spinning her narrative to sour the jury pool, etc. They purposely allowed certain bad actors to come into the court to poison the jury with things on social media because they wanted this to go a particular way, in my opinion. Now, D says access in operation, the curfew, the parking lot, and the pre-dawn line. In operation, admission had almost nothing to do with the order stated 8:50 a.m. public entry time. Because the public seats were few, members of the public began arriving in the pre-dawn hours between 4 and 5 a.m. before court was in session, all while the campus curfew was still in force, and sheriff deputies enforcing the order stopped arrivals at the parking lot and restricted entry onto the campus until the curfew lifted at 6 a.m. All right, so let's go to the next slide. All right, so it says defendant's motion for new trial and briefing support. So it says sheriff's deputies enforcing the order stopped arrivals at the parking lot. Okay, it says the queue that actually determined who would see this trial thus formed at the perimeter of the courthouse campus hours before any proceedings convened. A member of the public who appeared at the order's appointed hour at 8:50 a.m. had a practical matter no prospect of a seat, which is true. There was no way, if you showed up when the judge said to show up, that you would get a seat. We went to that court on little amounts of sleep. We could barely sleep. The judge ran the court from 9 to 6. And then after 6, those of us who were reporting on the case, we did lives that took about 2 hours to go through everything. But in order to even start our lives, we had to do safety measures. We had to do, drive out of the way, make sure people weren't following us, all kind of things like that. Then go live, then, prepare for the next day, all to have to be back at the court between 4 and 5 a.m. to get a seat for a court that started at 9 a.m. This is all things that happened covering this trial. All right. It says the line itself was administered without published standards and not even-handedly. Individuals were permitted to move ahead of members of the public who had already waited for hours. Thelma Anderson, who arrived early on June 6th and initially held approximately the 7th position, was displaced to approximately 35th, beyond the number of available seats, and was excluded from that morning's proceedings. Tamitra Carter, identified as number 7 on early arrival lists, was removed from the line on June 5th and lost the morning session. Admissions was run through 2 lines, one for a media list, one for everyone else. And media outlets denied credentials were directed by the public information officer to seek entry through the public line. Whereas Collin County Sheriff's deputy administering the line acknowledged on video persons who print out whatever to make themselves like they are media, consume the public few seats, and practice the officers conceded they could not police. So what they're talking about is what was happening. So as I told you guys, media was able to access the parking lot before the general public. So at 4:30, the lot would open up for media. WFAA had one of the 9 designated seats in the courthouse, right? However, they had their correspondent to do like the internet live updates, and then they had their reporters and legal experts. So what I witnessed, and I'll go to court and I will testify to that because it is a fact. What I witnessed from WFAA specifically was they would use their one credential seat to gain access for their other correspondents to get into the public line ahead of everybody else. And the public line was supposed to be first come, first serve at 6 a.m. And those of us to all, go in order that we arrive. Certain news media outlets were using credentials to access the parking lot at 4:30. And the way that they started to do it was they were allowing the line to form at the front of the courthouse. So everybody else who was general public, we would be held outside of the court perimeter, right? The news was able to access the court inside the parking lot. They would not authorize first come, first serve in the order that we came. They told us, the sheriffs told us, they're not policing first come, first serve as Judge Roach told us. It's about who lines up in the front first. So what we would have to do is when they open that parking lot, we would have to run to the front to get in line, to get a position, and it would cause all kinds of chaos because they would not honor first come, first serve. They were allowing news media publications to enter into the parking lot first, and that gave all of us regular people in the public a disadvantage. It was a lot of bullshit that was going on. Now, again, there were other white bigots that were covering this trial. You would never hear them accurately report what was really going on because it went against the narrative of them blaming Carmelo Anthony's supporters for everything. If they were truthful in their reporting, they would be truthful about how the court was operating, but they'll never be truthful because they're liars, racists, bigots, fucking miserable souls that thrive on the obsession of Black people and grift off of victimhood. That's what they do. They create scenarios that they instigate people, and then when people respond, they act like victims. And that's kind of what they do. So they'll never admit like the truth. They'll just instigate Black people to have a reaction to them. And then when Black people have a reaction to their harassment, then they act like their life's in danger and play victim. That's literally what they do. And then other white racist bigots pour into their fundraisers. Oh my God, poor you. Oh my God, you created all this bullshit for yourself. You attacked all these people and now they're responding. Oh my God, how dare they respond to you doxing them? Oh my God, I can't believe that people are being so reactive to you antagonizing them. Oh my God, poor you. Let me give you money. Like, so stupid. Like, racists are so ridiculous, but it works for them, you know? That's what they do. So anyways, so let's go on. All right. So it says inside the courtroom, 24 public seats and an overflow room provided and then withdrawn. The courtroom held approximately 70 seats by the court-appointed public information officer's own written account. 15 were allocated to the prosecution's family, 15 to the defense's family, and 9 to the media, including the courtroom sketch artists, with additional seats for court staff, leaving about 24 or so seats for the general public. The trial judge later confirmed that 200 requests by the media and 27 to 32 public seats that we rotated every day. None of these allocations appear in any order, and the 15-seat family member allotment was not honored in practice, the defendant's own family was limited to 8 seats in total, so that his grandfather and his aunts were excluded from his trial, while those admitted were required to register a day in advance and were warned that a visible facial expression could result in removal. Now, that's funny that these restrictions, that facial expressions and all of these things could result in removal, when they strategically placed Austin Metcalf's family in front of the jurors, and they often would do facial expressions. They would be crying, they would be sniffling, they would be doing all kind of gestures. Austin Metcalf's father, according to Queen Sheba, she witnessed him, and Court TV's Cody also witnessed him like coaching the witness. None of those things prompted their family to be removed. There was often facial expressions nonstop and all of those things. None of that prompted their removal at all, but that was some of the rules that Karmelo's family was to abide by. All right, so let's go to page 6. All right. So it says, for jury selection, the court furnished what its order had never promised: an auxiliary viewing location outside the courtroom, a functioning overflow room where members of the public who could not be seated inside observed a proceeding on June 1st and June 3rd, 2026. On June 4th, 2026, the first day of testimony, the court eliminated it. No announcement was made in open court, no order was entered or modified, and no findings were made. Public access were thereafter confined to the seats inside Exhibit 14, Exhibit 16, Exhibit 18, nor was the elimination a reaction to anything that occurred at trial. As early as May 25th, 2026, the public information officer had advised an inquiring journalist in writing that there will be no overflow room during the trial. This, although the county's own media request intake form listed overflow room access among the accommodations that could be requested. When Thelma Anderson asked the court for an alternative viewing location, there was no way even to file the request to the county's electronic filing system, had no category for courtroom access requests in a criminal case, so the request was routed by email to the court coordinator and on the public information officer, and it was denied outside any judicial proceeding. The public information officer confirmed in writing there is no overflow room. All right. The day by day, the accommodations existed only while no witness testified. The pattern is visible day by day during jury questionnaire and voir dire. June 1st and June 3rd, an auxiliary viewing room accommodated the members of the public who could not be seated inside. On June 4th, the first day of testimony, that room was eliminated, and on every documented day of testimony thereafter, members of the public were excluded. The accommodation existed precisely when no witness was testifying and vanished precisely when evidence began. All right. So it says the filings that it's going to show. So let's go to the next page. All right, so these are the different days that they didn't allow like an overflow room. It says viewing room eliminated without announcement, order of findings from a line, roughly 80 to 100, approximately 27 admitted. It says on June 5th, Anderson excluded Carter, removed from the line and denied morning session. PIO confirms in writing there's no overflow room. June 6th, Anderson displaced from approximately 7th to 35th in line, excluded. It says June 8th, same, no overflow room, no audio, no video access. remain in effect. Public access, if any, remain limited to the courtroom seating. June 9th, same. No overflow, no audio, no video access. Da, 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 da. All right. So it says the exclusion that followed were repeated and concrete. Jacqueline Yan traveled from North Carolina and on the first day of testimony found a line of roughly 80 to 100 people, from which only about 27 were admitted. Tiara Allen flew in from Arizona, observed jury selection from auxiliary viewing room, and was told on June 4th that the room had been eliminated and was excluded from the courtroom. And on June 4th and June 6th, Bridget Smith attended June 1st, 4th, 5th, and 6th and confirms both the roughly 27 seats public cap and elimination of outside viewing locations once testimony began. Kiaria West was turned away on June 1st and purported jury members only rule and was physically removed from the courthouse on June 6th because the expressive content of her clothing. Thelma Anderson was excluded on June 4th, June 5th, and on June 6th was seated only in mid-afternoon after substantial portions of the day proceedings had passed. Let's go to the next one. All right. So it says throughout, no declarant observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions. The unrecorded agreement, the defense tried its case under the law limitations in reliance of an understanding reached off the record. So now they're going to go into the backdoor negotiation that the prosecution had with Karmelo Anthony and what that's all about. What are y'all talking about in the chat? Are you guys hitting the like button? My coffee, my iced coffee is watered down, but we're still gonna drink it. Are y'all hitting the like button? Somebody said, are we still on this? Yes, we are. It's a new update, a new motion. And we're going over every single page, period. So hit the like button, take a seat, grab some popcorn, or go on about your merry way. Either or. And catch us on another topic. All right? And if you want to donate to the to the page, it's Neek at Night Media, period. All right? So let's go on to the next one. It says the unrecorded agreement. So 16, the same off-the-record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May 2026, the lead prosecutor proposed that the parties try the case clean, based only on what happened under the tent that day, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. The terms were negotiated in meetings and calls on May 5th, May 8th, May 11th, and May 21st, 2026. The parties presented the understanding to the court itself in chambers, off the record, to avoid media reporting on bad act evidence. The understanding was memorialized only as a deliberately generic motion in limine, hand delivered to the court on the first day of trial. It does not appear on the public docket. From that point forward, the defense tried its case under that limitation at every stage. In reliance on the bargain in voir dire on June 3rd, the defense did not explore with the panel the themes of the decedent's character and aggression it otherwise would have developed. And as you guys know, if you have been watching social media, Austin Metcalf's character was that of a bully. He bullied cheerleaders. He bullied other people. Him and his brother, Hunter, are outright bullies. They are thugs. And unfortunately, he lost his life, but he was a thug. And that character should have been presented to a jury. However, his bad acts and previous character was not presented to a jury, and they did not hear the level of a thug both of the twins are. The level of the thug that the mother coddled and still makes excuses for till this day. His mother has done a TikTok live where she is blaming the cheerleaders because they're upset that her son bullied them, and she's making it their fault that her son is a bully and has no accountability. And the father showing his racist ideologies, who would be the teachers of these boys. All of those things were relevant. None of them were presented. Now, I believe that it was a complete racist jury anyways, but it still should have been a part of the record, which it was not. So it says it says from that point forward, the defense tried its case under the limitation at every stage. In reliance on the bargain in voir dire on June 3rd, the defense did not explore with the panel the themes of the decedent's character and aggression it otherwise would have developed. In its opening on June 4th, it introduced none of them. Through the state's case on June 4th, 5th, and 6th, the defense let the state student's witness leave the stand without confronting them with their own recorded statements to the police. That Austin Metcalf was kind of like the aggressive guy on the team, that he got triggered, that Austin and Hunter, they're not going to let you disrespect them, that if Austin is about to get into a fight, you can tell, and that he could be a bit aggressive at times, and in an ambulance of caution, even narrowed the questioning of the understanding permitted the defense designated no experts, foregoing a neuropsychologist prepared to explain how the defendant's epilepsy affected his perception of a threat, and a forensic psychologist prepared to address adolescent brain development and the fight or flight response, because the state took the position that such testimony would breach the understanding. And I believe that this is proof of ineffective counsel, because why would you make that understanding or that agreement in the first place? Because you need those things to defend your client. All right. So next. All right. The forbearance had a purpose. The payoff was to come in the defense case under the understanding, as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. The defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through him. Every pretrial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine that matters only in self-defense case built on such evidence, and as trial counsel has sworn in this case, the defense would ordinarily depend on the defendant's own account of his perception of the threat. On Monday, June 8th, the final day of evidence after the defense has spent voir dire, it's opening the entire cross-examination of the state's case and the first day of its own case honoring the bargain. The lead prosecutor announced that the agreement had never contemplated a testifying defendant and asserted that defense counsel had already opened the door by mentioning in opening that the defendant played chess, a position the court itself rejected. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding, an understanding that throughout the months the defense relied upon it existed on no record because it had been reached at and presented to the court off the record. and that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. Allotted 10 minutes, the defendant elected not to testify. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witnesses. And at punishment, the defense case was reduced to 3 pre-approved questions of the defendant's mother. The state, for its parts, called no punishment witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately. Exactly as the lead prosecutor had described on May 11th, that the agreement would operate. The state's punishment presentation will be confirmed by the reporter's record. The state thus performed the bargain at punishment the day after, denying that the same bargain covered the defendant's testimony. In the end, neither side put on character evidence. The understanding covered the bargain was performed on both sides through the last day of trial. The only term was that the one most vital to the defense, the defendant's own testimony. Karmelo Anthony was necessarily a witness to what happened under the tent, under the understanding as the state itself had repeatedly described it. All right, let me flip to the next. And hold on. We got a low battery. I thought I was plugged up, child. One second. How would I do? Oh. All right, 1 second. All right. Are y'all following so far? Are you guys following along? Do you guys want me to repeat any parts that I'm reading? Matter of fact, let me read that paragraph over. Let's read that paragraph over real quick. All right. So it says, and let's make sure that we're taking this in. Hold on. Let's go back. What page we on? We on page 9. Let's go back. All right. On Monday, June 8th, the final day of evidence after the defense has spent voir dire, it's opening the entire cross-examination of the state's case and the first day of its own case honoring the bargain. The lead prosecutor announced that the agreement had never contemplated a testifying defendant and asserted that defense counsel had already opened the door by mentioning in opening that the defendant played chess, a position the court itself rejected. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding, an understanding that throughout the months the defense relied upon it, existed on no record because it had been reached and presented to the court off the record. And that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. He was only allotted 10 minutes. The defendant elected not to testify. So he was only given 10 minutes to decide if he was going to testify or not testify. Okay? And so it says allotted 10 minutes. The defendant elected not to testify. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witnesses at a punishment. And at punishment, the defense case was reduced to 3 pre-approved questions of the defendant's mother. The state, for its part, called no punishment witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately. Exactly as the lead prosecutor had described on May 11th that the agreement would operate. The state's punishment presentation will be confirmed by the reporter's record. The state thus performed the bargain at punishment the day after denying that the state bargain covered the defendant's testimony. In the end, neither side put on character evidence. The understanding covered the bargain was performed on both sides through the last day of trial. The only term, whatever that it says, was the one most vital to the defense. The defendant's own testimony, Karmelo Anthony was necessarily a witness to what happened under the understanding as the state itself had repeatedly described it. He would testify like any other tent witness, as his elimination as a witness was devastating to the defense that turned on his own perception of the threat he faced. All right, which is major. All right, do you guys see that? It says he would have to testify like any other tent witness, and his elimination as a witness was devastating to the defense that turned on his own perception of the threat he faced. By then, the defense had already paid the price for reliance and could not undo the voir dire, opening, cross-examination, expert designations, or the decision framework that had followed in the understanding. All right. It says the expedited schedule, Saturday court, and 10 minutes to decide. The trial itself was run at speed. At the May 29th conference, the court announced its intention that the defense begin calling witnesses immediately upon the state resting, so that no trial day would go unfilled, including Saturday, June 6, 2026, a day on which several defense witnesses were unavailable. Trial counsel told the court that the schedule could force the defense to call defendants out of order. The state rested midday Saturday, and the defense began its case that afternoon. The whatever that word is of the parties' understanding described above and set out fully in part, was that 4 or 5 below, erupted on Monday, June 8th. All right. It says the final day of evidence, when the moment came for the defendant to make the most consequential decision of the trial, whether to waive his Fifth Amendment privilege and testify, the court allotted the defense 10 minutes to counsel a 19-year-old through it and denied counsel's request for additional time. Do y'all see that? He was given 10 minutes to decide. They said, hey, if you say anything about how you felt, how you perceived things, like there was only 10 minutes, and they were denied any extra time. Given the new stipulations that they gave on his testimony, they were only given 10 minutes to go over that with Karmelo. And when they asked for additional time, they were denied. And y'all want to tell me that he had a fair trial? Y'all want to tell me that things happened were just and fair? No, they were not just. They were not fair, but y'all don't care. As long as your outcome was what you wanted it to be, you don't care about a fair judicial system. You just want to see a black man in jail, and you want black people to be the only people that get the sentences in these cases. Like, you guys only want to see it one way. All right. Let me see. Where was I at? Okay. It says, okay. On Monday, June 8th, the final day of evidence, when the moment came for the defendant to make the most consequential decision of the trial. Okay, the defense rested that day after the shortened session, and the jurors were sequestered overnight in a hotel, informed that if they did not reach a verdict on Tuesday, they would remain sequestered. On Tuesday, June 9th, 2026, the court delivered its charge. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding the defendant guilty of murder. The punishment phase, evidence, argument, deliberations, and the rejection of sudden passion was then completed, and 35 years sentence imposed before the day ended. The sequestration and the deliberations widely and publicly reported will be established at the hearing and confirmed by the reporter's record. It says, after the verdict, the sealed file, the missing record, and the televised defense of the closure, the secrecy outlasted the verdict. Trial counsel withdrew on June 10th, 2026. Appointed appellate counsel was then replaced, and present counsel were substituted in on June 23rd, 2026, all while the 30-day deadline for this motion ran. The reporter's record remained wholly untranscribed, and the pleadings and case files set in the court's chambers rather than a district clerk's public record sealed by an oral order. And y'all want to tell me that this was a fair and just proceeding? Hell no, it was not. Everything about this was unconstitutional. And no matter if you feel like Karmelo Anthony is guilty or not, this was not the way that court is supposed to go. If the evidence, because, all of these bigots like to say, he's guilty, the evidence is overwhelming, the evidence is the evidence, If that's the case, why do we have all of these tricks? Why do we have all of these tricks up our sleeves? Why are we doing all of these manipulative practices? Why are we not handing over the transcripts? If the evidence speaks for itself, he's guilty and guilty is charged, the evidence is overwhelming, why the manipulation? You don't have an answer for that. You just know that you are a bigot and you think that the justice system only works for white people and any black defendant should be in jail. That's what you think. Because if you are of critical sound mind and body and you are fair, whether you think he's guilty or not, you would want the justice system to be fair for all defendants, no matter what they are charged with. All right. So it says, and let me go back to the last line. It says the secrecy outlasted the verdict. Trial counsel withdrew on June 10th, 2026. Appointed appellate counsel was then replaced, and present counsel were submitted in on June 23rd, 2026. All while the 30-day deadline for this motion ran. The reporter's record remained wholly untranscribed, and the pleadings and case files set in the court's chambers rather than in the district clerk's public record, sealed by an oral order. At a conference on June 29, 2026, the court advised that the entire court file had been sealed by oral order and conditioned counsel's inspection of it on an agreement not to disclose what he observed, a condition counsel could not give, leaving the file available only in chambers. 2 days after imposing sentence, the trial judge gave a televised interview defending the restrictions, describing the decision to bar cameras and streaming as an easy decision, acknowledging that he sometimes thinks maybe he should have at least audio streamed or something so people can hear it, and explaining that he declined to do so because people are going to distort whatever happens. So what's the point? In a written statement to Fox News, the judge added, "Now that the trial is over, it is important to me to provide transparency." And in a public letter of June 17, 2026, he thanked other judges of the county for adjusting their own dockets to accommodate this trial. At minimum, raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. All right. Because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed, and because the case file has been held in chambers rather than in district clerk's public record, the recitation above is drawn from the indictment, the court's charge, the public docket, the court's own orders, and the public statements, the attached affidavits and declarations, and counsel's knowledge. Defendants will offer evidence at the hearing in support of the grounds timely raised herein. So what he's saying is they have not offered over the transcripts. They purposely withheld the transcripts to leave his appellate attorneys at a disadvantage in filing this motion because they ran an unjust court. If everything was fair, everything was just, everything was on the up and up, why withhold the transcripts? Why are the transcripts not available? Why is no portion? I can see if you say, you know what, it was a weak trial, and maybe I don't have all of the days transcribed, but you make no days available to his lawyers? None? And y'all want to sit here and tell me that things were fair? This was designed, in my opinion, because, again, I don't know for a fact, but the timeliness of the judge saying that he's going to resign, he has not left the bench yet, but the timeliness of him saying that he's going to resign, for him giving those post interviews and letting his white, racist, bigoted audience that are happy about this sentence know that we're going to hold these N-words accountable and we're going to give them the most severe punishments. I believe that the reason why he did those interviews, in my opinion, is because he's going to use this for political gain. I believe that he needs this to go a particular way because he knows how many racist bigots are on that side. And those are the bigots that will put you in office and vote for you. And I believe that was a signal to racist bigots. Hey, I got you. I got the racist bigots' interests, and I'm going to make sure these N-words are having the most severe punishments, even though we have similar cases in Texas of white defendants that have significantly less time. I'm going to give you guys a press conference and let you know that we're going to give black defendants the most severe, and we're going to do a shady withholding of transcripts. We're going to do everything that we can in our power to put the defendants at a disadvantage, That's what I get from it. But that's not factual. That's my opinion. So you guys can let me know what you get from it. But that's what I gather from his post interviews, the bigots, racist, white supremacists that he allowed to dox people, target and harass people in the court. The fact that his public information officer knew about the harassment of Black journalists. The fact that he never had his sheriffs enforce his own curfew that he imposed. The fact that he made it chaotic outside of court and made it that only those who entered the court at 4 a.m. or 5 a.m. for a proceeding that didn't start till 9 a.m. All of these things, I believe, were by design. All right. So, all right. So it says, because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed, and because the case file has been held in chambers rather than the district clerk's public record, the recitation above is drawn from the indictment, the court's charge, the public docket, and the court's own orders and public statements, the attachment, affidavits, and declarations, and counsel's knowledge. Defendant will offer evidence at the hearing in support of grounds timely raised herein. On June 9th, 2026, the jury found defendant guilty of murder. And on the same date, the court imposed sentence in an open court assessing punishment at 35 years confinement in Texas Department of Criminal Justice Institution Division. All right, let's go to the next page. All right. On June 4th, 2026, the trial court signed the certification of the defendant's rights of appeal. Although the certification issued before the verdict, the judgment of conviction was rendered and sentence imposed on June 9th, 2026, and the notice of appeal followed. On June 10th, 2026, the defendant filed his notice of appeal, and the appeal was docketed in the Fifth Court of Appeals as cause number blah, blah, blah. On or about June 11, 2026, after the verdict, the sentence, the certification of right of appeal, and the filing of notice of appeal, the presiding judge gave a televised interview concerning this case, which aired on WFAA TV. Now, WFAA, as I stated, was the media outlet that I witnessed with my own eyes, allowing their reporters outside of the 9, okay, because they already had one of the 9 seats. WFAA is the first interview that he did, and also the news network that was allowed to sneak their other reporters on the lot before the public, sneak their legal experts onto the lot. And I also have a video of one of their legal experts saying such on June 4th, when they first start letting them sneak into the line. That's the media outlet that gave him his first interview that they're citing, that the court allowed to sneak additional people into the public line and put all of us in the public line at a disadvantage. All right. So, it says this motion, actually, let me get some water real quick, y'all. Let me get some water. All right. All right. Do we need to go? What's going on in the chat? Do we need to boot some more people off of the comments? Like, what we need to do? Everything good? What's going on to my mods? Shout out to my mods. If you're enjoying the reading, again, I know that it takes me a while to get through things. If you're enjoying the reading, we do appreciate a donation to the Neek at Night Cash App, because, you know, you get in the full reading. All right. Now, again, other news outlets like Court TV, etc., they're going to give you like the summary. We're reading everything that was put into the motion. So if you're enjoying having this fully read out, I know, you know, I be going off a tangent, but if you are enjoying it, definitely hit the like button, hit the share button, let people know that we're live, we're reading the full thing, and donate to the channel, okay? Neek at Night Media, spelled exactly like my channel. All right, let's continue. All right. The motion is timely under Texas Rule of Appellate Procedure 21.4, being filed within 30 days after June 9, 2026. The date sentence was imposed in open court. The court retains authority to consider and rule on this motion through the 75th day after that date. A notice of appeal, if any, does not divest the court of that authority until the appellate record is filed in court. All right. Because sentence was imposed in open court on June 9th, 2026, the 30th day to file this motion is July 9th, 2026, and the 75th day falls on Sunday, August 23rd, 2026. Subject to Texas Rule of Appellate Procedure, defendants request a hearing and ruling no later than Friday, August 21st, 2026. To avoid any dispute over Rule 21.8's deadline, defendant is presenting this motion within 30 days of filing, as Rule 21.6 requires, and contemporaneously requests that the court sign the attached order on presentment and set the motion for an evidentiary hearing so that the parties may present evidence and the court may rule within the time Rule 21.8 permits. Contemporaneously with this motion, defendant is filing a motion to recuse the presiding judge because Rule 18A of the Texas Rules of Civil Procedure governs recusal in criminal cases. All right. It says this at Arnold v. State. Defendants request that the evidentiary hearing on this motion be conducted by the judge presiding after the recusal motion has been referred and resolved in accordance with that rule. This motion is supported by affidavit because it raises matters outside of the trial record established by the attached affidavits and authenticating declarations, and it's timely filed and presented. Defendant is entitled to an evidentiary hearing, and the court would abuse its discretion in denying one, Reyes v. State, Roswell v. State, Hobbs v. State. Under these circumstances, refusal to hold a hearing would be an abuse of discretion because the motion and its supporting affidavit raise matters not determinable from the existing record that, if true, could entitle defendant to relief. All right, let me change the page so y'all can see what I'm reading. All right, it says, where was I? That it especially so here where the reporter's records has not been prepared, the official court reporter has advised counsel that no portion of the trial has yet been transcribed, so the relevant proceedings cannot presently be reconstructed from any existing record. It says the first ground for a new trial. Hold on, I clicked on something, y'all. All right. The first ground for a new trial. The trial court violated defendant's Sixth Amendment right to a public trial by materially restricting public access to the trial proceedings without the findings and alternatives required by Waller, Presley, and Strichter. The issue is not whether the court had authority to manage courtroom security and capacity. It did. The issue is whether, after adopting an access order that foreseeably excluded members of the public from a high-profile criminal trial, the court made the findings, Waller v. Georgia, requires and considered that the reasonable alternatives demands for contemporaneous public access. It did not. The court's order gave the general public only 10-minute daily initial admissions window, left roughly 24 seats for public observers in a nationally watched murder trial, barred meaningful re-entry during proceedings, and provided no overflow room, no audio feed, and no video feed for those foreseeably turned away. Once closure is shown, it cannot stand unless the record contains a Waller complaint justification for those restrictions. The existing record contains none, nor does the danger end with this case. In a televised interview about a case that has drawn national attention, the court publicly defended these restrictions as the right way to conduct a high-profile trial, describing the decision to bar cameras and streaming as an easy decision, and stating that it had struck that balance pretty well. Should a trial held behind a 10-minute entry window with no overflow room, no audio feed, no live stream be treated as an adequate substitute for an open courtroom? The public trial guarantee of the First and Sixth Amendments would be hollowed out in practice. All right, so let's go to the next page. The restrictions here amounted to a closure of the courtroom imposed without the findings that law requires. Defendants does not contend that live streaming is constitutionally required in every case. The issue is that once physical seating was foreseeably inadequate, the court was required to consider reasonable alternatives and make Waller findings before excluding the public. An open courtroom belongs to people of Texas who fund and sustain it. The openness of criminal trials is among the oldest and most settled features of Anglo-American justice. The United States Supreme Court has held that the public and the press possess a right secured by the First and 14th Amendments to attend criminal trials, and that absence and overriding interests articulated in the findings, a criminal trial must be open to the public. And then it cites these cases. A presumption of openness inheres in the very nature of the criminal trial under our system of justice. For a public trial gives assurance that proceedings are conducted fairly, discourages perjury and misconduct, and guards against decisions based on secret, bias, or partially. As the court observed, it would be difficult to single out any aspect of government or higher concern and importance to the people than the manner in which criminal trials are conducted. Texas has long spoken to the same effect in its own voice. The Code of Criminal Procedure commands that the proceedings of the trial in all courts shall be public. It says the Court of Criminal Appeals has embraced the presumption of openness recognized in Richmond newspaper, explaining more than a century ago that the Texas Constitution is but in accord with the genius and spirit of our free instructions, which is intended to guarantee publicity. Goodness, why am I getting so tongue-tied? To guarantee publicity to the proceedings of our courts. And then it cites Houston Chronicles, and then it says, okay, so let me change the page. All right. These guarantees are not abstractions, and they are held by the accused alone. The open trial guarantee belongs as well to the citizens of Texas, in whose name the prosecution is bought, by whose taxes the courthouse and the court are sustained, and whose confidence in the administration of justice depends on their ability to see the justice done. Public attendance is the mechanism by which the community observes that the court it funds are functioning lawfully. A check on official power that the Supreme Court has repeatedly identified as core purpose of the open trial guarantee. When the public is excluded from a Texas courtroom without lawful justification, the injury falls on the defendant whose Sixth Amendment right is violated and on the community whose courtroom it is. It is the defendant's injury that this motion vindicates. The community's stake underscores why the violation is neither technical nor trivial. A public trial is staged for two audiences at once. The first sits in the gallery. The citizens whose name the case is brought, who watch to satisfy themselves that the state proves what it claims and that the accused is not quietly condemned. The second sits on the bench and in the jury box. The judge and the jurors, for whom the awareness of being watched is itself a discipline, keeping them keenly alive to a sense of their responsibility and to the importance of their functions. A 10-minute entry window empties both galleries at once. It turns the public away before it can watch, and it relieves the court of the very audience whose presence is the discipline. What the order described as access operated in practice as material exclusion. History explains why the law guards the open courtroom so jealously. The public trial guarantee is a long-standing safeguard against secret proceedings. It has always been recognized as a safeguard against any attempt to employ our courts as instruments of persecution. What openness protects, secrecy endangers. A proceeding the public cannot watch is one which the ordinary checks on error, overreach, and bias quietly fall away. That is the structural risk a closed courtroom creates. Whether or not anyone can later prove the harm the secrecy concealed, which is precisely why the law treats the deprivation as structural and does not put the defendant to proof of a hidden injury. All right, let's go to the next one. The most directly applicable appellate authority on this precise question is published. The most directly applicable appellate authority on this precise question is a published decision of this Court of Appeals handed down months before the trial began. In Strichter v. State, the Fifth Court of Appeals held that a trial court violated the defendant's Sixth Amendment right to a public trial and ordered a new trial, where the court, citing courtroom space and a generalized security concern, refused to seat a single member of the public during jury selection without first considering the reasonable alternatives the law requires. It cites a case and it says, because Strichter was designated for publication under Texas Rule of Appellate Procedure, it is a published memorandum opinion of this Court of Appeals and thus the most directly applicable appellate authority on the public trial question. And having been issued months before this trial, it was available for the trial court to review when the court entered the amended order and closed these proceedings. The closure here was therefore not the resolution of an unsettled question. It ran headlong into a recent published decision, a very court that reviews this one. I'm going to pause right there to make sure you guys are still there. It looks like the comments kind of stopped. Are y'all still here? Are y'all still watching? Are y'all hitting the like button? Are y'all subscribed if you're not subscribed? Now, we are in acquired taste over here. But I want to make sure that you guys are still watching. You guys still hear me clearly. And maybe y'all just following along where y'all decided to, not type as much into the comments, but let me know that y'all still here. Y'all still listening. What do y'all think so far in me reading this? What do y'all think so far as to what arguments they're making? What do you think? I want to hear from y'all really quickly. I'm gonna flash some of them on the screen. So let me know what y'all are thinking so far. What y'all? Somebody said I'm driving. You on my TV, not on my keyboard right now. No, that's right. The judge also said on TV he thought Karmelo was guilty and sympathized with the Metcalfs. Okay. Listening. Okay, taking it all in. Okay. Not surprised. Right. From what y'all hearing, does it sound like there was a fair trial? I'm going to drop the link, and if anybody wants to come on and speak while I read this, y'all can be in the queue and let me know. I'll bring y'all up at random. I know that it could be a little bit of time here and there, but y'all let me know if there is anything that you want to say real quick before I finish reading it. Let me see. There was one person who wanted me to tell them when I went live. I be forgetting to tell people. Where's one second? Why can't I click on that? That's so weird. Hold on one second, y'all. Let me see. Anybody want to come up real quick? Click the link. I'll take a quick moment to let y'all up real quick if y'all want to say something. If not, I will continue to read. Let's see. All right, let's go back to y'all. Okay, y'all scared? Y'all scared or what? This is what I want to know too. She says, it's interesting about the off the record part, and why would the defense allow something to be off the record? Right. That makes no sense. Like, why would you agree to something so crucial and not get it in writing? That makes no sense at all. Like, none at all. Somebody said I'm cooking. Okay. All right. I'll finish reading. But thank y'all for those of you who have been sharing my live. I see a couple of you guys sharing it on Twitter. Make sure to share the link to this live on other social media as well. This is the new team filing this motion. Yes. So his new appellate team filed this motion. And I did not have time to get my hair in order. This looks a greasy mess, but child, we got to get to business. We'll worry about this hair later. All right. Let's continue. Let me make sure the page that I'm reading is the same page that y'all see. All right. Thank you. All right, all right, all right. Let's go. Let's go. Let's go. All right. So it says the most directly applicable appellate authority on this precise question is a published decision of this Court of Appeals handed down months before the trial began. Wait, did I read that already? I think I read that. All right. 35. Every justification the Fifth Court rejected in stricter is a justification the court invoked here. And that rejection was on far more extreme facts. There, the court refused to seat one observer because the veneer filled the gallery. Here, the court rationed the general public to roughly 24 rotating seats across every stage of a nationally watched murder trial. There, the trial court declined to split voir dire to make room, explaining, I am not going to spend 2 days picking a jury. The Fifth Court held that space in overcrowding through, though legitimate concerns must be outweighed, a defendant's Sixth Amendment right because there are readily available alternatives and that neither convenience nor judicial economy can constitute an overriding interest. Here, the record and the court's own public statements at least raised a fact issue that reasonable alternatives existed, including a larger or additional courtroom space, a live audio or video feed, and the overflow accommodations the court used during jury selection and then withdrew, and where the stricter court faulted the trial judge for failing to identify a specific concrete fact of danger at it says the order here rests the same generic recital that unrestricted access may compromise security. Entered without a hearing. If excluding a single member of the public from jury selection required a new trial and stricter, then the recurring exclusion of numerous members of the public from testimony and punishment after the court withdrew an available overflow alternative and made no Waller findings cannot be dismissed at trivial. A second court of appeals reached the same result weeks later on facts materially indistinguishable from the space rationale invoked here. It says, in Hernandez v. State, the 14th Court of Appeals reversed a capital murder conviction and ordered a new trial because the trial court closed voir dire to the defendant's family and the public, citing an 80-person and a lack of physical space without conducting a Waller analysis, making findings, or considering reasonable alternatives. Hernandez v. State, it says the court held that concerns about space must not outweigh a defendant's Sixth Amendment right and admonish that trial courts are expected to know and apply this basic rule. Stricter and Hernandez are thus recent published Texas decisions holding that a space-based closure of jury selection entered without Waller findings or the consideration of reasonable alternatives is structural error requiring a new trial. And both were available for this court's review before this trial. Stricter and Hernandez addressed the merits of a space-based closure. Dixon and the preservation authorities address when the complaint must be raised. Defendant satisfies both rules here because the closure was administered off the record and the as applies exclusion became apparent only after trial. The Court of Criminal Appeals has likewise reversed on a narrower version of this problem. It says in Stedman v. State, the court reversed a conviction and ordered a new trial because a trial judge excluded the defendant's family from voir dire out of a generalized concern about space without articulating a specific threat and without considering reasonable alternatives. This case is Stedman magnified at every dimension. The court excluded not one family, but the general public, not from voir dire alone, but from every stage of the trial on findings no less generic. The unrestricted access may compromise security, juror privacy, and a fair trial. Without a hearing, and after using, then abandoning the very kind of overflow alternative Stedman faults courts for failing to consider, if barring a single family from jury selection was structural error demanding a new trial, excluding members of the public from substantial portions of jury selection, testimony, and punishment is so the same, I guess. Hold on, let me go to the next page. All right. Let's continue. Okay. So it says the Sixth Amendment to the United States Constitution guarantees the accused in a criminal prosecution the right to a public trial, a guarantee applicable to the states, though, through the 14th Amendment. The Texas Constitution independently secures the same right, providing that the accused shall have a speedy public trial. And then it cites a code. And then it says the proceedings in trial in all courts shall be public. The right to a public trial is not confined to the presentation of evidence. It extends to jury selection. Before a trial court may exclude the public from any part of a criminal proceeding, it must satisfy the four-part test of Waller v. Georgia. 1, the party seeking the limit access must advance an overriding interest that is likely to be prejudiced. 2, any limitation must be no broader than necessary to protect that interest. 3, the trial court must consider reasonable alternatives to closing the proceeding. And 4, the trial court must make findings adequate to support the limitation. The Court of Criminal Appeals has adopted and applied this test. Stedman v. State, etc., etc. The trial court bears the burden of considering reasonable alternatives. The balance of interest must be struck with the special care and findings by the trial court. And our linchpin of the Waller test, Stedman, blah, blah, blah. It says the right of public access applies with particular force to selection of the jury. The Supreme Court has held that the guarantee of open criminal proceedings reaches the voir dire of prospective jurors because the selection of jurors has presumptively been a public process with exceptions only for good cause shown. Open jury selection was the settled practice in America when the Constitution was adopted, and the court emphasized that proceedings conducted in secret frustrate the very public interest that open selection exists to serve. Closure of jury selection is therefore permissible only on the same showing of an overriding interest. Narrow tailoring and specific findings that Waller and Press Enterprise require. The order's restriction nonetheless applied to jury selection, along with every other phase of the trial, conducted behind the same closed doors and unsupported by any such finding. All right. Udo on the go is in the chat. Where he at? Somebody said what's up to Udo. I don't see him in the chat. I agree with you. Kara says they should ask for a new venue if granted. Right. They definitely should. Where's Udo at? They're all in it. This young man is yes, I believe that all of this is by design. All of this is by design. I don't see Uda though. Y'all saying Uda is in the chat. I don't see him. Anyways, let's continue to read. All right. Are we on the next page? Oh, let me change the page. All right. All right. So yes. Yes. She said they checked all the boxes and backed by legal precedent, a dream team they are. Yes, yes, yes. I believe that they are the dream team. And I'm so happy to have the pleasure of, I spoke with Russell Wilson, the lead counsel. That's the one who I was speaking with and corresponding to. And then one day I talked to Justin A. Moore, but mostly I was speaking to Russell Wilson, and they are the true dream team. And these bigots hate it. They thought they were doing their big one by constantly getting his GoFundMe's shut down, right? So in order for him to have this level of counsel, his family thought that they were going to have to raise extreme amounts of money to be able to afford such representation. So when they went to try and make GoFundMe so that they can get money, these racist bigots thought they were doing their big one by shutting down those GoFundMes to put him at a disadvantage. However, the true God, not the God that these bigots serve, because they can't be Christians with these evil demonic hearts. They're not true Christians. They're evil people hiding under the guise of this new white supremacist Christianity. That's something totally different, veiled by nothing but evilness. But the true God said, you know what? We're going to eliminate that hurdle, and we're going to offer an extensive team free of charge. And therefore, their plan to constantly put him at a disadvantage, these amazing attorneys said, the God I serve said, let me just eliminate that obstacle for y'all, and let's offer our services free of charge. And the bigots were scrambling. These fake, bigoted, evil wannabe claiming that they're Christian but got the most evil hearts, they were left to create and draft a new narrative. They had to create more victimhood. They had to then pivot from that narrative and try to do other things to shape the narrative, right? And they think that their word is final. Now, again, I am of the belief that motions for new trials are difficult. They are difficult and they are rarely overturned. However, just like the true God allowed that hurdle to be moved, he is the ultimate person who's going to decide what happens ultimately. He is the final say. These racist bigots aren't the final say of whether he gets a new trial or not. Whether he gets a new trial is based on the errors and procedures that were not properly followed. That's what determines it. These racist bigots think that they are the almighty control. Now, it is a racist system. It is a biased system where Black defendants are sentenced much more harshly than white defendants. That's proven by data, even though they are the main ones that's doing the essay and the kid diddling. Even the people connected to covering this, they child. Anyways, they're the main ones and the main culprits of kid diddling, but it's always the Black defendants that get the much more harsher sentencings. And we see that in this case, and it is God's final authority on whether or not Karmelo Anthony will get a new trial, whether he'll serve 35 years, whether this will be, something else. All of that is not in that's not in their control. Just like whether or not he had proper representation wasn't in their control. But I'll continue. to read. All right. We'll continue to read. We have so many more pages to go. All right. We got lots and lots of pages, baby. And again, if you're watching this on the playback and I'm not reading the things fast enough, you can speed me up on the playback speed. Only if you're watching this on the replay. All right, let's continue. All right. So 10 minutes a day did not keep this courtroom open to the public. A reviewing court first characterizes the restriction. A full closure is tested under all four Waller factors. A partial closure is tested under the same factors, with the first requiring a substantial rather than an overriding reason, and only a true, trivial, or a de minimis restriction leaves the public trial right unimplicated. The court's amended order regulating trial proceedings, media access, security, and courtroom decorum was not a trivial restriction. It provided an pertinent part. In quotes, it says, the courtroom shall open each day of trial at 8:30 a.m. Entry shall be permitted beginning at 8:30 a.m. For members of the media at 8:40 a.m. For designated family members at 8:50 a.m. For members of the general public, no more than 9 members of media shall be permitted in the courtroom at any one time. Seating shall be on a space available basis. The courtroom doors shall close promptly at 9 a.m., and individuals arriving after that time shall not be admitted until a recess. Once admitted into the courtroom, no person shall leave and re-enter during proceedings except during a recess. So what they're saying is the public only had 10 minutes to enter this court. After 10 minutes, it was closed. Okay? So it says, by its terms, the order only affirmative window for the general public to enter was the 10 minutes between 8:50 a.m. and 9 a.m. The remainder of the provision spoke in terms of exclusion. The doors shall close promptly at 9 a.m. Individuals arriving afterward shall not be admitted until a recess, and no person shall leave and re-enter during proceedings except during a recess. The order capped media presence at 9 persons, made seating space available, and contained no provision for admitting members of the public as seats became open during the proceedings, nor did it furnish any overflow room, audio feed, or video feed for the public unable to be seated. By its terms, the amended order governed all aspects of the trial proceedings, and it remained in effect and was applied throughout. The restrictions operated continuously and were not confined to any discrete portion of the case. They governed the jury selection process, the guilt-innocence phase, and the punishment phase alike. The closure was therefore pervasive rather than incidental, depriving the public of access to every stage of the proceedings at which the order applied. The cumulative and practical effect of these provisions was to exclude members of the public from the proceedings at every stage at which the order applied, including jury selection, the guilt-innocence phase, and the punishment phase, which constitutes a closure subject to Waller. The defendant bears the initial burden to show that the trial was closed to the public, but that burden is carried on the totality of the evidence. And the inquiry does not turn on whether the defendant can show that any particular person was actually excluded. It says, holding the initial burden rests on the defendant and reaffirming that closure is determined from the totality of the evidence rather than whether a spectator was actually excluded. The focus is not on whether the defendant can show that someone was actually excluded. The reviewing court instead asks whether the trial court fulfilled its obligation to take every reasonable measure to accommodate public attendance. Here, the cumulative effect of the 9 media cap, the 10-minute public entry window, space available seating, the no re-entry rule, and the absence of any overflow or live stream establishes that members of the public were excluded, and the defendant has carried his burden to show that the proceedings were closed. These facts are further established by accompanying declarations of members of the public who sought to attend the trial and were denied the entry of the courthouse. Those declarations, executed by members of the public who came from across the country to attend, established the closure concretely and consistently, and no witness observed any disturbance or security incident that would explain it. Jacqueline Yan traveled from North Carolina on the first day of testimony. She found a line of roughly 80 to 100 people and watched as only about 27 were admitted, with no overflow room provided for the remainder. Tiara Allen flew from Arizona and observed jury selection from an auxiliary viewing location she knew as the Oval Room on June 1st and June 3rd. On June 4th, she was told that the accommodation had been eliminated and she was excluded from the courtroom on both June 4th and June 5th. Bridget Smith attended on June 1st, 4th, 5th, and 6th and confirms that the public seating was capped at roughly 27 seats, that admission was divided into 2 lines, one for media lists and one for everyone else, and that outside viewing location used during the jury selection was eliminated once testimony began. This was kind of repeated, but we'll go to the next one. One member of the public attended the trial nearly in its entirety, provides a day-by-day account that corroborates each of these features from inside. Nakia Washington traveled from Cincinnati, Ohio, and was present at the courthouse on June 1st, 3rd, 4th, 5th, 6th, 8th, and 9th. During jury selection, the court used an auxiliary viewing courtroom, the memorial room, that seated roughly 60 members of the public and carried a live video and audio feed of the proceedings. On June 4th, the first day of testimony, the public was informed only after arriving that the overflow room would not be available for the remainder of the trial, and access was thereafter confined to approximately 27 seats inside the courtroom, with no overflow room audio feed or video feed of any kind. Access each day was governed not by the order's admission or it says hold on. Access each day was governed not by the order's admission time, but by pre-dawn line that was formed as early as 4 to 4:30 a.m., was counted off in groups of 27 and was inconsistent and at times chaotic. And although Miss Washington ultimately gained entry on each day she attended, she was excluded from the morning's proceedings on both June 4th and June 5th. Admitted only in the early afternoon after substantial portions of the day had already passed, so that even an attending member of the public was denied access to significant parts of the trial. She observed no disturbance or disruptive conduct inside the courthouse that would justify excluding the public. The only altercation she witnessed occurred outside in the line and arose from the very manner in which the court administered access. Let me change to the next. This case is not controlled by the decisions on which the state may rely. In Dixon v. State, the Court of Criminal Appeals held the public trial right as a forfeitable and that a full courtroom standing alone does not violate the guarantee because the right does not require the court to seat every person who wishes to attend. Defendant does not contend otherwise. The violation here is not that the courtroom filled. It is that the court adopted in advance and without case-specific findings a reoccurring access regimen that limited the general public to a 10-minute daily entry window and roughly 24 seats, barred meaningful mid-proceedings access, and furnished no contemporaneous alternative for those foreseeably excluded. Nor would Dixon's deposition aid the state. There, the claimed exclusion of the portion of a single day closing arguments proved by one witness against an otherwise silent record, and the trial court resolved the resulting factual dispute only after a contested hearing. Here, the closure spans the testimonial phases of the trial and is established by 7 mutually corroborated sworn accounts, by the written admission of the court's own appointed officer, and that there is no overflow room, by the court's own televised confirmation of the seating figures, by the undisputed elimination of an accommodation the court had itself been providing, and no finding of any kind exists to which difference could attach. Nor is the Williams v. State, in which the Court of Criminal Appeals treated the brief exclusion of a single family member during one witness testimony, mitigated by a live video feed to neighboring courtroom, as a trivial de minimis closure that did not implicate the Sixth Amendment. The restriction here was the opposite of trivial. It was not a single brief exclusion tied to one witness. It was not accompanied by any live feed, and it was not supported by witness-specific findings. It was a trial-wide access regime applied across jury selection, the guilt-innocence phase, and the punishment phase under Williams' own framework. A closure of that scope is tested under Waller, not excused as de minimis. Indeed, the Williams court took pains to cabin its holding. All right, let me go to the next page. Oh, wait, am I 2 pages behind on y'all? I'm sorry. Why y'all didn't tell me what I was reading wasn't on the screen for y'all? Child, I was behind 1 page reading for y'all, and y'all didn't even tell me. Hold on, let me get... Where is my... I feel like my lips is dry. All right. Let's continue. What y'all talking about in the chat? Y'all said it's too little for y'all to see. Is it? I'm sorry, y'all. We'll follow along, child. Okay. If it's too little for y'all to see, put it on your TV screen. If you can't put it on your TV screen, then try to follow along the best you can. Again, on the playback, you can speed me up if I'm not reading fast enough for y'all. So, somebody said you're doing a great job. I didn't feel like I needed to read along. Okay, period, child. Y'all know I'll be messing up here and there, but we get into it. We get into it. All right. All right. So let me see. Where was I at? Okay. It characterized that triviality doctrine as an exceedingly narrow exception to Waller, reaffirmed that Waller remains the primary framework for analyzing courtroom closures under the Sixth Amendment, and admonished that the doctrine should be employed sparingly and only in the narrowest of circumstances. The court expressly declined to mark the doctrine out of boundaries, leaving that task to the future case with different facts. A standing trial-wide access regime spanning jury selection, the guilt-innocence phase, and the punishment phase is not the rare circumstances William contemplated. It is the ordinary closure for which Waller supplies the governing test. This Court of Appeals has already applied that principle to reject the very triviality argument the state may advance here. In stricter, it declined to treat the exclusion of public from jury selection as trivial, holding that the values sought be implicated by the Sixth Amendment are violated when the public is excluded from jury selection. Defendants need to prove that every seat was empty or that every member of the public was excluded. At minimum, the access was a partial closure. Members of the public were repeatedly excluded from substantial portions of the proceedings while no continuing overflow audio, blah, blah, blah. All right, so it says these decisions do not create a mechanical rule that a live feed is always required or always sufficient. They make a narrow point, and then they cite the cases. We're going to go to the next page. All right. All right, so it says the case sits on the wrong side of that line, and uniquely so, the court did not merely fail to provide an alternative, it provided one during jury selection, a live feed to an overflow room, and then switched it off for the testimonial phases, the most consequential part of the trial. A court that has shown it can pipe the proceedings to an overflow room and then darkens the feed when the witness take the stand has not taken every reasonable measure to accommodate public attendance. It has done the opposite. Critically, the closure was imposed by the court on its own motion. No party moved to close the courtroom or to restrict public access. The court entered the amended order and conducted no evidentiary hearing and received no evidence in support of any interest offered to justify the restrictions. Defendant was not afforded a pre-order hearing or an opportunity to be heard before the access was imposed, and the written order did not disclose the fact that made the closure apparent in operation. The actual allocation of public and family seats, the defense family limitation, the withdrawal of the overflow room when testimony began, the denial of alternate access, or off-the-record administration of public line. Let me see. Okay, so it keeps talking about the overflow room and how it didn't provide an overflow room. Let me see. It talks about how they only gave us, it kind of repeats some parts. So let me go past some of this. Let's see. All right, let me go to all right, let's go to 27. All right, so it says, finally, the mechanisms by which the court administered and defended these restrictions operated off the record. A member of the public's request for an alternate viewing location could not be filed through the county's electronic system for a criminal case and was instead routed by email to a public information officer designated by the court, who reviewed and denied the request outside of any judicial proceeding. No hearing was held, no evidence was taken, and no order subject to appellate review was entered. At the same time, the member of the public who observed these proceedings describes no disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions imposed. The as-applied operation of the court thus confirms both halves of the defect. The closure was more severe in practice than the order text, and the generic speculative findings offered to justify it are contradicted by the conditions the public actually encountered. These conditions can be stated with precision because they recur across the sworn accounts of the members of the public. And it says, A cap roughly 27 seats for and off the record allocation. Okay, so let's go to the next one. It says the absence of any method for allocating the limited seats, producing an inconsistent and non-transparent line in which some persons were permitted to move ahead of others who had waited for hours, displacing members of the public who had arrived early to positions well beyond the available seats. Let's see. I'm trying to go past the part about. I'm skipping past some of it because some of it is kind of like repetitive. So let me see. They're just citing all the ways that they violated his rights by not offering an overflow room and not offering, you know, accommodations for the trial. So let me see when they go to something else. Let me see. All right. Let me go to, hold on. Okay. Let's go here where they talk about what y'all saying. Do you think the evidence motion is sufficient to overturn the verdict, or are they being strategic in how they approach the legal arguments? Only God can, like I said, it's Brittany says, do you think the evidence presented in this motion is sufficient to overturn the verdict, or are they being strategic in how they approach legal arguments? I believe that God has the final say. I don't know what can happen. I'm not going to say, yeah, it'll overturn it, or no, it won't. God has the final say. I don't know. As racist as Collin County's is, as corrupt as the judicial system seems to be, I don't know. But I would hope that a higher court and a recusal of the judge would get things a little bit more balanced. But I don't know. You know, I can't say. All right, so I'm going to go down to 72 where it says these alternatives are neither novel or untested across the country. And in Texas, courts confronting public interest as intense as this case or far greater have kept their proceedings open by ordinary means rather than closing them. State courts may permit camera and live audio video coverage of a trial in the trial court's discretion. Texas courts have repeatedly used that discretion to keep even the most charged criminally trials fully open. In 2019, Dallas County murder trial of Amber Geiger, a police officer, the trial court permitted the entire proceeding to be live streamed from the courtroom, and the public watched in real time. I was one of the people who covered the Amber Geiger case and followed it in real time. It says let me see, where was that? Okay, so it says Texas courts have repeatedly used that discretion to keep even the most charged criminally trials fully open. In 2019, Dallas County murder trial of Amber Geiger, a police officer, the trial court permitted the entire proceedings to be live streamed from the courtroom, and the public watched in real time. Only months before this trial, the first criminal trial arising from the Uvalde school shooting response was moved to a Corpus Christi courtroom chosen in part for its capacity to hold the parties, the victims' families, and the national media, and was kept open gavel to gavel by live stream coverage, a designated media room, and overflow space during jury selection. The occurrence and public character of these proceedings are documented in widely available reporting sources, NBC, 5, DFW, and other news outlets. Then it says, the nationally watched murder trial of Derek Chauvin is a useful illustration. Every factor a court might invoke to justify restricting access was present there. Extraordinary public interest, witness safety concerns, and pandemic limits on in-person seating. Yet the court did not exclude the public. When the state proposed to rely on overflow courtrooms and closed circuit cameras instead of broadcast coverage, the court rejected that proposal as inadequate, holding that audio and video coverage was the only reasonable alternative to ensure a truly public trial. State versus Chauvin. The court authorized the entire trial to be broadcast and live streamed, declining only to show juvenile witnesses or the victim's family on camera. The contrast with this case is stark. The overflow viewing by closed circuit feed and the Chauvin court deemed the constitutional floor and found inadequate standing alone is more than this court ever provided, for here there was no feed of any kind. The principle holds even where broadcasting is forbidden. The federal courts prohibit photographing or broadcasting any procedures from the courtroom. Yet they keep even their most security sensitive prosecutions open by first come, first serve seating and overflow rooms carrying live feeds inside the courthouse. The January 6th Capitol cases and the Boston Marathon bombing trial proceeded in open court with the press and public present. And in marquee federal trials whose main courtroom could seat only a fraction of the public, the prosecution of Samuel Bankman Fried and what's her name? Ghislaine Maxwell, among them, the courts opened overflow courtrooms carrying live feed, and in Maxwell's case, a nationwide live audio feed so that the bar on broadcast became no bar to access. A no-camera state forum did the same in a nationally prominent 2024 New York criminal trial where state rules forbid cameras. The court kept the trial open and overflow room carrying the proceedings on closed circuit television. What none of these courts did, facing public interest and security concerns equal to or greater than those present here, was admit the public for a single 10-minute window, bar re-entry, and then deny an overflow room audio feed or video access whatsoever. So they're saying other trials where the stakes were just as high or greater, they allowed overflow rooms. They didn't allow these extreme conditions. But this case, they banned the overflow room. They banned re-entry. They banned all of these other things to access the proceedings. Somebody in the comments said the Diddy trial. And yes, the Diddy trial also allowed overflow rooms as well in that case. All right. It says these comparators are not controlling authority, and they are not offered as such. They are offered for the limited practical point that reasonable alternatives were familiar, available, and not speculative. In none of these proceedings, however, intense the public interest or acute the asserted security concern, did a court write a 10-minute window of public access into an order. And in none did a court, having set the terms of access, then deviate from its own order by withdrawing the overflow feed and that it had earlier provided. That is what marks this case as an outlier rather than an example. The occurrence and public character of these widely reported proceedings are matters potentially subject to judicial notice. Texas are blah, 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 and the legal sufficiency of this ground does not depend on them. It rests on Waller, Stedman, Lilly, Presley, Cameron, and the Texas emergency orders already cited. The comparators confirm what those authorities require, that overflow seating, audio access, video feeds, and adequate courtroom space are the ordinary means by which court keeps high-profile trials open, and that the court adopted none of them, confirming that its closure was neither narrowly tailored nor the product of the consideration of reasonable alternatives that Waller requires. The same picture emerges from trials the public has actually watched in recent years. The variable that set those proceedings apart was not whether cameras were allowed inside the courtroom. Some permitted them and some forbade them, but whether the court supplied a reasonable alternative to exclusion, an overflow room, or a live audio video feed. A camera in the courtroom is not constitutionally required. A reasonable alternative to closing the doors is. Every one of these proceedings supplied that alternative. This trial supplied no continuing overflow room and no audio or video access during testimony or punishment. The following comparison is offered for illustration only, set those recognizable proceedings beside this one. So they showed how in Derek Chauvin's case, it was in 2021, and in courtroom cameras were permitted, and the alternative provided was the entire trial was broadcast and live streamed in audio and video, and the state's overflow only proposal was rejected as inadequate, and the public kept contemporaneously informed. Yes. Amber Geiger in 2019, they were permitted in courtroom cameras. The whole officer murder trial live streamed from the courtroom and carried live by local stations, and the public was kept informed. Yes. Uvalde was permitted by in courtroom cameras, and it's had gavel to gavel live stream, a designated media room, and an overflow room space during jury selection. New York criminal trial in 2024, they barred in courtroom cameras. However, they still had an overflow room carrying the proceedings on closed circuit televisions, and they kept the public contemporaneously informed. And then it shows the same type of chart for United States v. Bankman, United States v. Maxwell, and this case in Collin County in 2026. So it showed how all of these other cases allowed, an overflow room, etc. And in this case, in the Carmelo Anthony's case, it says cameras were permitted if authorized, none used to carry the proceedings. An overflow feed during voir dire only June 3rd, then withdrawn for testimony on June 4th. Thereafter, no overflow room, no audio, and no video, and no continuing access. The overflow feed was withdrawn after jury selection. No audio or video during testimony or punishment. The trial judge's own subsequent public statements confirm both the breadth of closure and the availability of an alternative he declined to employ. In a televised interview after trial, a recording of which filed conventionally with the clerk as Exhibit 4, and a verified transcript of which is attached as Exhibit 3, the judge stated that his courtroom held 70 seats, that he had received 200 requests by the media, and that the general public was left with only 27 to 32 public seats. Now, the 27 to 32 is a lie, because there was never 27 to 32 seats. On June 4th and 5th, I believe they gave 27. No, on June 4th, 27 seats were made available. After June 5th, was it? Yes. On June 5th, only 26 of us were able to go in. They did not even offer 27 after June 5th. They started only allowing in 26 public, actually. So on June 5th, it was 27 of us in court. I mean, not in court, in the line. That's the day that Gerald from the NCB got kicked out of the line. He was a part of the 27. After they kicked him out of the line, they did not then get a 27th person to go into court. After that day, they started to only allow 26 public. So the whole part where they said that the judge lied and said that he was allowing between 27 to 32 is a lie. The only time that 27 was allowed into court was on June 4th. After June 4th, June 5th, 27 of us was lined up and slated to go in. Gerald was kicked out. And then after that date, they stopped allowing 27 and they only allowed 26. And the DA had seats. And then as the trial went on, the DA's extra seats started being given to the Metcalf family as well. So they're liars. So it says that re-rotated every day. Figures that corroborate the declaration's account of roughly 27 public seats and confirm that the press was accommodated while members of the public were turned away. The judge further acknowledged that an audio feed was feasible, stating that he sometimes thinks maybe he should have at least audio streamed or something so people could hear it, and that he declined to do so, not for any reason bearing on fairness of the trial or safety of participants, but because in his view, people are gonna distort whatever happens. And so what's the point? So that's what the judge said. Yet he allowed a racist bigot to be in the courtroom and distort everything. But letting everybody else hear was the problem. Yeah, okay. It says offered as the decision maker's own account, these statements corroborate that the closure was broader than necessary and that the court rejected a reasonable alternative for a reason. The public trial guarantee does not countenance whatever the hell. So it says step back. And the order created has no precedent in Texas criminal practice. A standing trial wide order rationed the general public to a single 10-minute entry window and roughly 24 rotating seats, capped attendance behind the media allotment, barred re-entry once the doors closed, and after brief experiment with an overflow feed during jury selection, switched the feed off for testimony. All right, so let me go down to all right, so it's basically saying that they didn't document on the record that there was like any threat or any other reason why they did this. It says the judge owns. Oh, well, let me just read it all for y'all. Let's go to the next one. It says, to account for the restrictions, the court did not point to a single record finding an articulated threat or a considered rejection of alternatives, the things Waller and Presley require, but defended the results as an easy decision. It had struck pretty well. Wait, did we go backwards? We already read that. Okay. The judge's own statement of his purpose confirms that the closure was a deliberate denial of the contemporaneous public access. The Constitution guarantees in a written statement to Fox News after the trial, the judge explained, I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in courtroom was to protect the process, witnesses, and jury. Now that the trial is over, it is important to me to provide transparency. Yet, y'all haven't given the transcripts yet, but y'all want to provide transparency? Okay. That is an admission that public access was restricted during the trial and that transparency was withheld until the trial was over. But the public trial guarantee secures the public's right to observe the proceeding as it happens. It is the contemporaneous openness of the trial, not the retrospective account offered after verdict and sentence. That assures that the proceeding is conducted fairly and discourages misconduct. Transparency furnished after the trial has ended is no substitute for an open trial and cannot cure the denial of access while the proceeding was underway. The interest the judge invoked protecting the process, witnesses, and jury are moreover precisely the kind of generic non-particularized concerns that cannot justify closure absent specific findings on the record. The court's own public information officer independently confirms both the breadth of the closure and the existence of a simple alternative to the court declined to use. That the court declined to use. By email dated June 5th, 2026, Steve Stoller, whom the 296th District Court appointed as the public information officer for this trial, explained the court media and access process to members of the public who had sought to attend. Mr. Stoller confirmed that the courtroom held only about 70 seats, that the prosecution and defense each received 15 seats for family, and that the judge allocated only 9 seats for the media, including 1 for the courtroom sketch artist, and that after court staff, only about 24 or so seats for the general public remained, so that the court had no choice but to turn members of the public away. Most pointedly, Mr. Stoller stated without qualification, there is no overflow room, nor was the absence of an overflow room and an ad hoc response to conditions that emerged at trial. By email dated May 25th, 2026, before the trial began, the public information officer had already advised an inquiring independent journalist that there will be no overflow room during the trial. And I believe that independent journalist that he's talking about is me, because I gave him those emails. All right. Let's continue. I'll show you guys my emails that I provided to them that's in this motion when we get there. But let me check what y'all are saying. Is there anybody who wanted to come up and speak real quick while we continue? Or are you guys just going to listen on? Is there anybody that want to speak real quick? If not, we will continue. My water is like, part of it is frozen. They included several of my emails in this motion, and we'll get to those in a minute. I'll read y'all my correspondence with the court and everything that I provided that's in this motion as well. Unforgettable, hello.
Oh, me.
You are very low. Can you speak
Hold
up?
on. Can you hear me now?
Yeah, go ahead.
Okay. Does my mic sound good?
Yeah, go ahead.
Okay. I wanted to say, Nick, this was meant for you to be at this trial, for you to go through all of it. It really was. And I'm so proud of you. I really am. You are handling this very well.
Thank you.
And in spite of everything that you went through, you still, you know, keeping it classy and maintaining, your integrity and keep staying true to, you. You
Yeah,
didn't
thank
step
you.
out your collar, you didn't step out and give the lady what the chick, what she wanted.
Oh yeah,
But
because we're gonna still pursue other remedies. But go ahead.
okay, and one more thing. You said earlier about her being allowed in the courtroom and everything. Don't forget, she doxed his family.
Mm-hmm.
Everywhere he went, she kept doxing them. Can something be done about that?
I don't know. His family would have to file. Everybody got to file something. You know what I mean?
Mm-hmm.
I don't. You know, they would. I think that they're like there's a lawsuit with the dad, so we'll see what makes of that.
Mm-hmm. Um,
Yeah.
yeah. Well, I'm very happy that you are able to assist his legal team. Has anybody else been able to help him out?
Yeah,
Like in your
they have other affidavits in here. So I read off a couple of different people who gave them statements as to the days that they attended and their denial and things like that. So they got other statements from other people that attended as well.
That's good. That's good. Yeah.
All right. Well, thank you,
All right.
Unforgettable. I'm gonna continue reading.
Okay. And thank you, Neat, for, you know, doing all this for us. Appreciate it.
All right, thank you. Somebody in the chat says, "What about clemency or pardon from Trump? The president can only pardon federal. This was a state case. This wasn't a federal case. So, um, that's the difference." All right, so let's continue. Thank you. He says, "Intelligent with integrity, composure, and class." I know that's right. Child, I appreciate it. Um, right. Somebody said like Trump would never pardon this case. Like if he had the ability to, he would never do it because so many racist bigots are wanting him to be in jail. He would never, like, if he could, because again, he can only basically overturn federal cases. This wasn't a federal case, but if he could have, he would have never did it because it's too many racist bigots that support him and that he emboldens that would be upset if he did that. He would never. He would never. So you're right. If he could have, you know. All right. So let's see, where is it at? Oh, okay. It says by email dated May 25th, 2026, before the trial began, the public information officer had already advised an inquiring independent journalist that there will be no overflow room during the trial. This despite the county's own media request intake form, which listed overflow room access among the accommodations that could be requested. The decision to deny the excluded public any alternative means of observation was thus made in advance of trial, before any trial day circumstance existed that could have justified it. Now, I also provided his defense team with the intake form. And that's under the exhibits that I'm gonna read to you guys that I provided his legal team. It says the 15-seat family allotment the public information officer described was not how family access operated in practice. The defendant's own family was limited to 8 seats in total, so that the defendant's grandfather and aunts were the defendant's own family was limited to 8 seats in total, so that the defendant's oh, sorry. Let me just start over. Child, let me make this bigger. Because after a while, child, this stuff started looking a particular way. All right, let's start over. The 15-seat family allotment the public information officer described was not how family access operated in practice. The defendant's own family was limited to 8 seats in total, so that the defendant's grandfather and aunts were excluded from his trial altogether. The discrepancy is not a conflict in the defendant's proof. It is the proof. The written order disclosed no numerical family allotment, no public seat allotment, no defense family limitation, and no procedure for challenging exclusions. The public information officer's later 15-seat description and Ms. Toussaint's 8-seat account show that material access rules were being administered outside the written order and outside of open court. So his family was told, hey, you get 15 seats, but they were not granted those 15 seats during the trial. Now, every day of the trial, there was the Metcalf family who I believe they had more than 8 seats, but then they took up at least like half of the public seats as well, and they were allowed to do that because the officers were allowing them to cut the line and do all kind of other stuff as well. So there was a whole lot of going on at that court. And on June 5th, when there were some people who got kicked out of the court, it was caused because the Metcalf family was being allowed to cut and the officers wasn't doing nothing about it. They allowed it. And they told us, oh, well, too bad, so sad. So let's see. It says, okay. So set beside the trial judge's own admission, the picture is complete. The judge acknowledged that an audio feed was feasible, stating that he sometimes thinks maybe he should have at least audio stream or something so people could hear it, and declined it not for any reason bearing on the fairness of the trial or the safety of participants, but because in his view, people are going to distort whatever happens. The court thus faced a courtroom that could seat only about 24 members of the public with no overflow room and a readily available alternative. So it says it confirms the failure to consider the reasonable alternatives that Waller requires. These admissions do more than corroborate the breadth of the closure. They reveal the considerations that actually drove it, and those considerations cannot satisfy Waller. All right, so let me go down some. It says, so let me scroll past some. Jury selection, okay, in practices. All right, let's skip past some pages. All right, let's go here. So it says hold on. Let me read what was before that. Okay. The court's off-the-record sealing of the record was unlawful and harmed the defendant. The secrecy did not end at the courtroom door. It reached the court record itself. Beyond the gag order that silenced the parties, counsels, and witnesses, the court directed that motions and subpoenas to be hand-delivered to the court and held under seal, and the court, not the district clerk, served as the custodian of the case file, which was kept in chambers rather than the district clerk's public file. No public order authorizing that arrangement supported by notice, hearing, and findings the law requires before a record may be sealed was ever entered. The docket nonetheless reflects a series of orders restricting the record. An order to redact, June 25th, 2025, an order to file and redact, and an order to seal, both June 11th, 2026, and a further order entered on June 18th, 2026, that the public docket leaves undescribed. The filings in this high-profile prosecution were thus unavailable for contemporaneous public inspection in the ordinary course. All right. So it's saying that the way that they did not allow us to view the record was unlawful, and the fact that they had certain seals and everything was unlawful. It says the sealings was not confined to particular filings. The entire court file was placed under seal by oral order, with no written order, no public notice, no open hearings, and no findings to justify withholding the record from public view. The breadth and basis of that order are confirmed by the court's own statements. At a conference held on June 29, 2026, the court advised the parties that the entire court file had been sealed by oral order, and that counsel could not access the file unless he first agreed not to disclose what he observed in it. Counsel responded that he could not commit to withholding information he had not yet seen, and the court left the file available for inspection only in the court's chambers. The episode lays bare the character of the closure. Access to the record of a public criminal trial was conditioned on a premise of secrecy that no responsible advocate could give, and the file was kept quite literally in the judge's chamber, beyond the reach of the public and of the defense alike. An oral order sealing an entire court file, pronounced without notice, hearing, or findings, is sealing it. Pronounced without notice, hearing, or findings is sealing in its least reviewable form. There is no order to contest, no findings to test, and no record of decision to seal at all. This continuing denial of access to the file of a piece with the closure of the courtroom itself, both with hold the open proceeding the Constitution guarantees, and both confirm that the secrecy was structural rather than incidental. Conditioning counsel's access to the file also impaired the defendant's ability to investigate and present this motion within Rule 21 short deadline. Counsel could not responsibly agree not to disclose or use information before seeing it. The condition therefore prevented counsel from inspecting the complete file during the very period in which counsel was required to identify, verify, and present extra record grounds for a new trial. Defendant does not ask the court to decide the public's independent access rights in the abstract. He relies on the file restriction because it affected his own ability to litigate this motion, and because it corroborates the same off-record restriction of public access that occurred in the courtroom. The public and the press hold a constitutional right of access to criminal proceedings and to the records of those proceedings, and a court may not seal the record of a judicial proceeding in secret. That right of access is a fundamental element of the rule of law, and a court discretion to seal is to be exercised charily, only after it identified and balances the competing interest on the record. Sealing without public notice and an opportunity to be heard is itself unconstitutional. A court may not maintain a file or docket that hides filings from the public view. United States v. Valenti. It says, in Texas, the right of access is both constitutional and statutory. The open court's guarantee of the state's constitution and the command of the Code of Criminal Procedure that the proceedings in the trial in all courts shall be public, secure the public's access to criminal proceedings and the records generated in them. Text Code Crim Proc Art text it says amends the record of a criminal case are therefore presumptively open, and a court may not seal or sequester them without public notice, an open hearing, and specific findings. Although Rule 76A governs civil court records, the same principle of public access applies with full force in criminal proceedings, and defendants relies on criminal open court guarantees, not Rule 76A. As the governing law, see Text R CIV.P 76A, civil sealing procedure requiring a public motion, posted notice, an open hearing, and written findings. The court honored none of these requirements. It sealed and sequestered the record without a public motion, without notice, without an open hearing, and without findings sufficient to justify withholding the file from the public. All right. It says, taken one at a time. Each of these measures might be debated. Taken together, they accomplish what the law forbids by any route. A proceeding materially closed in operation. The general public was rationed to a 10-minute entry window and a rotating handful of seats. The press was capped, and the remaining public turned away. The overflow feed was switched off once testimony began. Substantive pretrial hearings went unrecorded. So it says a gag order restricted the covered persons who might have described what was happening, and the case file itself was drawn into chambers and sealed by oral command. Without notice, hearing, or findings, the through line is not any single ruling, but a consistent effect. Public access was materially restricted through written limitations, off-record administration, and record sequestration. That is the structural injury the public trial guarantee exists to prevent. A proceeding conducted under these conditions is not an open trial marred by isolated irregularities. It is a proceeding materially closed in operation, and the deprivation is complete the moment members of the public are excluded without Waller findings, regardless of whether the outcome would have been different. The record sequestration did more than offend the public's right of access. It directly harmed the defendant. The period after judgment was marked by a rapid succession of counsel. On June 10th, 2026, trial counsel withdrew, and the court appointed appellate counsel, who was then replaced by newly appointed appellate counsel before the defendant's present counsel were substituted in on June 23rd, 2026. Throughout that period, and while the 30-day deadline for a motion for new trial was running, the materials necessary to evaluate and prepare the motion were held by the court in chambers and were absent from the public file. Each successive counsel was thus required to come up to speed and to prepare against a hard statutory deadline on an incomplete and inaccurate record. The reporter's record could not fill the gap. When counsel contacted the official court reporter, counsel was advised that no portion of the trial had been transcribed. Counsel was thus left to prepare this motion with neither the pleadings and case file held in the court's chambers nor any transcript of the proceedings, and no substantive pretrial litigation occurred. An impression the sequestration of the file left no fair opportunity to test in the time allowed. By withholding the record during the very window in which the defendant and his changing counsel had to identify and develop the grounds for relief, the court's unlawful sealing compressed the defendant's effective time and deprived him of the complete and accurate record to which he was entitled. The defendant's entitlement to a new trial rests on his own Sixth Amendment right to a public trial. The court's off-the-record sealing confirms that the public access was materially restricted in both the courtroom and the case file, and that the restrictions was structural rather than incidental. And by impairing the defendant's ability to prepare this motion on a complete record, it worked a distinct unfairness that reinforces the need for relief. The resulting violation is structural. The gag order reinforces the need of for a hearing and shows the cumulative restrictions on public access. The defendant does not seek in this motion to litigate the public's or the witness's independent speech rights in the abstract. The defendant relies on the gag order because, together with the access restrictions and the record sequestration, it limited contemporaneous public understanding of the proceedings and underscores why the denial of public access was not harmless, trivial, or curable after the verdict. Let me catch y'all up to the page we are on. All right. Oh wait, which page are we on? Oh, let's go over one more. All right. Let me check in on y'all. Somebody said, I just read something that he said he declined to recuse himself. I'm sure that he would decline to recuse himself, because if they admit that they want to recuse themselves, that's also kind of like admitting that they did something wrong. So they almost always deny to recuse themselves. If you guys remember in the YSL trial, Glanville was asked to recuse himself and he denied it, but his lawyers motioned that he was biased and doing unfair rulings, and they were able to get a new judge with the whole fiasco that he did with Young Thug lawyer, and then how he did that meeting with Woody that he wasn't supposed to do. And so they were able to get a new judge. So oftentimes the judges are going to deny that, like I think even in the Tory Lanez case, I believe the motion that they asked the judge to recuse himself too, and I believe he denied that as well in that case. And in majority of the cases where I see the judge to be asked to recuse themselves, they most likely are going to deny it. But if they are found to have been running a kangaroo court, then those rulings can be heard outside of them. All right. So the physical closure did not operate alone. From July 28th, 2025 through the verdict, every person with firsthand knowledge of this case, the parties, their attorneys, the witnesses, expert consultants, agents, spokespersons, law enforcement, and court staff, was forbidden on pain of contempt from making any statement that addressed the character, credibility, expected testimony, guilt, or innocence of any party or witness that it intends is likely to influence public opinion or potential jurors. A prior restraint of that is presumptively unconstitutional under Article 1, Section 8 of the Texas Constitution, which provides greater rights of free expression than its federal equivalent, and it survives only upon specific findings supported by evidence that, one, An imminent and irreparable harm to the judicial process will deprive litigants of just resolution of their dispute. And two, the judicial actions represent the least restrictive means to prevent that harm. Davenport v. Garcia. It says some legal codes, and then it says gag order challenge in a criminal prosecution considering Davenport and First Amendment standards. Prior restraints bear a heavy presumption against validity. The July 28th order findings failed to test on their face. A finding that media coverage has the potential to cause imminent and irreparable harm is a finding of possibility, non-imminence. The speculation Davenport forbids. No evidence is recited. None was heard. And the findings that venue change, juror screening, and sequestration would be inadequate alone concedes the point that decides the issue. The alternatives existed, and the court knew them by name. Indeed, it went on to employ two of them, screening the veneer through written questionnaires and sequestering the seated jury. The latter widely reported and to be confirmed at the hearing. A restraint is not the least restrictive means where the court's own order catalogs the lesser tools and the court's own trial deploys them. That the order issued sua sponte on no party's motion with no evidence offered by anyone completes the failure. And in the 10 months it operated, not a single violation was ever alleged. So far as the record reflects, the imminent harm never once threatened to materialize, and the post-speech remedies Texas law prefers were never needed. The absence of enforcement is not the absence of injury. A prior restraint does its work through obedience, and here it is obeyed. The order's fourth prohibition severs the restraint from its only asserted justifications. Child, let me read that over. Child, 44 pages in, I'm starting to feel woozy, but that's my looking at the screen. Okay, let's start over. This is the 100th paragraph, by the way. All right. The order's fourth prohibition severs the restraint from its only asserted justification. The findings speak of juror impartiality. The prohibition reaches any statement likely to influence public opinion. Public's opinion, generally jurors or no jurors, for nearly a year in any public medium. A witness who professed the defendant's innocence to a reporter. A family spokesperson who questioned the prosecution. A court-appointed official who described the access restrictions themselves. Each spoke on pain of contempt. Whatever latitude Gentile v. State Bar of Nevada affords for regulating attorney speech under the substantial likelihood of material prejudice, standard that latitude has no application to lay witnesses and spokespersons, and no standard known to Texas or federal law permits gagging commentary addressed to the public opinion as such. Somebody said you need AI to read it for you. I'm gonna read it myself, and if you want to stick along, you can. I'm not gonna get AI to read it because I don't want to do that. But if you are irritated, then you can get AI to read it for you. Anyways, Thank you. She said, "You're doing great, by the way. I appreciate you reading yourself instead of hearing fake ass AI read it any day. Just my thoughts." Yes. Um, you know, let's continue. All right. So let's see. Where was I at? Where was I? Oh, and the restraint interlocked with the rest of the design. The gag order so safe harbor procedural announcements, hearing schedules, court filings, presupposed a public docket. The court then sealed the filings by oral order so that the safe harbor described documents no member of the public could read. The gag order itself, meanwhile, provides that it yields only the further written order of this court. Both restraints, moreover, issued, is it sua sponte? No party asked the court to silence the participants, and no party asked it to restrict the courtroom. The gag silenced those with knowledge. The access order excluded those who sought it. The sealing erased the paper trail, and each measure recited the defendant's fair trial rights while the defendant's actual trial was conducted beyond meaningful public view. The July 2025 order matters to the Waller analysis for the further reason as well. It proves the court knew the less restrictive toolkit listing venue change, juror screening, and sequestration by name 10 months before trial. And when the time came to restrict the courtroom itself, the court considered no alternative at all. All right. It says, a violation of the right to public trial is structural error that is not subject to harmless error analysis. Johnson v. United States. And then it says a civil code, because the closure pervaded every stage of the proceedings at which the order applied, jury selection, the guilt innocence phase, and the punishment phase, rather than the discrete ancillary hearing. The appropriate remedy is a complete new trial. A structural error that is preserved and timely raised entitles the defendant to relief without any showing of prejudice. Weaver v. Massachusetts. I always have a problem saying Massachusetts. Anyways, I always get tongue-tied saying that. Massachusetts. Do y'all get tongue-tied saying Massachusetts? Anyways, somebody said, how long was the motion? Because you mentioned you was on page 44. We a lot of pages away. Okay. There's a lot of pages. A lot. Like double that. Even more than double of that. But we're going to get through it. We're going to get through it. But to answer, there's 193 pages. And if there's anything that starts to be like more repetitive, we'll skip through it. Also, too, when I complete this live, I'm going to clip the pertinent parts. So whenever there are like certain issues, I will like make smaller clips. Okay. So this motion is 193 pages. And yeah, so my evidence that I submitted to them is page 100. It starts at page 100. So we on 44. I'm gonna try to speed it along. I'll try to speed it along. Okay, where was I? Oh, okay. So it says, in the alternative, should the court conclude that any error affected only the assessment of punishment, defendants request a new hearing on punishment. The defendant had no earlier opportunity to object, and this motion preserves the claim. As a general rule, a complaint must be raised by a timely objection in the trial court. Texas RAPP.P. That requirement, however, assumes that the appellant had the opportunity to raise it there. Hardeman v. State, and then it has some code, where a defendant has no opportunity to object to the trial court's action until after the action is taken, a timely motion for a new trial preserves the error. It says the complaint could not have been preserved by a contemporaneous objection for two independent reasons. First, the constitutional violation lies not in the text of the amended order alone, but in the way the access regime operated in practice. A regime that, as the accompanying declaration show, excluded the public far more severely than the order's terms disclosed. The operation unfolded outside the courtroom, at the courthouse entrances, and in the pre-dawn lines administered by sheriff deputies and the public information officer, where the trial counsel seated inside the courtroom and attending to the trial could neither observe it nor measure its scope. Counsel had no way to know from inside the courtroom how many members of the public were being turned away, that the overflow accommodations used during jury selection had been withdrawn, or that admission was being administered without standards. Second, the access determinations were not made by the court in open court on a record to which an objection could attach. The court delegated them to the public information officer and courthouse staff, who administered credentialing, line management, and denials of access off the record. There was thus no ruling for counsel to object to as it occurred, nor did the amended order text put counsel on notice that a closure would occur. The order recited that the media and the public retained the right to attend proceedings and promised reasonable public access consistent with constitutional requirements. It nowhere disclosed the allocation of seats that would leave the general public roughly 24, an allocation that appears in no order and that surfaced only in the public information officer's June 5th email. The court began the trial by performing its promise, furnishing an auxiliary viewing room through jury selection. Counsel was entitled to take the court's order at its word. The closure crystallized only when the accommodation was silently withdrawn, without announcing rulings or modifications of the order, and when admission came to be administered at the courthouse entrances and in pre-dawn lines that counsel bought in with the parties through a separate secure interest. Never saw facts that evidentiary hearing will establish the full scope of the closure became apparent only after trial, when present counsel obtained the declaration of members of the public who have been excluded. A motion for new trial is the proper vehicle to raise such a claim. Dixon v. State 595. The point is underscored by a proceeding that unfolded outside the defense's knowledge. Before trial, a member of the public filed an emergency petition for writ of mandamus in the Fifth Court of Appeals, seeking relief from the same access order as an unconstitutional partial closure. The Court of Appeals denied that petition on procedural grounds on June 4th, 2026. The first day of testimony and the very day the overflow room accommodations was withdrawn. In regarding King NO.0526000804-CR, it says on his motion for reconsideration, the relator served the district attorney and the trial court, but by its own account could not serve the defense because he lacked counsel's email address. And the appellate's court own notices of the proceeding were directed to the district attorney, not to Mr. Howard, the defendant's attorney of record, who received no notice of it. Notice facts that appear from the Court of Appeals docket and the hearing will establish that the public's access challenge was thus pending and litigated as the trial approached and proceeded. And the state on notice of it, while the defense was left unaware that a member of the public was contesting the very closure at issue, and that the state knew of it while the defense did not, both corroborates that the closure was real and confirms that the defendant had no opportunity to litigate or object to it as it unfolded. The record of the proceedings is, moreover, among the materials in the court's file that the court has placed under an oral protective order, so that the proof of who was and was not notified is itself withheld from inspection. A further reason these facts must be developed at a hearing. That is precisely this case. The court restricted public access on its own motion and administered the resulting restrictions off the record and outside of the courtroom, so that the defendant had no contemporaneous opportunity to object to the closure as it actually operated. This motion is therefore the first available vehicle through which defendants can present the complaint, and it does so specifically with particularly the structural error in thus preserved and timely raised, and defendant is entitled to a new trial without a showing of prejudice. Weaver 582 U.S. at 299 to 300. To the extent the court concludes that a contemporaneous objection was nonetheless required and not excused by the manner which the order was imposed, the alternative grounds set out below independently preserve and establish the claim. In the alternative, and to the extent the court concludes that a contemporaneous objection was required, the complaint was preserved because, for the reasons just stated, this motion raised it at the earliest opportunity available to the defendant. The right to a public trial is forfeitable and must be asserted at the earliest opportunity, and a motion for new trial is a proper vehicle for doing so where the defendant had no earlier opportunity to object. Dixon v. State 595, and then it has a code. It says, reaching the merits of a public trial, complaint first raised in motion for new trial where counsel learned of the exclusion only after trial. See also Peyronel v. State. It says a code, and it says public trial right is forfeitable. The trial court's independent obligation to protect public access does not diminish this showing. The two principles operate on different planes. Presley fixes the court's substantive duty to consider reasonable alternatives and make adequate findings before closing any portion of the trial, and to discharge the duty even on its own motion. All right. I don't know why it shows that I got gloss on my top lip, but this bottom lip, like, it just eats the gloss up and my mouth be feeling dry. Sorry, y'all. Gerald, hello.
Hey, what's up? I've been up here for like 40 minutes. Oh my
Oh,
God.
dang, I didn't even see you. My bad.
I'm just playing. I just came up like 5 minutes ago.
Oh, okay.
Yeah, I just really finished my little video that I did, but I am just in disbelief. I mean, I'm not really in disbelief, but we called this from the beginning, and it is all coming out now. We knew this was kangaroo court. I mean, to hear about this secret deal and, to see that, Karmelo's mom was given 3 pre-approved questions, and to see all of the affidavits from, the black media, this is just a mess. And, the appellate team really made a good argument about, Judge Roach and his comments, because when you think about it, the trial was over on June 9th. Karmelo filed a notice of an appeal on June 10th, and the judge is out here making comments days after. I mean, the case would still be in a pending state. You know what I'm saying? And
while not offering the transcripts to legal counsel.
right, and being that the transcripts have not been transcribed, they said that they were in the judge's chambers, Judge Roach's chambers. What they doing in his chambers?
Right.
Like, what are you like? Like, see, this is crazy. Like, what are the transcripts doing in your chambers, bro? Like, are y'all trying to take stuff out? How do we know that they're not going to take something out of the transcript? Like, how do we know that, the judge is not, ordering someone to take this out and take that out? Or, like, come
Right.
on.
Right. Like, what? Where's this like secrecy that they're doing in this? Like, it's weird.
Yeah, it's really weird. And, hopefully, Carmelo gets a new trial. I mean, my man, I don't know. It's like you have hope, and then it's like you don't have hope, because it's like, they play this game with black people every single time, and it's like, so I just really hope that, this argument lands. I hope that Judge Roach get recused, and if he don't, he'll hear this new motion for a new trial, and we already know how that's gonna go.
Right.
So what else did you read that stood out? I still have to go through a lot more of the documents. Like, what did you read that stood out to you?
What stood out to me so far is the fact that they put all of the, well, I already knew that they put, I think, let me mute you while I talk because it's a feedback. What I knew going into covering the trial, I already knew that all of the pretrial motions was under a gag order. Before I even covered the trial, I thought that was highly suspicious, because any other trial that I've covered, be it the Diddy trial or the T.I. and Tiny trial, or any trial that I covered, we were able to see the pretrial motions before. We were able to see what they were trying to argue, what they were trying to get in, what the judge excluded. The fact that he had all of these things under seal was sus to me. The fact that I reached out to the PIO and they told me that nobody was selected, and I happened to write them on a day that they had all of Legacy Media there. They did not open that to anybody who applied, and then later said, oh, just kidding, y'all don't have a chance to cover this. We only gonna let Legacy Media cover it. It's like y'all played in our face, then them telling me that I couldn't use a pen and a paper. All of that was sus, and that's when I kept reaching out to you, like, I don't know, I'm feeling iffy, like, this is weird, like, they trying to hide something is weird, like, what, since when do they not let you use a pen and a paper, and since when do they have rules like this, and all of these things. I'm like, this is sketch. Like, I kept going back and forth on, if am I going to be safe going out there? Like, safety was a big deal, and how they were not making sure that we were going to be safe was also sus, down to how they operated in court. Those kids got on the stand, they lied. The defense attorney never contested whenever they said, who was at fault? Was Karmelo? Like, they never contested that. And it was just like, since when is it a self-defense case and you don't rebut what they're saying? Like, all of it was sus. The way that they said that there was an order that nobody could be on the premises at 6, but then on June 4th, they told all of the Metcalf family and gave them access to the lot. And it was like 15 of them ahead of us was sus. The way that when we got there and wanted them to honor first come, first serve, they told us that they can't honor it. The only time that they can honor it is once we get in front of the courthouse. And it was like a zoo. All of that was weird. Like, they were creating chaos. And I feel like they were purposely trying to create chaos so that they can try to justify some of this bullshit. But
Half sweet tea, half lemonade. Half sweet tea, half lemonade.
Gerald, you over here ordering something?
No,
I
that'll
said
be
all
it.
this stuff.
Hold on, sis. I'm sorry. I'm trying to order some food right now. Hold on. I was like, soon as I got ready to order, you was gonna tell me to start talking. But yeah, so I did hear, what you were saying about all of this different like type of rules and stuff. You're absolutely right. I've never covered a trial where you don't see the motions already that was filed, or all of the court documents and stuff. Now, this was a different case, man, and I just knew about it. Like when I did my research about Collin County and seeing that it's Republican and MAGA, I already knew what time it was. You know what I'm saying? That's
Mhm.
why, off of the yes, Buffalo and Ranch. That's why when I was telling you, I was like, listen, I ain't really trying to stay down there in honky town. I'm trying to stay like a city over because I mean, just experiencing that crazy stuff and racism, the officers not protecting black people, just taking the sides of white people, not taking police reports seriously, not investigating stuff, not trying to, keep the peace and calm. Like, I thought that's what y'all are, peace officers. Like, it was
Right,
so
right.
much chaos. I mean, I've never seen that. It was kind of like the Diddy trial. Well, I ain't gonna say it's like Diddy trial, but it was just like, I think this was just mentally worse.
Yeah, it was worse than the Diddy trial for me
I
because
mean, you too.
in the Diddy trial, we could go into the overflow room. We didn't have to be a part of that. And they have multiple overflow rooms so that you can choose, like, do I want to go in courtroom A or courtroom B, or you know what I mean? Like, and you
Right.
could get a, like, if there was a crazy homeless person in this one, you can go into that one. Like, it was much more comfortable in that was chaotic.
Yeah, and spread out. Yeah, absolutely. I think with the Diddy trial also was we was dealing more with people than like actual police officers and officials and these corrupt freaking judges and prosecutors and stuff. But yeah, um, I just really hope that he gets a fair shot. I mean, I don't know. I just feel like all them judges, they are all MAGA. Like even the black judge that gave him bond, I think she was a Republican too. But
Mhm.
maybe, I think maybe, I don't know, she looked at the facts or what have you and, decided to give him bond or whatever. But I don't know, man. I think a judge from another county like Dallas County need to review this case, or
Yeah.
somewhere where there are, equal share of whites and blacks. Because when you talk about Collin County, what it's like 10% black people, I mean, that's really not that's really not like your peers, because when you look at that jury, it is black people in Collin County. So why isn't there a black person on the jury? Like, Collin County is not just made up of white, Asians, Indians, or whatever. It is some black people there. So there should have been some black people on that jury. Then he would have been able to, say, okay, I had, my peers, on the jury or whatever, like a jury
Yeah.
of my peers. But to put these people up here, this is not his peers. Like, what? What
And
other people that
all
look
the
like him?
and listening to how they were operating stuff and not putting stuff on the record. And I don't know why Mike Howard would even agree to not put stuff officially on the record. Like, where they do that at?
I'm still trying to really understand this deal. Like, how could that deal benefit your client?
At
Like,
all. Like, nothing. Like, you need an expert, you need a
right?
psychologist. Like, why would you ever even agree to that? Like, that's
Like,
what
why?
made me think it was a setup. Like,
Yeah. And why would you even agree? Like, if you're claiming self defense, you have to talk about character, reputational. Like, you have to. That's probably why they didn't bring up those emails from the cheerleaders. But I feel like when you're telling your story, like, you have to be able to characterize how someone was approaching you in order to like explain why you felt the need to defend yourself. And
Yeah.
that's why I'm trying to understand, how did Mike think this was benefiting his client? Was this the most I mean, I don't know that mother.
Right. That makes no sense.
It makes no sense, like the whole deal. And it's like, who approved the questions for the mom? Did you read who approved them?
Uh-uh.
Like, I'm trying to figure out, the mom had 3 pre-approved questions on the last day of evidence, which was June 8th, which would have been what, the defense last day of presenting evidence. And she was asked 3 questions that were already pre-approved by who? The judge acting
Right.
like he don't know nothing about a deal because it's not on the record. Duh.
Mm-hmm.
Like, man, this jump made me
Yeah.
mad all over again. Cause Mike know better. Like, come on, bruh. You should be disbarred. Like, you should not even be able to practice law. To be
And
making
not just
deals.
him, he had a co-counsel as well. Like it was him plus his
Yeah.
co-counsel.
Toby shook too. Like, I'm sorry. Hold on.
Yeah.
I'm just like, yo, what in the world, man? Like, how
Yeah.
do
Who's this
you
that we
just?
the people just entered? Oh, they clicked off. But I'm gonna let you say some more. I'm gonna talk to the people. I'm gonna use the bathroom really quickly and then I come back. Tell them what you think.
Okay, I'm trying to let this motorcycle go by. Oh my gosh. But yeah, y'all, like, I just honestly feel like that this whole case, is about the color of your skin. If you're not white in Collin County, or if you're not on the other side, because we already know that had the roles been reversed, they would have said that, oh, he deserved it. Carmelo deserved it. He should not have been, he shouldn't have put his hands on anybody. Like, we know how this stuff goes. You know what I'm saying? And then you have these racist white magatards that sit on Twitter all day, grifting, claiming that they are victims, scared of black intelligent journalists who are reporting the facts as they are coming out, both sides, and giving our opinions on the facts. I just honestly feel like that this was all a scheme that Todd set up. Throwing a little joke there, because you got to laugh to keep from crying sometimes. But I just honestly feel like that, Carmelo Anthony has a good defense team. You know, we'll see how the motion for his new trial goes. I just don't feel like that they're gonna grant it. I seen the press release that Judge John Roach put out about the judges, thanking them. And when you file a motion to recuse a judge, it goes to another judge who has to decide whether that judge you're wanting to be recused should be recused or not. And I just feel like they are a tight knit community. Bill Worski, the prosecutor, told the jurors that in opening statements. They are a tight knit community. We were at the game. I saw the people come in, and everybody was so, just so community, and it's a railroad, man. It's a railroad. And
Yeah,
I just, yeah.
it's definitely a railroad. They arguing over on my Facebook. Who y'all arguing with? I don't even know who they arguing with. But all right, thank you,
You
Gerald.
know the racist code.
I'm gonna mute you real quick
You're
and
welcome.
finish reading some more of the paper.
All right, I'm gonna step down because I'm about to be home and eat. Thanks.
Okay, all right, thank you. All right. All right, so let's see where we at. Let me see where I'm at. In summary, the grounds and facts supporting a new trial on the first ground are these. The trial court materially restricted public access during the testimonial phase and the punishment proceedings, repeatedly excluding members of the public without the findings or consideration of alternatives. While it requires the same access regime applied across jury selection, guilt, innocence, and punishment, and repeatedly excluded members of the public from substantial portions of these proceedings, and the resulting violation is structural. The defendant had no other earlier opportunity to object, and a new trial is the only adequate remedy should the court not find the first ground persuasive. It should next consider the second ground for new trial. So the second ground for new trial, the state's repudiation of the parties' unrecorded agreement limiting character evidence after the defense relied on it, coerced the waiver of the defendant's rights to testify, denied him a complete defense, and warrants an evidentiary hearing. A, the agreement that the defense, the agreement and the defense reliance. Paragraph 111. Okay. Santabello does not involve an identical procedural setting, but it supplies the governing due process principle. When the state induces detrimental reliance on the definite promise and then repudiates it after the reliance can no longer be undone, fundamental fairness is implicated. The Santabello v. New York, the state made a promise, the defendant relied upon, then broke it. Through a change of prosecutors and perhaps inadvertently, the court held that the breach could not stand and vacated the judgment, even though the breach may have been unintentional, and even though the sentencing judge said the broken promise had not influenced him. The defense here relied on the parties' understanding through successive phases of trial, voir dire, the opening statement, and the cross-examination of the state's witnesses, and the state repudiated it only when the defense reached its own case, at the point when the reliance could no longer be undone. If the inadvertent breach in Santabello required relief, the deliberate mid-trial repudiation here warrants at the least the hearing this ground request. Let me catch y'all up on what page I'm on. And a lot of people don't like the full filings. They just like you to give them a summary. But I want to give y'all everything and break it up later. So I know the actual meat and potatoes is boring to a lot of people, but I want to read everything, and I figured if I'm going to read everything, then I might as well read it with y'all on live. Why not? Why do I keep putting my lip gloss in here and it keep getting lost? Sure. Anyways. Oh, because it's over here. So sorry if this is boring to some of y'all, but we'll clip it up and we'll shorten it for everybody else who wants just the clip notes. But somebody said the full filing is on Calhoun County website, ? I don't know where it's at. I was sent the full filing personally. I'm not sure if it's on the website or not. I was sent it directly. All right. So where we at? All right. So it says through a change of prosecutors and perhaps inadvertently, the court held that the breach could not stand and vacated the judgment, even though the breach may have been unintentional and even though the sentencing judge said the broken promise had not influenced him. The defense here relied on the parties' understanding through 3 successive phases of trial, voir dire, opening statements, and I already read that. All right. Before and during the trial, the state and the defense operated under an unwritten understanding that certain character and extraneous offense evidence would be excluded and would not be offered at trial. The reliance on that understanding, the defense made strategic commitments it could not later retract. It conducted voir dire and the selection of the jury, delivered its opening statement, and cross-examined the state's witnesses, including foregoing questioning it would otherwise have pursued concerning the knife, on the assumption that the agreed upon evidence would not be introduced. The understanding was never reduced to writing or placed on the record. The agreement by its terms covered the defendant's own testimony. Every description that the lead prosecutor gave defined the understanding by reference to what happened under the tent. And the defendant was himself an eyewitness to those events. The defense therefore understood by the plain meaning of the prosecutor's word that the defendant could testify to the incident just as any other witness without opening the door to character, reputation, or extraneous offense evidence. In reliance on the agreement, the defense forbore throughout the state's case from cross-examination it otherwise would have conducted, declining to confront the state student witness with their own prior statements describing the complainant's aggression, such as that Often Metcalf was kind of like the aggressive guy on the team, Mason Nordyke, that he got triggered, Edwin Parra, that Austin and Hunter are not going to let you disrespect them. It says that if Austin is about to get into a fight, you can tell, and that Austin can be a bit aggressive at times. It says, another person says, in the same reliance, the defense declined to designate or call its neuropsychology and forensic psychology experts, introduced none of these subjects during voir dire or opening statements, and limited its punishment presentation to 3 pre-agreed questions of the defendant's mother. It says, when the defense began to present its case in chief, the state asserted for the first time that the defense had opened the door to the previously excluded evidence through statements in its opening, and it threatened to introduce the character and extraneous offense evidence the understanding was meant to exclude. By then, the defense had already committed to the course it charted in reliance on that understanding. Its voir dire, its opening statement, and its cross-examination of the state's witness were complete and could not be undone. A party that obtains benefit of an opponent's reliance on a definite understanding and then repudiates that understanding once the reliance can no longer be withdrawn raises a serious question of fundamental fairness. Where one party performs in reliance on the other's promise, due process does not permit the promise simply to be disregarded. The prejudice was compounded by the court's response to assess whether the door had been opened. The court engaged in further review and previewing of the evidence, a course the parties' original understanding had not contemplated. Affidavit of Trial Counsel, Exhibit 10, the court itself addressed the understanding and stated that any such agreement between the parties would be unenforceable, confirming that the dispute over the alleged understanding was squarely before the court, and the defense claimed reliance could not be vindicated through enforcement on the existing record. Affidavit of Trial Counsel, Exhibit 10. Defendant does not, on the present record, advance a freestanding claim of prosecutorial misconduct. The existence and terms of the understanding and the circumstances of its repudiation are disputed and require development at a hearing. I don't even know if I'm saying that right, but Who are y'all arguing with? Hold on, let me go to Facebook because y'all are arguing with somebody that maybe I need to block. Hold on 1 second. Let's go to Facebook. Y'all arguing with somebody and I don't see it. Let me see. Y'all arguing with who? Y'all arguing with? What's going on? Who we need to block? Who y'all talking to? Who we blocking? Hold on. Why is it not showing me the full thing? Hold on. Oh, boss. Oh, okay. Hold on. Okay. Okay. If that's the problem, we got him out of there. Okay, boom. Hopefully that fixes it. Now. All right, let's continue. Sorry, those of y'all who are watching me on Facebook. Okay, let's see. The repudiation. Let me make sure I'm saying this right. How the fuck do you say this word? How to say this? Oh, so I said it right. Repudiation. That's what I said, right? I think I said it right. I said repudiation. Anyways, the repudiation coerced the defendant's decision not to testify. After the state disclaimed the agreement, the court advised that it knew of no mechanism to enforce the agreement and would rule under the rules of evidence alone, and it allowed the defense only about 10 minutes after requiring counsel to preview the entire direct examination with the prosecutor to decide whether the defendant would take the stand. Forced to choose between testifying and exposing himself to the very evidence the state had agreed to withhold or preserving the forbearance the defense had already performed, the defendant elected not to testify. A 180-degree change in the defense strategy that was the direct consequence of the breach of the agreement. A waiver of the fundamental right to testify extracted under those conditions is not the knowing involuntary choice the Constitution requires. Rock v. Arkansas. A prosecutorial agreement the defense relied upon is binding and enforceable as matter of due process. Agreements between the state and an accused are enforced as a matter of due process and fundamental fairness, and a court must independently assess such an agreement. Effect on the constitutional rights at stake, Ricketts v. Adamson. What transforms such an undertaking from unforeseeable proposal into a binding constitutionally significant commitment is the accused's detrimental reliance upon it. Mabry v. Johnson. A proposal on which the accused has not relied is without constitutional significance. While the promise relied upon the defendant's detriment implicates the due process clause, Santabello 404 U.S. at 262, here, unlike in Mabry, where relief was denied, precisely because the accused had not relied on the withdrawn proposal. The defense relied on the parties' understanding continuously and irreversibly. Through Vardir, its opening statement, and the cross-examination of the state's witnesses, and finally in decision whether the defendant would testify, that reliance is what rendered the understanding binding, and its mid-trial repudiation of denial of due process. Nor may the agreement be dismissed as one of the states lacked power to make or the court lacked power to recognize, While a grant of transactional immunity requires the approval of the court, a prosecutor needs no such approval to bind the state not to use particular evidence. A prosecutor can engage in a binding agreement to refrain from using particular evidence and may bind himself to an agreement for use immunity without court approval. The parties' understanding was precisely that, a mutual undertaking not to introduce the character, reputation, and extraneous offense evidence each side had assembled against the other. It bound the state when it was made, and it enforceably did not depend on whether the trial court believed it possessed a mechanism to enforce it. These principles are not confined to the plea context. Courts enforce a prosecutor's promise and forbid the states from keeping the benefit of a defendant's reliance while repudiating the promise that induced it. As a matter of fundamental fairness, even where the breach was unintentional and even where the promise bore on the accused decision whether to testify. It has this code in there. And then it says enforcing an unconditional promise relied upon to the detriment of the constitutional right not to testify, barring prosecution where the accused cooperated and testified in reliance on a promise of immunity. The state here induced the defense to forego an entire category of evidence and cross-examination, and then once that reliance could not be undone, repudiated the understanding to expose the defendant to very evidence it had agreed to withhold. The paradigm of the unfairness these decisions condemn. The consequence fell on rights of constitutional dimension. The accused has a fundamental right to testify in his own defense, Rock v. Arkansas, and to present a complete defense, Chambers v. Mississippi, Crane v. Kentucky. Defense had been built, and the resulting threat to expose the defendant to the extraneous offense, evidence, and understanding had withheld, forced the defendant to forego the stand and the defense to abandon a strategy to which it had already committed before the jury. Whatever the merits of the parties' disputes over the agreement scope, its effect was to deny the defendant a fair opportunity to present his defense, an injury that does not turn on which side had the better reading of the agreement. As trial counsel has sworn, the state's breach directly and significantly undermined the defense's ability to present a complete defense. National standards confirm that such understandings belong on the record and that the state may not weaponize their absence. Professional standards reinforce the same point. An understanding affecting the client's substantial rights should be placed on the record, and a prosecutor bears both a duty and a duty of candor to the court and a duty to make a clear and complete record. Defendants' claim, however, rest on due process and detrimental reliance, not on those professional standards themselves. There remains a basic unfairness in who was made to bear the risk of the understanding silence. The understanding was reached among seasoned professionals, experienced prosecutors, and trial counsel, negotiating in the shadow of a court that itself addressed the subject. If lawyers of that experience did not or could not reduce the understanding to a writing or record clear enough to hold the state to it, the defendant, a young man and a recent high school graduate with no training in the law, cannot fairly be charged with having failed to secure what the seasoned professionals around him left unwritten. The defense relied on the understanding. The state accepted the benefit of that reliance and then disclaimed the understanding once its silence became useful. A process that asks the least sophisticated participant in the courtroom to absorb the consequences of the most sophisticated participants' failure to make a record is not the even-handed process due process requires. At the least, the equities demand that the court resolve this dispute on a developed record rather than on the state's after-the-fact account. The understanding, the reliance, and the repudiation can be identified with specificity, and they present fact questions for the hearing. The evidence, the understanding withheld was the character, reputation, and the extraneous offense evidence each side had assembled against the other. As to the defendant, the acts itemized in the state's notice of intent to use extraneous offenses. As to the complainant and his brother, the evidence of violence, bullying, and racially motivated conduct set out in the defense motion in limine. The parties reached the understanding in a series of meetings and conversations in May 2026, culminating in a conference with the court on May 21st, 2026, and the defense memorialized it in a motion in limine tendered to the state and the court. In reliance, the defense conducted voir dire, delivered its opening statement, and cross-examined the state witnesses without introducing the withheld evidence, and it shaped its case around the decision to call the defendant to testify. The defense began its case on June 6, 2026, and continued it on Monday, June 8th. On that final day of evidence, the state asserted for the first time that the defense had opened the door in the opening statement and that the understanding had never contemplated a testifying defendant. Okay, so basically right here is they waited to the end, something that they should have objected to in opening statements. They never objected until it was time for Karmelo to testify. Then they say, oh, well, they opened the door, so if he testifies, then we can introduce X, Y, and Z. But if they would have objected and it would have been ruled on during opening statements, when Karmelo's attorneys questioned the witness, if they knew that the door was already open, they would have acted on that and introduced evidence that Austin and his brother are thugs and bullies, and they had disparaging conduct. They would have been able to introduce these things that they thought were under an agreement. But what they did was they waited to ambush them with this open the door strategy that they were supposed to object to during opening statements when they claim it was first introduced. And the judge allowing them to do this, I mean, we see how he ran his court. Unjust, unfairly, and it's definitely corrupt. So, oh, okay, sorry. What page am I on? What page? Let's see. Sorry, y'all. What page are we on? What page do I have on the screen? Ooh, child. I gotta catch y'all up. Hold on, my bad. All right. Let's see. Where was I at? I'm on paragraph 122, and I am the party. Okay, so I'll read that over because I think some of y'all may have misunderstood. So let me just start back over at 122. The understanding, the reliance, and the repudiation can be identified with specificity, and they present fact questions for the hearing. The evidence, the understanding withheld was character, reputation, and extraneous offense evidence each side had assembled against the other. As to the defendant, the acts itemized in the state's notice of intent to use extraneous offenses, and as to the complainant and his brother the evidence of violence, bullying, and racially motivated conduct set out in the defense motion in limine. The parties reached the understanding in a series of meetings and conversations in May 2026, culminating in a conference with the court on May 21st, 2026, and the defense memorialized it in a motion in limine tendered to the state and the court. In reliance, the defense conducted voir dire, delivered its opening statement, and cross-examined the state's witnesses without introducing the withheld evidence, and it shaped its case around the decision to call the defendant to testify. The defense began its case on June 6, 2026, and continued it on Monday, June 8th. On that final day of evidence, the state asserted for the first time that the defense had opened the door in opening statement and that the understanding had never contemplated a testifying defendant. And the court advised the parties that it had no mechanism to enforce the understanding and would rule under the rules of evidence alone. Okay, somebody said, I'm confused. Okay, so they have evidence that they did not want introduced to make Karmelo look bad, right? So because there is some evidence that would make Karmelo look bad, the defense agreed, I won't make Austin and Hunter look like the bullying thugs that they are. If you agree not to use evidence that was before the track meet to make Karmelo look bad. So both of them had bad character evidence that would paint the victim negatively and paint Karmelo negatively. They both had a pile of prior acts that showed that Austin and Hunter were thugs and bullies. And then they had evidence against Karmelo. Whatever evidence they had against Karmelo, I don't know because they haven't said it here and it didn't come up in the trial. Now, they made this agreement orally amongst the prosecution and the defense that I won't bring up the bad character of these thugs and you don't bring up the bad character evidence you have against Karmelo. So they go and the jury hears the opening statements. They hear the voir dire. They hear how he questions the witnesses, and they never say, hey, in opening statements, you opened the door to this bad character evidence and you didn't tell us that he was going to testify. We didn't know that he was going to testify, basically. And so now that you want to put him on the stand, we didn't know that he was going to testify, and you opened the door to bad character evidence. And so therefore, when he gets on the stand, we're going to confront him with bad character for him. But that puts the defense at a disadvantage because prior to Karmelo testifying, they could have introduced all of this bad character thug behavior of Austin and Hunter. So they would have only heard the bad character of Karmelo and not the bad character of the thugs. So because it would have been one-sided in bad character being introduced, they decided to not testify. Now, had they known that they opened the door for this bad character evidence in opening statements, then they would have been able to confront all of the other witnesses a different way. They would have been able to put it all out on the table. But because they were working under this agreement that they thought they had, they didn't put all of the information out on the table. So it put the defense at a severe disadvantage because the case was then, like it wasn't balanced. It was only left to what happened under the tent. When, to me, what happened before the tent was the biggest evidence. all the behavior that happened before the tent was relevant. The fact that they bullied cheerleaders, the fact that they had racially motivated instances, all of those things were relevant. If Carmelo Anthony, let's say, because there was a rumor that he was suspended, if he was suspended, let's put it all on the table. You know what I'm saying? They're boys. Let's put their thug behavior, their bullying on the record, and let's put Carmelo's bad act on the table, and let's be able to shape the frame of mind that he had accurately. Because if they say that he opened the door, he would have been able to say, hey, you know, I had this prior incident. It made me fear for my life, or da-da-da-da-da. He would have been able to explain it. But because they had this bogus agreement, he was only left to tell only what happened under the tent. So he could not explain, okay, this is why I did this, or this is why I did that, and this is what brought me to this frame of mind, because they limited the scope only to what happened under the tent. Why his lawyer would agree to that agreement, we don't know what they had on Carmelo that he thought that that was worth it. But if he didn't murder nobody, I don't think that it was worth it. If he don't got no prior murder, which we know he don't, that agreement was not worth it. If he was suspended, whoop the fucking do. Let's hear it. Because these thugs, the Metcalfs, had bad character too. They were literal thugs. They were all of these things, like, you know? So anyways, hopefully I explained that for y'all who kind of were confused. Hopefully you understand now. Let me know what you think so far, but we'll continue. And now that the racists are gone, should we lift the subscription ban? Should we open it up, or should we leave it locked down? Y'all let me know. I hope he get a new trial and the bad character stuff comes out. Right. Me too. Because it's clear that these Metcalf twins were thugs and bullies. Somebody said keep it locked. Okay. All right. So where we at? Let's change the page. All right. Understanding and would rule under the rules of evidence. Okay. Faced with the repudiation, the defense abandoned its plan to call the defendant and to present certain expert testimony. The state's own conduct then corroborated the understanding it had just denied. At punishment, it called no witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately, precisely as Mr. Worski had described on May 11th, the agreement would operate. A matter the reporter's record will confirm. The state's punishment presentation is circumstantial evidence from which the court may infer the parties' shared understanding at minimum. It is a fact that should be explored at the evidentiary hearing, and the final ledger confirms an asymmetry of the breach. Neither side ever introduced a character evidence the understanding covered. The state's forbearance cost it nothing because the defendant's silence never opened any door. While the defense lost the one witness who was necessarily present under the tent in a self-defense case that required his testimony, these facts are disputed and can be resolved only through testimony. The agreement was never reduced to writing, embodied in an order, or recited on the record when it was made. To complete the record, the defense both furnished its own recitation of the agreement in the trial counsel affidavit and requested the states by email date June 25th, 2026 to counsel for state undersigned. Counsel asked whether there was some type of agreement between the state and the defense regarding extraneous offenses, whether it was not reduced to writing, and if so, for the state to state what you believe the agreement was from the state's perspective, and further inquired about the procedure by which pleadings were delivered to the court but received and not filed, and about any written waivers signed by the defendant or his counsel. June 25th, 2026, email from undersigned counsel to counsel for the state. As the date of this motion, the state has not provided a responsive factual recitation of the agreement. An evidentiary hearing is required. The existence, terms, and repudiation of the understanding, the strategic decisions the defense made in reliance on it, are disputed and cannot be determined from any available record, particularly because no reporter's record of the relevant proceedings is available. These matters can be established only at an evidentiary hearing at which trial counsel and, if necessary, the prosecutor may testify. The trial counsel's account is set out in the accompanying affidavit and will be presented at the hearing. Defendants accordingly request an evidentiary hearing to determine the existence and terms of the understanding, the defense reliance on it, and the circumstances of its repudiation. In summary, the grounds and facts supporting a new trial on the second ground are these: the state induced the defense to try its case under an unwritten agreement limiting character and extraneous offense evidence. Hold on, let me move y'all along. All right. What do y'all think so far? Let me drop the link if there's anybody who wants to come up and tell me what y'all think so far. If not, we'll continue going. Kia Marie says they set him up. This sounds like a setup to me. And it sounds like a setup that his defense attorney allowed. Who agrees to this? This agreement does not benefit your client. Why would you agree to not allow expert testimony, psychologists, all of these things that, even if there was a bad act that he did, can explain? Expert testimony can explain why his behavior could have been what it was, why his epilepsy made him act the way that he did, all of those things. Like, all right, we got racists that are on Facebook. Ben Wilson wants to call us naggers, and I guess that is his way of saying the hard R. They said, he's cold-blooded murderer. End of story. We think you naggers are effing stupid. This person says, Neek, what is the judge's place in all this? He was the one to allow this to happen and not call the proper, as he says, balls and strikes of the motions. OG Patrice, what's your thoughts so far?
Hey, how you doing, Nika? And can you hear me okay?
Yes, I can. I'm going to grab another water, but you go ahead because this is frozen and I need more agua. Go ahead.
Okay, no, I just wanted to say I think you're doing a very good job. And I think having this transcript from the appellate attorneys for the appeal is great, and that you're actually reading it kind of fully in its entirety for us to get a breakdown and a better understanding of the things that they are putting in the appeal. And congratulations to you as well, Neek, for having some of your emails and things that you did while you were there to be a part of this and hopefully that the appeal is granted. And I think that it's very important that this appeal means something to the culture, and by it being such a high profile case is because number one, things like the appeal matters, right? And it matters for things like transparency, because transparency brings about trust. And we know that as Black people in America, that there is usually no transparency and no trust in the criminal justice system when it comes to us. So when you're talking about in that railroad of a kangaroo court that happened in Karmelo's case, there was no transparency there. Therefore, the trust of the people, which is us, the people of public opinion that are on these platforms talking about this thing right now, the trust is broken. It was never there. They didn't allow any cameras and things of that nature in the courtroom. I think that that would have brought about some type of transparency. So things you're bringing up, are very, very good points that they are bringing up, and I really pray and hope that Karmelo gets this appeal for this new trial, because hopefully there will be some new witnesses, some new evidence, because a new trial can bring about all those things. So right now, currently, they can only go by the transcripts in which they have based this appeal transcript off of, which is the, I'm sorry, I didn't hear you.
I said they don't even have the transcripts yet.
Yeah, I heard you say something about the transcripts were locked in the judge's chambers or something. Like, where they do that at? I've never heard of that. But again, these are the reasons why that transparency is important when it comes to the criminal justice system, and when it's particularly when it comes to us, because we know predominantly that, disproportionately the criminal justice system is unfair when it comes to us as opposed to our white counterparts, right? We know that the system is based off of the judgment. It is based off of, and it's particularly looking at the history in Collins County and the fact that they still have, these good old boy mentality people ruling this little county, where there's a buddy system obviously there that's going on, that it's okay for us to commit crimes and do things that are against the law, but God forbid you do it. So it's like, do what I say do, not do what I do. That's kind of seemed the mentality to me that Collin counties have. And we know that it's a very conservative county. So when you're looking at Austin Metcalf, who's a white victim, you're looking at the fact that we had a white judge, there was a white prosecutor, the jury was predominantly white. So when you put all of those things into play, yeah, you're talking about definitely getting railroaded. And I believe that's exactly what happened with Karmelo. I also believe that a lot of his civil rights were violated, right?
Yeah.
Now,
I
when you
believe
talk,
so too.
yeah, and it's even important for us to even realize that competency when it comes to the defense attorney is so important and is a factor in that. I don't know if you read that yet, but the competency of Mike Howard and the Toby Cook guy, right? Like your lawyer have to make sure, uh, per the his amendments and the Constitution, that Karmelo is getting a fair trial. That is to be ensured by him, by the defense attorney, that his legal team can perform competently. I didn't see that. And it's even the responsibility of the prosecutor to make sure that both sides have a fair trial. And I didn't see any of that. I saw a lot of railroading. I didn't see a lot of fairness. I didn't see things that, would ensure even that the judge was being fair. So I think it was things that he said was very suspect, when it comes to allowing things to be said on the stand by the prosecuting witness to sway the jury to have a thought or a process to be one-sided. I from what you guys were coming out reporting to us, Nick, that's what I had in my head, that, okay, this jury is already one-sided already. You
Yeah.
know what I mean? And it just wasn't fair. And I don't know if you read this part already, but there's a part that I wanted to know if it was in there, or if you get to it, where if the appellate attorneys, appeal attorneys, brought up the fact that the judge and the prosecutors and the defense attorney allowed these underage 17-year-olds answer the question to the fact of, did they believe if that was an unalivement or not. I think that that is very prominent and important if it is in there, because that should not have been allowed, and the defense attorney should have objected to that, and he did not object, and the judge allowed it to be said as well. And so when you're talking about swaying the judge, you're talking about allowing some 17-year-olds to give their opinion when they are not officers of the court, they are not professionals, they are
And
not people
they're
that.
not to give what's called a legal conclusion.
Exactly, and leading the witness, or leading the jury, persuading of the jury, right? They don't have the expertise, the know-how, the credentials, or any of these are underage teenagers that you claim you want to protect, but then you're allowing them to give a judgment like that.
And give a
That
legal
is
conclusion.
definitely exactly swaying the jury. So something like that is definitely important. And then,
Because
I
they
know they
needed
can't.
they needed to justify who provoked. They needed them to say that Karmelo provoked so that they can justify that charge. Because they had to put it that he provoked, but the testimony contradicts that. You can't provoke if you're not the one that started it. You didn't put hands on person first. You never stood up. There's like, the testimony contradicts their last line of who provoked, who started it, who was it? Like, all of that is a contradiction, and it was up to Mike Howard to point that contradiction out, and he never did. He never contested it.
Absolutely. And I also wanted to ask about, do you think that there is some type of bias or conflict of interest when it comes to the fact that Toby Cook had a personal or friendship relationship with the prosecution? If
They used
that's
to work
mentioned in
under
there,
the
or
same.
would that be?
That hasn't been mentioned yet. The students ending off with, was it self-defense or not, has not been mentioned yet either. Toby Shook and I believe Worski, them like working together, hasn't come up yet either. So thank you so much for coming up.
Mm,
I will bring you up again at a later
no,
time.
for
Madam
sure.
O,
Yes, hey Neek, thank you for bringing
hey.
me up. So first of all, boo, thank you for doing this because I do my own little behind the scenes research, and a few days ago I stumbled across a document on their website, Collin County Court website, where all of Collin County District judges had just adopted to take on these new rules. And as I'm listening to you read, I'm like, that's what that was for. An example, the no courtroom shopping. So you have to have uh any of your following cases or whatever in the same courtroom. Um, the discrepancy of whether or not to record in the courtroom, all of these things that you're reading, if you go to Collin County Courtroom's website and do their, I think it was under the 2026 press release, like they just adopted these to do all of these things in preparation for this trial, including the new online juror registration portal where now they have to answer the questionnaire. None of this was in existence prior to April 2nd, 2025. All
Mm-hmm.
of this was done in preparation for this conviction. So now I'm looking into the Texas Attorney General's website, and you can find Collin County Sheriff Office requesting to keep certain information from the public as early on as April 10th, 2025. So I just want to come up and say thank you for going to get all of this information and for reading it to us. Um,
Yes, and
and just to
sorry that it's
offer up
so
that little
long.
tidbit.
I be taking my time because, child, these
Oh, Nick,
lights
I
in
can't
my
hear
face.
you.
Oh, she can't hear me?
No, I
Oh,
think it's because she dropped down. Hold on, let me try something.
but yeah, I'm just saying thank you for being patient
Say
with
something
me.
now.
Can you hear me?
On it. Nope.
Okay,
I'll
so
drop
you're
and
gonna have
come
to
back.
go out and come back. Yeah. So, but if you're listening, thank you for being patient with me. You know, a lot of people they be getting on us content creators when we be reading, but they don't take into account that it's bright ass lights blaring in our faces while we looking at a screen, and it's like, you know, it'd be a lot. But thank you for bearing with me. Thank you for listening. We're gonna continue because I got time today. And like I said, for those of you guys listening, I'm going to break down the live and I'm going to clip up the pertinent parts and take out the parts that are like repetitive and make it a smaller live. So definitely stay tuned. We are going to continue. And shout out to all the racist bigots in the chat that are also watching. Hi, you guys are so obsessed with us and you love it here. Okay, so thank you for watching because you guys are also adding to the watch time and the engagement. So thank you to you guys as well. All right, so let's continue. Where we at? Okay. All right. So, in summary, the grounds and facts supporting a new trial on the second ground are the state induced the defense to try its case under an unwritten agreement limiting character and extraneous offense evidence for foregoing cross examination witnesses and its own client's testimony in reliance on that agreement, and then repudiated the agreement after the defense had performed coercing the involuntary waiver of the defendant's rights to testify and denying him the right to present a complete defense because the agreement and its repudiation were placed off the record. An evidentiary hearing is required to resolve them. Should the court not find the second ground persuasive, it should next consider the third ground for new trial. So now they are on the third ground. So they went over the first ground for new trial, which was the fact that they did not have the right to a public trial. The second ground was this secret agreement and then like backdooring the defense at the end when it was time for Karmelo to testify. And then now they're going to go into this third ground for a new trial, and the court's unsupported provocation instruction improperly limited the defendant's rights of self-defense. So let me make sure you guys are on the right page that I'm on. Oh, yeah, we're on the right page. Okay. All right. Paragraph 126. A provocation instruction limits the right of self-defense and may be given only when the evidence supports all three elements. A provoking the difficulty instruction is one of the few charges that can take a defense away from the jury altogether. Properly given, it tells the jury that a defendant who provoked the encounter forfeits the right of self-defense he would otherwise enjoy. For that reason, the Court of Criminal Appeals has held that the instruction may be submitted only when the evidence supports each of its three elements, and that given it without the support is error. Smith v. State 965 SW dot 2D 509 blah blah blah. Here, the instruction was given without that support, and it did to the defendant's self-defense case exactly what an unsupported provocation charge always does. It invited the jury to set the defense aside before weighing it. On a record in which self-defense was the heart of the case, that error was not harmless and it requires a new trial. Almanza v. State. The defendant's defense at trial was self-defense, and the jury was charged on the justified use of deadly force. The court charge, however, is also instructed the jury on provocation, that the defendants forfeited his right of self-defense if he provoked the difficulty. See Texas Penal Code 9.31b4. A provocation or provoking the difficulty instruction is a limitation on, and in some cases, a negation of the right of self-defense. And for that reason, it should rarely be given. Smith v. State 965 SW .2 whatever. It may be submitted only when the evidence supports each of three elements. 1, that the defendant did some act or used some words that provoked the attack on him. 2, that the act or words were reasonably calculated to provoke the attack. And 3, that the act was done or the words were used for the purpose and with the intent that the defendant would have a pretext for inflicting harm upon the other. If any one of the three lacks evidentiary support, the instruction must not be given. Let me make sure y'all are on the same page that I am on. The charge here gave such an instruction. It directed the jury that if the defendant immediately before the difficulty did some act, use some language, or both with the intent to produce the occasion to bring on the difficulty and kill Austin Metcalf, and that such conduct was reasonably calculated to and did provoke a difficulty to which Metcalf responded by attacking or appearing about to attack him, and that the defendant then killed Austin Metcalf in pursuance of his original design, the jury would find against the defendant's claim of self-defense. The instruction thus stripped the defendant of self-defense upon a finding that he provoked Metcalf with a preformed intent and original design to kill him. B, the evidence did not support submission of the instruction. Even viewing the evidence in light most favorable to submission of the instruction, the record did not permit a rational finding on the third Smith element. The state may point to evidence that the defendant remained in the area, exchanged words with Austin Metcalf, possessed a knife, or took part in the confrontation. Even credited such evidence does not show that the defendant acted or spoke with the purpose and intent to provoke Metcalf's attack as a pretext to inflict harm. Provocation requires more than words, presence, poor judgment, or participation in a confrontation. It requires evidence of a preformed design to create the occasion for deadly force. The evidence did not support submission of that instruction. The third Smith element, intent to provoke as a pretext to inflict harm, was absent, and the charge demanded even more, requiring. Let me see. What did y'all say? Oh, let's finish reading. All right. So it says the evidence did not support submission of that instruction. The third Smith element, intent to provoke as a pretext to inflict harm, was absent, and the charge demanded even more, requiring a finding that the defendant acted with the intent to produce the occasion to bring on the difficulty and kill Austin Metcalf, and that he killed in pursuance of his original design. There was no evidence that the defendant approached or spoke to Austin Metcalf with a preformed design to kill him under the pretext of self-defense. The evidence raised at most a sudden confrontation in which the defendant used force he believed immediately necessary to protect himself. Submitting a provocation instruction on this record was error because it authorized the jury to deny the defendant his right of self-defense, even if the charge, no retreat instruction, which withheld the defendant stand his ground protection, unless the jury found he did provoke Austin Metcalf. 3, The error was harmful and requires a new trial. The error was harmful and it preserved defendant's objection to the submission of the provocation instruction. Because the error was preserved, reversal is required. Upon a showing of some harm, Al-Menza v. State, and then this code, preserved charge error is assessed in light of the entire charge, the state of the evidence, the arguments of the counsel, and any other relevant information. The harm here is plain. Self-defense was the central contested issue at trial, and the state did not let erroneous instructions lie. In closing argument, the prosecution affirmatively relied on the provocation instruction, urging the jury to invoke it to deny the defendant his right of self-defense, an instruction that wrongfully authorized the jury to set aside the defendant's only defense, and that the state pressed in summation caused harm well beyond the some harm threshold and requires a new trial. Trial counsel's affidavit establishes that the defense objected to the provocation instruction and that the state relied on the instruction in closing, and the defendant will supplement with the reporter's record when it is available. All right. Let me drink some water, y'all. All right. Where was I at? In summary, the grounds and facts supporting a new trial on the third ground are these. The trial court submitted a provocation instructions unsupported by the evidence, which improperly withdrew the law of self-defense. The defendant's sole contested defense from the jury's full consideration, and the error was both preserved and harmful. Should the court not find the third ground independently persuasive, it should grant a new trial in the interest of justice for the reasons stated in the fourth ground below. So it goes to the fourth. Let's put y'all on the same page as me. All right. Fourth ground for a new trial. A new trial should be granted in the interest of justice. Finally, and in the alternative, the court should grant a new trial in the interest of justice, even where no single ground independently sufficient. Their cumulative effect, a trial in which public access was materially restricted during the testimonial phase, a mid-trial repudiation of the parties' agreement that coerced the defendant's silence and gutted his self-defense presentation, and an unsupported instruction that narrowed the same defense, deprived the defendant of the fair, open, and adversarial trial, the constitution's guarantee. The court retains discretion to grant a new trial in the interest of justice where a valid legal basis supports it. State v. Herndon, and the grounds above supply that basis. Prayer. It says, wherefore premises considered, the court restricted the general public to a 10-minute daily admission window and provided no contemporaneous alternative for those foreseeably turned away. Without the findings Waller requires, the resulting closure is structural error that a new trial is required to cure. Defendant Karmelo Sincere Anthony therefore respectfully prays that the court set this motion for an evidentiary hearing at which the facts concerning the closure of the courtroom, the delegation of the courtroom access determination to a non-judicial officer, the parties' unrecorded agreement limiting character evidence and its repudiation, and the preservation and harm facts concerning the unsupported provocation instruction may be developed, grant the motion, set aside the judgment of conviction and sentence order of a new trial conducted in a courtroom open to the public enter a written findings of fact and conclusions of law in support of its ruling, grant the relief requested in the interest of justice, and grant such other and further relief to which the defendant may justly be entitled. All right. So then it puts all of his counsel, it lists all of his counsel, their state bar number, their law office address, their phone numbers, and then their emails on here. And then it says a certificate of service, and then a certificate of presentment, and then it goes into the exhibits. So now we're going to go into all of the exhibits. Now, let me read this. It says, 1,000% a railroading that happened in that racist kangaroo court, and they know it. How do you get past manslaughter to first-degree murder from warning someone not to touch him? Insane. All right. Thank you for the donation. Let me read some of these that came through. B Rad for real says, we need to chat if you have time and want to. Love your work in class. I'll find a way to get a hold of you. That if you want to chat. What do you want to chat about? Let me know. But thank you so much. Somebody says, hey Nick, are you gonna cover the David trial? I said that I wasn't. Because it was gonna be during this trial, and because the subject matter is with a girl that's similarly aged to my own daughter. So I said that I wasn't. Should I change my mind on that? I don't know. But I originally said that I wasn't. Somebody said they definitely left no stone unturned. These lawyers did. They threw everything into this appeal. Right. All right. So now we're going to go into the exhibits. So the exhibits are, it took us almost 5 hours to get to the exhibits. Child. Let me go read some of the super chats. F Monet, thank you so much for the super chat. Letitia, thank you so much for the super chat. Sally, thank you so much. Kimberly, Kimberly sent 2 different super chats. And then Miss Levi, thank you so much for the super chat. So let me heart you guys' cash apps. Thank you so much. And then trial, it took me 5 hours to read that. Is that bad? Maybe. I don't know. But anyways, if you guys want to donate to the stream, if you're enjoying me reading this docket in full, you guys can definitely donate via super chat. My preferred method is Cash App, and my Cash App is going along the bottom, Neek at Night Media. So now let's go into the exhibits. All right. So 62. Hold on. Thank you so much. They said send a Cash App to Neek at Night Media for support. If you can't, hit them with the like. Okay, it's free. Right. It's definitely free. All right. Let's get into the exhibits. Thank you. All right. Okay, so exhibit 1. Amended order regulating trial proceedings, media access, security, and courtroom decorum, with the order prohibiting extrajudicial statements attached. All right, so this is the order that the judge imposed on the trial. It says, and this was filed May 18, 2026. It says, on this day, the court enters this order to govern all aspects of the trial proceedings in this matter due to the significant public and media interest in this case. The court finds that specific procedures are necessary to ensure the defendant's right to a fair and impartial trial. The orderly, hold on, wait, let me make this a little bit bigger. The orderly administration of justice, the safety and security of all participants, and reasonable public access. Waller v. Georgia is a case that they cited in this, and Shepard v. Maxwell is the case that the judge cited, that the appellate attorneys continued to argue that they failed to even do things based on these cases that they cited. So the court finds that this case has generated substantial public and media attention, and that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial. The court further finds that reasonable time, place, and manner restrictions are necessary and appropriate, and that while the media and public retain the right to attend proceedings, such access is subject to limitations set forth in this order. The courtroom shall open each day of trial at 8:30 a.m. Entry shall be permitted beginning at 8:30 a.m. for members of the media, at 8:40 for designated family members, and 8:50 for members of the general public. No more than 9 members of media shall be permitted in the courtroom at any one time. Seating shall be on space available basis. The courtroom doors shall close promptly at 9 a.m. and individuals arriving after that time shall not be admitted until a recess. Once admitted into the courtroom, no person shall leave and re-enter during proceedings except during a recess. Now, again, this is what the judge ordered on May 18th of this year, and how he determined that he was going to run his court. So anybody who was members of the public, it says from 8:50 to 9 o'clock, that's all the members of the public had to enter the courtroom. And after 9, everything was shut. You can't leave out, and nobody could come in until the next recess. All right. The determination of who qualifies as members of the media, which media representatives will be permitted access to the courtroom, and the allocation of media seating shall be made with the assistance of the court-appointed public information officer for court media representatives must comply with all credentialing requirements established by that officer. The court will not intervene in or resolve disputes amongst members of the media regarding access or seating. The court has appointed Steve Stoller as the appointed public information officer. So the court is not going to get into the business of who the media gets access. Steve Stoller, who worked for all of these legacy media publications, he was at the discretion to choose who got access in the media seats. Now, if you guys don't know anything about Steve Stoller, he used to be on the news. He used to be a reporter. And so all of his peers were the ones that were granted access, and all of the independent media was denied access. Is that fair? I mean, no person, including members of the media, shall photograph, record, or otherwise visually capture the image of any witness, prospective witness, juror, or prospective juror, nor shall any person publish or disclose the name, identity, or personal information of any witness who is a minor, juror, or a prospective juror. No person shall communicate or attempt to communicate with any witness, prospective witness, juror, or prospective juror prior to the return of a final verdict. No interviews of witnesses, jurors, or prospective jurors shall occur until after the conclusion of the trial, and only if voluntarily agreed to by the person. Photography, video recording, audio recording, live streaming, or any other form of recording or transmission of courtroom proceedings is strictly prohibited. No cell phones or other electronic devices will be permitted into the courtroom. Electronic devices may be permitted in the courtroom by media for note-taking purposes only, subject to approval by the court, and must remain silent at all times. No media interviews shall be conducted in the courtroom, in the hallways, or in any security restricted area of the courthouse. All interviews must take place only in designated areas approved by the court and coordinated with the assistance of the court-appointed Public Information Office. Media activity must not interfere with courthouse operations, security measures, or the orderly conduct of proceedings. Now, all of us that was in the general public, we couldn't leave in and out. However, those 9 media, they could leave in and out if they wanted to. They had different rules. It says all persons attending the proceedings must be dressed in appropriate business attire. Clothing or items displaying messages, logos, symbols, or images related to the case or that are otherwise distracting or potentially prejudicial or are prohibited. Hats/caps are prohibited. No signs, banners, or demonstrative materials may be brought into or displayed within the courtroom or courthouse. No member of the public or media shall be permitted beyond the bar separating the gallery from the intersection of the courtroom. The area shall be limited to counsel, parties, court personnel, law enforcement officers involved in the case, witnesses when called, jurors, and other individuals authorized by the court. The trial shall be conducted in a secured environment. All persons entering the courthouse shall be subject to security screening, including whatever, and searches of personnel belongings. Additional security measures may be implemented as deemed necessary by the Collin County Sheriff's Office, other court security personnel, or the court. No weapons of any kind shall be permitted within the courthouse. Members of the public and media shall not congregate in hallways, entryways, or other areas of the courthouse in a manner that disrupts operations, creates security concerns, or interferes with the movement of individuals. All persons must comply with the direction of the court staff, security staff, and law enforcement personnel at all times. Order prohibiting extrajudicial statements or gag orders signed July 28, 2025 will remain in force until the completion of the trial or until further order of the court. Order is attached for reference. As stated in the court order, any violation may result in contempt, fines, attorney discipline, or other remedies. And I'm wondering, the Metcalf family was in communication with a certain influencer the entire time. Why were they never held in contempt, or why did they never have any fines or disciplinary action when they were communicating with a member that was acting as a reporter and giving them pertinent information? Why was that allowed? You wonder why. I believe that was done because, in my opinion, there needed to be certain narratives out there for the jury to be, tampered with, and it happened. That's my opinion. Not a fact, but my opinion. Anyways, any exhibits admitted during trial shall not be released to the public or media until the conclusion of the trial proceedings. Finally, as reflected on the attached map, the court has designated certain areas around the exterior of the courthouse as restricted access. These areas colored in red will be secured for the courthouse operations and security and will not be open for use by general public or the media. Furthermore, an individual or group shall not assemble or congregate in areas that block ingress, egress, or vehicular movement or pedestrian traffic. Any individual or group engaging in speech activities on Collin County's premises shall at all times comply with applicable federal, state, county, city, and other local laws, statutes, ordinances, regulations, or rules. Collin County Courthouse located at blah, blah, blah. Any violation of this order may result in immediate removal from the courtroom, courthouse, or courthouse grounds and may result in revocation of media credentials or access and the imposition of sanctions, including contempt of court. No warning is required prior to the enforcement of this order. The Collin County Sheriff's Office and other designated law enforcement personnel are ordered to ensure compliance with this order at all times during the trial. They did not ensure compliance because they did not enforce this order like it was supposed to. Full of shit. So this was the map that they included in the order of the restricted areas and blah, blah, blah. And then the next page is the gag order that they put into the case. And then the next page after that is also the gag order. Then exhibit 2, let's go to, that's all of the things filed in the case. All right, exhibit 3 is the Register of Actions public docket printed on June 26, 2026. All right, so this is the public docket of things filed in the case. Okay, the subpoenas, da da da. So then exhibit 3 is the transcript of the judge. Oh wait, how I get past? I'm on exhibit 3, but I had already went past for y'all. Sorry. All right. Ryan, we are predominantly on YouTube. So I know that you guys are incapable of using critical thinking skills because your hate, bigotry, and white supremacy only allows you to think in a narrow-minded scope. But Ryan, we are predominantly over on YouTube. So I'm streaming in 2 places. If you do not know how social media works, there are platforms like StreamYard that allows you to stream multiple places at once. Facebook is not where my primary audience is. It is 100,000 people over on Facebook that only like a small, very small fraction gets my alerts. We're predominantly over here on YouTube where I have almost 400,000 subscribers and much more people that we're talking to. We're not just talking to 10 people. LMFAO. Okay? But again, I know that you weirdos don't know technology, I guess, only when it suits you, I guess. I don't know. But in case you didn't know, and in case your bigotry and things clouded your mind, there's advanced technology that allows us to stream multiple places. So there's that. We're not talking to 10 people. Okay. I've been live for 5 hours, and actually we have 600 over here on YouTube. So type in Neek at Night on YouTube and join the masses of us. Retard. Anyways, What retard doesn't know? All right. So moving on. All right. So this is the somebody said, I don't care if I was the only one watching. I'm here. I know that's right. But anyways, so this is the transcript of the interview that the judge did. We well, some of us, we saw the transcript. I'm not going to read through the transcript because it was, to me, a political ploy for whatever he plans to do next, in my opinion. But this is the full transcript that they referred to on actually it's 6:19 now. Thank you for Ryan must have came over, child. Thank you, Ryan, for coming on and joining us over on Facebook. I mean, over on YouTube. All right, so that's the interview that he did with WFAA that Karmelo's attorneys referenced in the motion. And then after that, it is an affidavit authenticating exhibits. So let's go to this page right here where it says, the state of Texas, Karmelo Sincere Anthony, affidavit of Russell Wilson to authenticating exhibits to defendant's motion for new trial and motion to recuse. Before me, the undersigned authority on this day personally appeared. Russell Wilson, who, being by me duly sworn, deposed and stated, my name is Russell Wilson II. I am over the age of 18 years of sound mind and in all respects competent to make this affidavit. I have personal knowledge of facts stated herein, and they are true and correct. I am the lead counsel of record for defendant Karmelo Sincere Anthony in the above styled and numbered cause. I make this affidavit to authenticate the following exhibits, each of which I have personally reviewed. The same exhibits are offered in support of both defendants' motion for new trial and brief in support and defendants' verified motion to recuse because the two motions number their exhibits differently. I identify each item by its designation in each motion. The recording motion for new trial, Exhibit 4, motion to recuse, Exhibit C, and after the televised interview of Honorable John Roach Jr. by WFAA TV Channel 8 aired on or about June 11, 2026, I obtained and personally viewed video recording of it as a broadcast and published by WFAA TV. The video file Judge Roach WFAA interview.mp4 is a true and accurate copy of the interview as broadcast and published and has not been altered, edited, or modified in any way. A copy of the recording is filed conventionally with the clerk of this court on a USB flash drive as an exhibit not amendable to electronic filing under a notice of conventional filing and is designated motion for new trial. The transcript motion for new trial, motion to recuse, Exhibit A, after obtaining the recording, I caused a written transcript of it to be prepared. The initial draft was generated with the assistance of the transcription software. I then listened to the recording in its entirety and compared the transcript against the recording word for word, correcting each discrepancy I identified and given particular attention to the passages quoted in the motion. Based on that review, the transcript is a true and accurate transcription of the words spoken in the recording. The transcript is offered as an aid to the recording and not as a substitute for it. To the extent any discrepancy exists between the two, the recording controls. The order prohibiting extrajudicial statements, the attachment to the motion for new trial, Exhibit 1, motion recused Exhibit B. The document so designed is true and accurate copy of the order prohibiting extrajudicial statements. The statement to Fox News, motion for new trial, etc. So this is just him saying that, he verified the information that's in here. So then going to Exhibit 4 is the video recording of WFAA TV interview with John Roach, and that was filed with a USB flash drive. Exhibit 5 is the written statement of John Roach to Fox News. All right. And then this is a statement where Brooke Taylor says, Judge John Roach tells me he released the evidence because I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in the courtroom was to protect the process, witnesses, and jury. Now that the trial is over, it is important to me to provide transparency. Exhibit 6. So Exhibit 6 is the thank you letter from Judge John Roach dated June 17, 2026 on the Collin County website. On this letter is where he, hold on, let me show y'all this letter. All right. So this is the thank you letter from Judge John Roach on the Collin County's Public Information Office press release. It says the seal, Judge John Roach Jr. And then after this page, it goes on to state, as the presiding judge of the 296th District Court during the recent trial of the state of Texas versus Karmelo Anthony, I want to express my sincere gratitude to the countless individuals and agencies whose professionalism, dedication, and cooperation made it possible for the court to fulfill its most fundamental responsibility, ensuring the fair, orderly, and secure administration of justice. Trials that attract significant public attention require extraordinary preparation behind the scenes. While much of the public focus is naturally directed towards what occurs inside the courtroom, the truth is that the work of administering justice depends upon the collective efforts of many people, most of whom serve quietly and without recognition. I extend my deepest appreciation to the Collin County Commissioner's Courts for its unwavering support and commitment to ensuring that the resources necessary to conduct this proceeding were available. I am equally grateful to our Budget Department, Information Technology Department, Human Resource Department, Auditor's Office, CSCD, Public Works, and Facilities Department, each of which responded to challenges with professionalism, flexibility, and a willingness to do whatever was necessary to meet the moment. I offer special thanks to the District Clerk's Office and the jury services staff for their tireless efforts in managing the enormous logistical demands associated with jury selection and trial administration. Their work ensured that citizens called to serve were treated with dignity and respect throughout the process. I also wish to recognize the extraordinary efforts of the Collin County Sheriff's Office, whose deputies and leadership devoted countless hours to maintaining the safety and security of all participants while preserving the integrity and decorum of the judicial process. So this is something that Karmelo's lawyers pointed to, where they said, listen, according to Judge Roach, they maintained the safety, which we know that's bullshit because y'all seen what I went through. But according to Judge Roach, he thanked the sheriffs in maintaining the safety and security. So therefore, some of the restrictions that he imposed were bullshit. It says, my gratitude extends to the Texas Department Public Safety and to our law enforcement partners from the McKinney, Allen, Frisco, and Plano police departments. Their collaboration, planning, and visible presence provided reassurance and protection to all who entered the courthouse. Did it? I only seen protection preserved for people who skin color look like this, and no protection to people whose skin color look like this. Like, where was our protection? When? But according to Karmelo's attorneys, they made some procedural decisions based on, you know, there was no safety concerns, but yet they had all of these things. But we know that's bullshit, but we'll continue. You had Jake Lang, like she said, clowning outside, like saying that he wished Karmelo hang from a tree, saying that he needs to be unalived. But there was no safety issues, right? That's how you know you can't take this judge word. He full of it. He full of it. But because he's full of it, Karmelo's attorneys honed in on that, because it's like, you saying that, you know, there was security, there was no safety issues. So why couldn't you have did an overflow room? Why could you not been accommodating to this or that way? Why? Because you full of shit. Let's see. It says I likewise thank the Collin County and McKinney Fire Marshal officers for their expertise and assistance in ensuring that appropriate safety protocols and emergency preparations were in place. Were they? Were they in place? Who were they in place for? I would also be remiss if I did not recognize my fellow judges to Collin County throughout these proceedings. They modified already demanding schedules, adjusted their own dockets, and accommodated the unique need of this case without hesitation. They understood that ensuring the orderly administration of justice in one courtroom often requires sacrifice and flexibility throughout the entire courthouse. Their willingness to loan members of their staff, including their invaluable bailiffs, provided critical support and exemplified the collegiality, whatever, professionalism and spirit of service that define our judiciary. I am deeply grateful for their friendship, cooperation, and steadfast commitment to our shared mission. And what he's talking about is how the entire court was shut down. So all of the judges who also had dockets, they cut their dockets off so that this trial can run. And so there was no other court going on except for this trial. So he's thanking the judges for freezing their docket and being able to lend their bailiffs to him, basically. All right. It says, most personally, I want to recognize the remarkable staff on the 296th District Court. Their long hours, attention to detail, patience under pressure, and steadfast commitment to the public service were indispensable. They represented this court and this county with excellence. Did they? Finally, to everyone else who played a role, whether through planning meetings, operational support, communication, security, preparation, technical assistance, administrative coordination, or simply a willingness to answer the call when needed, please know that your contributions mattered. The public often sees only the final product. I have the privilege of witnessing the countless acts of professionalism and teamwork that made that final product possible. The administration of justice is one of our community's most solemn responsibilities. This trial demonstrated what can be accomplished when dedicated public servants from different offices and agencies work together toward a common purpose. Regardless of the title or assignment, each of you contributed to ensuring that the process was conducted fairly, safely, with the dignity of uh, with the dignity our citizens deserve. It has been one of the great honors of my judicial career to serve alongside individuals of such character and professionalism. On behalf of the 296th District, thank you for your service, your sacrifice, your unwavering commitment to the people of Collin County. With sincere appreciation, Judge John Roach. All right. Exhibit 7 is an email of Steve Stoller, the court appointed PIO, to Thelma Anderson on June 5th, 2026. All right, so this is Exhibit 7, and my exhibits are after this. You said Neek about 6 hours in doing the Lord's work. Yes. Hopefully it's appreciated. I don't see it in the Cash App form. Y'all ain't appreciating it that much now. I mean, come on. Like, we've been sitting here for 6 hours. Like, there should be more support, more money on the floor, you know? But let's continue, because all right. All right, so let's read Thelma Anderson's email. And this was from Steve Stoller to her. It says, "Hi, Thelma. My name is Steve Stoller. The 296th District Court appointed yours truly as the public information officer for the Anthony trial. I wanted to take the time to explain the process we followed for media coverage. To set the stage, there are only about 70 seats in the courtroom. Obviously, with so much interest in the trial, both locally and nationally, it is literally impossible to accommodate everyone. The prosecution gets 15 seats for family members. The defense gets 15 seats for their family members. The judge allocated only 9 seats for media, including one for the courtroom sketch artist, add court staff, and that leaves about 24 or so seats for the general public. As much as we dislike turning people down, we had no choice. The Collin County Public Information Officer established an application process more than a month before the trial started. Then he left the county. I came to pick up where he left off. The deadline for applications was May 20th. We received requests from all over the country, from major media outlets, local media, and a long list of social media influencers. We chose 8 media outlets for credentials on May 21st. We included the local television station and newspapers who cover Collin County courts on a regular basis. We felt that was the fairest route to take. We invited media members who were not approved for credentials to gain access with the general public on a first come, first served basis. We encouraged them to get in line early. Many of them, including some very well-known names in the media world, like the New York Post, Washington Post, and NBC News, waited in line with the general public and gained access to the trial. There is no overflow room. And then on the next, he replies to her and he says, I'm sorry, I can't be more positive about securing a media credential. I wanted to explain how we got where we are. I hope you understand. Warm regards, Steve. All right. So then to Exhibit 8. Exhibit 8 is the exhibits that I gave. All right. So the next exhibits are my email exchanges with the court public information officer. And I feel like I'm starting to look. I'm like, am I starting to look greasy? What's it giving? Is it giving greasy? I don't know. Hold on. Sorry. All right, we up to my part now. Five hours. 5 hours in. Now we get to my evidence that's in here. All right. So, exhibit 8 is my correspondence with the PIO. You said that's better, right? I was starting to look greasy, right? Child. Hold on, y'all. My bad. I know y'all like, girl, get to it. But I feel like, I'm gonna separate these videos, so child, I don't want to look so greasy. Hold on, y'all. I know y'all like, girl, be for real. Be so for real. I know. Okay. Anyways, all right. All right, so let's go. So, all right, so these are the exhibits in the motion that I handed over to his defense, and that is in his motion for new trial. And these are all of the things that I handed over. So it says credentialing and access emails redacted, arranged chronologically. And then it says sub exhibits 8A through 8I. And so then it gives a list of all of the exhibits that I gave to him or to the defense. And then it says Collin County's media portal captured May 22nd, 2026, April 29th, and May 8th, credentialing correspondence with the previous PIO. And then May 20th, media access allocation, Steve Stoller appointed PIO. May 20th, independent journalist inquiry. May 25th, overflow room eliminated. May 25th through 26th, public note taking barred. May 26, 2026, Sheriff's Office declines to state access / security protocols. May 26 through 28, 2026, note ban confirmed, then reversed. Note taken is only allowed for approved media, followed 2 days later by you will be allowed to take notes with pen and paper during the trial. May 29th, my email where it showed the overflow room and live feed announced for public. The PIO announced that the general public would watch the live feed of the jury selection process from the ceremonial courtroom. So let's get into my exhibits that are in this motion. Exhibit 8A, and this is the media intake form. So when I applied to be a media person, a person that had the media credentials, this is the intake form that I was given by the public information officer. I was given this. I know Gerald from the MCB was given this link, and also Queen Sheba. Also, we all submitted our media credential through this intake form. So on this, it's a submission that says, please complete this form to request media access credentials or logistical support for trial coverage. Submission does not guarantee approval. All requests are subject to court rules and credentialing criteria. So we were to give our outlet's name, our contact name, our email address, our phone number, the media type. Then they wanted us to show which type of access do we want in the trial. What are we asking for? Are we asking for credentialed courtroom access? Are we asking for overflow room access? Are we asking for live truck parking? Are we asking for still photography? Are we asking to be able to do interviews, or is this a general inquiry? And then we are to put the date that we requested, and then we were to put the special requirements / notes. So under the special requirements / notes, I listed all of my credentials, all of the prior trials I covered, all of my my resume, as you will. I put that all under the special requirements / notes. I said in mine, I believe I said, if I can't get access to the main courtroom, I want to be able to have access to the overflow room. All right. So this is the intake form that I submitted to Collin County Courthouse. Exhibit 8B. Credentialing correspondence with Derek Jackson. The credentialing process was changed midstream. Applicants were told prior submissions had not transferred. So this is my email to this is my email from Derek to me. So or wait, no, this is my email. Yes, this is the email that Derek sent. Okay, my bad. All right, so this is the email that Derek sent to me. Sorry. All right, dear media representative, you are receiving this email because you previously submitted a request for media credentials for the upcoming State v. Karmelo Anthony trial scheduled to begin Monday, June 1st. We are writing to inform you of an important update to our credentialing process. While we previously accepted submissions through a Google form, we have since implemented a new internal system to better manage and process media credentials. Please note, this message is not a confirmation of credential approval. Your request is still under review. However, in order to move forward in the consideration process, we require all applicants, including those who have already submitted through the original Google form, has not transferred to this new system. As a result, failure to complete the updated form may result in your application not being considered. Due to the volume of requests and the upcoming trial date, we ask that you complete this form as soon as possible to ensure timely review. So basically what happened was they gave us one link and told us to submit our credentials through this other form. So we submitted our credentials through one form, and then later they were like, oh, oops, y'all already submitted through this form, but we decided to have y'all submit through this form instead. And so then it was telling us that our previous submission didn't count and we had to redo our submission. So that's what this is saying. So we had to reapply again. Okay, so we applied and then we had to reapply. All right. So then on May 8th, 2026, I sent out an email to the PIO. And this was after I had already been waiting for weeks to see, like, am I approved? Am I not approved? I believe my first email to them started in April. And then by May 8th, I'm like, I'm trying to finalize my travel. Like, that's what I was trying to figure out. What's the deal? Like, am I approved, not approved? So I sent an email to the previous PIO and I said, I'm reaching out for a quick status update on my media application for the Karmelo Anthony trial, June 1st. As I finalize my travel and lodging for Neek at Night, I also wanted to ask for the court's latest estimate on the trial duration. This will help me ensure my logistics are fully secured for the entire proceeding. Thank you for your assistance. Best regard, Neek at Night. So, he replied back to me, and I just so happened to email him on a day that they allowed legacy media into the court. So I had previously submitted, and I had submitted twice. Yet when they opened up the courtroom to allow legacy media to come in, they didn't offer that to everybody that submitted. They only offered it to legacy media. So I just so happened to ask for a status update on the same day that they opened up the courtroom to allow legacy media in. So he replies to me and says, the courtroom was made available today to local television affiliates solely for the purpose of capturing footage of the empty courtroom for potential use during the upcoming trial. The courtroom is empty during this designated window, and all access was coordinated directly through the judge's bailiff. To avoid any confusion, this was not an open access opportunity, nor should participation today be interpreted as indication that any media outlet has been selected or approved for trial credentials. No credentialing decisions have been made at this time. The deadline to submit credential requests remains Wednesday, May 20th. Final credentialing decisions will be communicated on Tuesday, May 26th. So they said, hey, Neek, we allowed all of the legacy media to come in on a special thing where they can come view the courtroom, take pictures and video of the courtroom. We didn't give you that advantage. We only gave that advantage to legacy media. But don't worry, nobody has been chosen yet. We still got the applications open. You still have a chance to be one of the media people. That's what this says. Then Exhibit 8C, media access allocation. Steve Stoller, the court-appointed PIO, he says that the judge allocated access to 9 members of the media. Priority to legacy outlets, non-approved media were directed to the general public line, first come, first serve. All right. So then this is the email that I was sent. And it says, and this was everybody who I guess submitted that didn't get access. It says, dear friends, the 296th District Court in Collin County has appointed yours truly as the court-appointed public information officer for the upcoming trial. Please read the attached order regulating trial proceedings, media access, security, and courtroom decorum. It clearly details the court rules / protocols for the trial. As you know, courtroom space is extremely limited. As a result, the judge has allocated access to 9 members of the media. That said, many of you who applied for access were not approved. We gave priority to legacy media outlets who cover Collin County and our courts on a regular basis. The following organizations are approved for trial coverage. Those of you who were not approved for media access do not have the ability to watch the trial as a member of the general public. Seating for the general public is on a first come, first served basis. Doors will open at 8:50 a.m. for the public. If a media outlet attends as a member of the general public, then the general public rules apply. See attached order. So as you can see, the Associated Press, KDFW-TV, KXAS-TV, WFAA-TV, KTV-TV, Dallas Morning News, the Community Impact, and the Daily Mail, plus the sketch artists were the pool. Are y'all still with me? Are y'all still there? Are y'all still listening? Are y'all there? I mean, y'all not saying nothing in the chat. Like, it's still 600 of y'all. Or are y'all not able to? Let me lift up some of the restrictions. Maybe y'all not allowed to talk. I want to see more of y'all talking. It's 600 of y'all, so if y'all act up when I lift up, I'm a lift it up for a second. If y'all start cutting up too bad, we're gonna restrict it again. But they said I'm here. Okay, all right, we listening. All right, so this is the email that he sent. All right, so Exhibit 8D. It says, independent journalist inquiry, May 20th, 2026. The credentialing call was presented publicly as a general call for credentials, then limited to established legacy outlets. So I was upset that they played in our face, basically, because they presented this like that it was going to be fair, that they were going to give the 9 seats fairly, and that we all had a chance. They allowed legacy media to go into the courtroom prior to the trial, did not tell us about it, and then came and slapped us in the face and said, oops, even though we said we didn't pick legacy media and we allowed legacy media to come in the court, we're going to give legacy media the seats. And so I replied, because I felt like, whoa, hold on. Why y'all play in our face then and act like we had a chance at credentials and we didn't? So I then sent an email and I said, while I respect the court's desire to work with established media partners, I have to be candid. The application process was presented to the public as a general call for credentials. It is difficult to understand why independent journalists were invited to apply if the selection criteria were strictly limited to legacy outlets with pre-existing history at the courthouse. Many of us spent time preparing our credentials under the impression that the selection would be based on professional merit rather than a pre-existing footprint in this specific district. As I still intend to cover these proceedings thoroughly, I want to ensure that I am fully prepared to operate as a working professional within the public gallery. To that end, could you please clarify a few logistical points? Number 1, electronic devices. The court's order stipulates that electronic devices may be permitted for note-taking purposes, subject to approval by the court. What is the formal procedure for a working journalist in the public gallery to secure this approval so that I may use a tablet or laptop for silent note-taking? Number 2, queuing protocols. Having covered numerous high-profile trials, I know that unstructured first-come, first-served public queues for high-interest cases frequently devolve into disorder. When there is no objective system to verify arrival order, disputes are common. Given the heightened racial tension surrounding this specific case, I am concerned that an unmonitored queue could create a flashpoint for confrontations that compromise the courthouse security. To ensure we remain compliant with the rules prohibiting hallway congregation, what specific protocol will the court or sheriff's office employ to manage this line? Is there a designated monitored area for the queue to prevent the chaos often associated with unstructured entry? Number 3, I asked about information access. As an independent journalist, I am committed to fair and accurate coverage. Is there a process or distribution list where those of us not granted media status can still receive press releases, schedule changes, or logistical updates throughout the trial? My goal is to be well be a well-prepared observer who provides accurate reporting while respecting the decorum of the court. I appreciate your time and your guidance on how to navigate these logistics. Best regard. And then I had my name and number, and it was redacted. So they replied back to me, and it says the 296th District Court in Collin County has appointed yours truly as court-appointed public information officer for the upcoming Anthony trial. Please read the attached order regulating trial proceedings, media access, security, and courtroom decorum. It clearly details the court's rules/protocol for the trial. As you know, courtroom space is extremely limited. As a result, the judge has allocated access to 9 members of the media. That said, many of you who applied for access were not approved. We gave priority to legacy media outlets who cover Collin County and our courts on a regular basis. The following courtroom space extremely limited. As a result, the judge has allocated these media, blah, blah, blah. So I replied back and I said, thank you for clarification regarding selection criteria for the Anthony trial. While I respect the court's desire to work with established media partners. Wait, did I read this already? Did I read that? Let's go to 8E. I think I already read that. Or maybe, I don't know. All right. So Overflow eliminated. So this is my next exhibit that they offered. And are y'all still here? Let me see. Somebody sent in a super chat. Thank you for the super chat. Somebody said this was fixed from top to bottom. This was their way to control the narrative. I agree. They had the whole year to plan and execute. Disgusting. Exactly. I agree. All right. So my next email. Right. I thought I read that already. My bad. Child, it's getting late. Okay. So I replied back and I said, hold on, let me make sure y'all see what I see. Child, it's getting late. Hold on. All right. So I said, hi, Steve. I'm writing to request a direct, individualized response. Not, because basically he was giving me a response that was like a blast to everybody. And he did not answer the question that I gave. So I'm like, no, I need you to give me a direct response. Stop giving me these generalized blasts. Like, I need you to answer my questions. So I said, hi, Steve. I'm writing to request a direct, individualized response to 3 critical logistical items regarding the state versus Anthony trial proceedings, which I am covering on the ground for Nick at Night. Because your recent broadcast updates were sent to a general distribution list, they left several operational questions unanswered for independent journalists operating from the public gallery. And I asked my questions again. Number 1, electronic device approval. Per Section 2, Page 2 of the court's amended order, electronic devices are permitted for note-taking purposes subject to approval by the court. As a working journalist sitting in the public gallery, what is the exact formal mechanism to secure this specific judicial approval prior to Monday morning so I can utilize my laptop or tablet silently? Number 2, overflow room access. Line 9, because now I'm being more specific because I already asked you these questions and you didn't answer them. So now I'm asking you again and I'm pointing you to the line where, like, what are we doing? So I said, number 2, Overflow room access. Line 19 of the county's official media request intake portal explicitly allows applicants to request overflow room access. Is the court actively utilizing an overflow room with a live video/audio feed for this trial? If so, what is the procedure for independent media access, for us to access it? Number 3, safety and line management. Given the high-profile nature and heightened tension surrounding this case, an unmonitored first-come, first-served public queue presents a distinct security vulnerability that specific protocols are the court and Collin County. What specific protocols are the court and Collin County's Sheriff Office implementing to monitor the morning line, verify arrival order, and prevent disorder outside the main entrance? As my travel and logistical footprints are fully finalized, because at this point, I done finalized my travel. I need an answer. I need to know that I'm going to be safe. I need to know that there's protocols in place to protect us from these racist bigots. I want to know how I can have certain things to me. So I need you to answer this directly, because now I have my lodging finalized and I need your immediate attention to this. So I said, as my travel and logistical footprints are fully finalized, I appreciate your immediate direct answers to these items so I can ensure absolute compliance with the court's decorum. And then I signed best regards, and I put my name, journalist and host for Nick at Night. So then Steve Stoller replied to me and he says, Nick, I apologize for the delayed response to your specific questions. I will get them answered as soon as possible. There will be no overflow room during the trial. Thank you for your patience and understanding. Warm regards, Steve. So this was him telling me on May 25th, before the trial even started, that they were not going to have an overflow room. All right. And it took him, let me see, when did I first write him and ask those questions? So I first asked these questions to Derek on May 20th, and then he responded to me with an answer on the 25th. So a whole week had went by. All right. So then Exhibit 8 through F. I wanted to know, how can I take notes like everybody else that got access? And so Exhibit 8 through F, or Exhibit 8F, my bad, not 8 through F. Exhibit 8F, public note-taking barred. Okay, they barred me from being able to use a pen and a paper. Like, what? I can't use a pen. I can't use a paper. Now, this is when I really got nervous, because I'm like, damn, I done paid for 2 weeks of a hotel. I done rented a car for 2 weeks. I've, arranged my uncle to be there with me. And now, a few days before trial, you're now telling me that I can't even use a pen and a paper. Yo, I was going through so many emotions leading up to covering this trial. Everything felt corrupt. Everything felt fixed. And I felt like God was like, no, you need to make them answer these questions. You need to make sure that they respond to you on the record. You need to make sure that you are as detailed as possible, and you need to make sure that you document everything. And you need to make sure that you ask them about safety concerns and how they're going to manage it and how they're going to keep you safe. And I documented everything. And we will be using this documentation in other things. Now, going to the next one. All right. So he told me that my question number 3, which was whether or not there was going to be a safe line, should be addressed to the sheriffs. So he wrote me back and he said, Neek, question number 3 should be directed to the Collins County Sheriff Office. They're responsible for security at the courthouse. So, I wrote back to him and I said, "Hi, Steve. Thank you for confirming that there will be no overflow room utilized for this trial. I look forward to your upcoming response regarding the formal mechanism for securing the court's note-taking device approval per Section 2. Page 2 of the order. Sergeant Pond, CC'd per PIO, Stoller's directive below. I am directing question number 3 to the Collin County Sheriff's Office." So I CC'd the sheriffs in this email. And I said, now this part is directed to you, Sheriff, as he told me to direct to you. I am directing question number 3 to the Collin County Sheriff's Office. Given the high-profile nature and heightened public tension surrounding the State v. Anthony trial, what specific protocol is the Sheriff's Office implementing to monitor the morning public queue outside the main entrance, verify arrival order starting at 6 a.m. when the curfew is lifted, and prevent potential disorder before the doors open at 8:50 a.m.? Since there is no overflow room, who comes first and honoring first come, first serve is crucial. How will this be handled to verify the safety of those of us standing outside in line for hours? As an independent journalist, as an independent journalist managing on-the-ground coverage, I appreciate your insight into these safety measures so I can coordinate my team's arrival safety. Best regards, journalist and host for Neek at Night. All right. So then Steve Stoller replied and he said, "Hi, Neek. As per Judge Roach, those who do not have media approval and gain access with the general public do not have approval to take notes." I read that and I said, wait. We don't have approval to take notes. Excuse me? Huh? What do you mean? You're just talking about like when I asked for a laptop, right? You're just talking about that, right? You're not talking about a pen and a paper. What? So I'm reading this and I'm like, he can't be talking about a pen and a paper. We can't take notes. What? Like what trial don't let you take notes on a pen and a paper? I understand electronic device. Okay, cool. That was a long shot, but I was going to shoot my shot. But what do you mean by that? Exactly. Huh? So the next exhibit that I gave to Karmelo Anthony's appeal attorney was the sheriff office declining to state their access in their security protocols. So the sheriffs replied to me and they said the following. This was from the sheriffs. They told me, they said, The Collin County Sheriff's Office does not discuss security protocols, processes, or procedures. Thank you. And so I read that and I'm like, well, that's reassuring. So then I replied to Steve, because now I need to know, what do you mean by only approved media can take notes? So I wanted to clarify, like, what? So I said, hi, Steve. Understood on electronic devices and laptops. To clarify on the note-taking itself, does Judge Roach's directive prohibit traditional pen and paper note-taking by members of the public gallery as well? Or are physical notebooks and pens permitted inside? I want to ensure absolute compliance with the physical decorum of the room on Monday morning. Best regards, journalist and host Nika Knight. Exhibit 8H. Note ban confirmed, then reversed. All right. So then he wrote me back and he said, it's all the way at the top. He wrote me back. And so I wrote on May 26th. So this, when we were going back and forth, that was May 26th. So they have my May 26th correspondence and then Thursday, May 28th. So he wrote me back because I said, understood on the electronic devices and laptops. To clarify, on the note-taking itself, does Judge Roach's directive prohibit traditional pen and paper, etc.? He wrote me back and said, note-taking is only for approved media. So, they don't have it in here, but I there was another email where I contacted the court itself. So when he told me no, that they're not going to, like it was only for approved media, I wrote the court directly. So I wrote the court directly and I said, hey, are y'all not going to allow pen and paper? And Steve intercepted my email from the court and CC'd the court and me together and was like, I told her yesterday that only approved media could take notes. And I'm like, you told me today. You literally told me an hour ago, but I'm confused. You keep only saying only approved media could take notes. Like, I need you to tell me directly no to the pen and paper. So I wrote the court directly and he intercepted my email. And when he intercepted my email, he responded and was like, I already told her yesterday only approved media can take notes. So then I wrote him back and I was like, that was today, sir, and got you. So then, 2 days later on May 28th, he writes me out of the blue and he says, hi, Neek, I have an update for you. You will be allowed to take notes with pen and paper during the trial. Warm regards. This is now a couple of days before, like the trial started on June 1st. This was on May 28th. Oh, now we decided you could use a pen and paper. Like, what? So I responded and I said, hi, Steve. Thank you for the update and the clarification on the note-taking protocols. I appreciate you looking into that for me. See you at the courthouse. Best regards. And then he wrote me back and said, looking forward to meeting you, Neek. All right. And then Exhibit 8I. This is Overflow Room live feed announced for the public. And it says the PIO announced that the general public would watch a live feed of the jury selection process from the ceremonial courtroom. Television monitors, audio provided, pen and paper notes permitted, and that once testimony began, the proceedings would continue following the same procedures. So then the next email is the email that the PIO sent to me. And it says, dear friends, for those of you who did not receive approved media access to the Anthony trial, you will have an opportunity to assess the proceedings with the general public on a first come, first served basis. Jury selection will begin at 9 Monday morning. The media and general public will have an opportunity to watch a live feed on the jury selection process from the ceremonial courtroom located on the first floor of the courthouse. Television monitors will be set up there. There is a fixed camera in the jury pool room. You won't see much, but you will be able to hear the proceedings with the audio that's provided. As you know, there's no recording available and electronic devices are strictly prohibited. You will be allowed to bring in pen and paper to take notes. Since general public access is first come, first serve, and space is limited, try to arrive as early as possible. The general public will enter the courtroom at 8:50 a.m. Once testimony begins Thursday, the proceedings will take place in the 296th District Courtroom on the second floor of the courthouse, following the same procedures. Thank you for your cooperation. Warm regards, Steve Stoller. And he signed it that he was the court appointed a PIO. So that was all of the exhibits that I gave over to the Karmelo Anthony defense that is in his motion for new trial. And now we're going to go to Exhibit 9. Exhibit 9 is Sergeant Davis conversation regarding admission of the media and the public cell phone video transcript authenticating affidavit. This is a video exhibit. So hold on. Let me see. Before we get into that, let me give you guys the link again. And y'all tell me what y'all think so far. Somebody said Neek emails should show bad business was in play. Correct. So a lot of people, when I got emotional, it was so much that was going on. Like, y'all do not understand. Like, it was the stuff that happened before the trial. It was the BS that was happening during the trial. It was the intimidation. It was the guns. It was the white supremacists. It was the racists. It was all of these things that were being allowed to happen. It was so much BS happening. And it was definitely, in my opinion, corrupt, unjust, and unfair. There was no good faith basis that they had, in my opinion. Again, that's not a fact. That's just my opinion, that they did not have good faith basis for what they were doing. They were trying to railroad him, in my opinion. Everything that they were doing was to try to get a rigged outcome, in my opinion. But if there's anybody who wants to come up and speak about what we heard so far, click the link and let me know your thoughts. I kind of want to take a break reading. And if some of y'all can come up and speak real quick. I think you did an excellent job in documenting and dealing with all of the BS. Thank you so much. Queen, it says that you're... Oh, here you go. Hello? Queen?
Yes.
Hey, what's your thoughts so far?
Well, I was just listening to you. Now, is this concerning the pre-trial that's supposed to be coming up?
This is the motion that Karmelo Anthony's lawyers filed for to recuse the judge, and a motion for new trial.
For a new trial. Okay. So so what you're saying is that the paperwork that you're reading off and stuff, you have been accepted, right?
The trial is over.
Okay, but didn't they aren't they gonna do an appeal?
Well, this is the motion for new trial that the appellate attorneys have submitted.
Oh, okay, so they've just submitted right now.
Yeah, it's just submitted right now.
Oh, okay, because I was trying to get an understanding of that part right there. That's what I was trying to figure out. So I thought I would chime in to see if I had it correct or not. You know.
Yeah, this is just a motion. It has to be ruled on, and they have, I think it said 72 days until August to make a ruling.
Oh, okay, okay. So on the ruling, is that when they make their decision, who they're gonna let?
If they're
Like
gonna grant a motion for new trial or deny it.
yes,
Yeah, so that's the phase we're on right now.
okay. And just like on the first one, when you were like accepted, you will be notified if you're accepted for this one, or will you be going back if if they
I
do?
wasn't accepted as media for this one. I was just in the public.
Oh, just in the public. Okay,
Yeah.
okay. Well, that's just what I was trying to find out, and I hope that he does get the appeal. My only concern that I have about Carmelo, and I'm sure you would probably know, because I've been hearing people say that, um, before he went to trial the first time, that he had been offered a plea deal, or am I hearing information wrong?
I have not heard anything about a plea deal. There's nothing in the proceedings that mention a plea deal. And there's nothing that
Okay.
came up in court that mentioned a plea deal.
Okay, yeah, that's what I thought, because usually, in most cases like this, they offer a plea deal. So I was kind of wondering about that too, because I remember, you've been there, pretty much, the whole time. And, I don't remember you mentioning it. So, that's what I'm asking now. So I'm like,
Yeah,
they
there was
didn't give
nothing
him
that came up in trial about a plea deal.
yeah, that part is really strange to me. You know what I'm saying? 'Cause I see
Well,
all these other different
they don't
cases.
always offer a plea deal.
Really? I mean,
No,
I
they
know they don't, but in this situation right here, you think they would, 'Cause I see so many different cases, where I mean, you see people that's getting shot 2 or 3 times, and these people get plea deals. I'm like, how in the hell they get a plea deal, and end up getting like 12 years, for killing 2 people, you know? And
yeah.
then you have this individual here, but the other question, and I'll let you finish doing what you're, talking. But the other question that I was wondering about is that it kind of slipped my memory now. But anyway, the other question I had, it was said that okay, he had a bond, I guess, in 2025, and
Hmm.
that he was bonded out.
Yes, he bonded. He was out on bond. Hmm.
Okay, yeah, I heard he was bonded out. Okay, and I was thinking, okay, he was bonded out for an entire year, if
Yes.
I'm getting this correct. Okay, and just being honest with you, Neek, if it was my son, and I'm just being honest, if it was my son, and my life is hanging on the line like this, and I'm sure, maybe Carmelo's family know how prejudiced they would be or whatever. I don't know about that part. But if it was my son, I would have coached him. I'd have coached him like, you're gonna get on the stand. Now I don't know if he had that opportunity or if it's up to the lawyer. Is it up to the lawyer to say whether or not he can get on the stand?
It's up to the defendant to decide whether he gets on the stand or not. based on the advice from his lawyer.
Okay. But even if his lawyer says no, can he still say no? I want to get up there.
Yes.
Yeah, that's what I thought because I'm like, if that was my son, I'd have coached him. And I'd have been like, hey, first of all, this guy is what 2 or 3 feet taller than me, and and this is just my opinion. I feel like that Carmelo was trying to scare the guy. Okay, by
Mhm.
even making a statement of, if you touch me, see what'll happen. I think it was a scare tactic, you know what I'm saying? Because my mama, she used to always tell me this, Rebecca, she said, a scary person will hurt you. And I'm
Yeah.
like, well, why would you say that? And she said, because they scared. She said they will actually kill you because they scared. They fighting for their life, you know. And
Yeah.
so I think that that's what he was doing. And if the guy was much taller than him, I don't think he meant to even stab the dude in his heart. I think he meant to go for his side or something like that. You know what I'm saying? I don't think he meant to go that route. But if I was his parents or whoever, I would have coached him. And I'd be like, hey, you're gonna get up on that damn whatever they call it. You're gonna
Yeah,
get up
but
on that
most
stand.
people are gonna go with what a lawyer says. Your life on the line, you gonna um think that the professionals that you've paid are acting in your best interest. So if they tell you it's not a good idea, most people are gonna go with what the lawyer advises. So um
Yeah.
but I'm gonna thank you, Queen Becca. I'm gonna go back to reading.
Yes, okay. I was just wanting to find out where we're going with it, because I was I'm like, wait a minute, are we already, going into an appeal or not? So that's just what I wanted to find out. Thanks, Nick, for
All
explaining.
right.
All right.
Thank you. All right. So this exhibit 9 is it says the cell phone video is filed on a USB with notice of the filing, the transcript, and authenticating affidavit of Tamitra Carter follows this sheet. So this is Sergeant Davis' conversation regarding admission of the media and the public. All right. Sergeant Davis. Hey, I'm doing all right. Sergeant Davis with Collin County Sheriff's Office. Hey, is there a reason you being here right here? Tamitra Carter. I was waiting for cause I know y'all going. So I didn't know how y'all was gonna do it today. So I wanna just follow however y'all gonna do it to get in the courthouse. Sergeant Davis. Okay, you would have to follow the same thing. What we tell everybody else. You can park anywhere else, but you cannot sit. This is a construction in the yeah. Tamitra. Okay. Sergeant Davis, because so just go down there to that church. How was it says Sergeant Davis. It's sir. You can go to the church. You can go. I mean, it's up to the church on to call on Tamitra. So are y'all letting media in like y'all did yesterday? Sergeant Davis, media is allowed at 4:30 only with their proof of media license. Tamitra, yes, because yesterday they had people that wasn't the media in there. Yes, and then Sergeant Davis, we're trying to fix that. Tamitra, thank you so much. Sergeant Davis, but it's really hard to. Tamitra, determine it. They said I was here at 4. I was here at 4:30, and I'm the first person in line. And I go in, and it's already 23. Yeah, we're trying to 27 people in the public line. So I'm like, oh my God, Sergeant Davis, I understand that. I understand. And it is really hard for us to determine who's what. And people print out whatever and make themselves like their media. And it's hard for us to determine that. Why? why, Sergeant, why couldn't the judge give the media proper credentials so that y'all can easily identify who media and who not? Anytime that I cover a trial, so this is a conversation between a lady named Demetria and a sergeant asking about the line access and things like that. To the person that said, I'm bored, click off. Like, duh. So basically, this sounds like a video of somebody talking to a sergeant and asking them how they're going to operate the line, how they're going to operate, who's going to get access, and basically saying media is sneaking on the lot at 4:30. So this is the conversation that they added the transcript between these two. So it's kind of broken up and everything like that. So it says, determine, I was here at 4. I was here at, I wonder if this is a pretty girl, because this sounds like, because she was coming, I think, at 4. It says, I was here at 4. I was here at 4:30, and I'm the first person in line. I go in, and it's already 23. Yeah, we're trying to 27 people in the public line. Yeah, so I'm like, oh my God. Sergeant Davis, I understand, and it's really hard for us to determine who's what. And people print out whatever and make themselves like their media, and it's hard for us to determine that. She says, right. The sergeant, but I would recommend either the church there's also a Life Path there. And Demetria says, and then we come up 5:36. Sergeant Davis, at 6 is when they allow civilians to come in, non-media people. Okay. However, like I said, it's really hard. You can circle back and kind of keep driving up and down to see what's going on. But we are only allowing media at 4:30 because they come on at 5. Yeah. Demetria, sergeant, to do their live. Whatever, because I noticed like 27 people in the public line. Yes, and I was the first one in the gate, and I'm like, so how they, right, so they must have came in as media. Sergeant Davis, I'm assuming so. I don't know. I wasn't here yesterday. Demetria, but today, are y'all checking badges? Sergeant Davis, they should be. I wonder if this is pretty girl, but this is a conversation with the sheriffs showing what I was telling y'all. They were allowing media to access the lot at 4:30. They were holding all of us back at 6. The media, they were sneaking first in line. So that was putting us at a disadvantage because they're telling us, oh, the people that's on the lot at 4:30, those are part of the 9 credentialed media that already have a badge. And so many of us was like, that's bullshit, because these people accessing the lot that you guys are giving preferential treatment are getting in the public line. So I think that's kind of what she is explaining to them. That's what it looks like. So it says, I don't know. That's what we were told. We're supposed to check for media, and it's hard for us to even check badges. Sometimes they'll show us just cameras, and that's what we have to go with. I don't know. It's hard to determine. Demetria, because if that's the case, I'm an independent journalist, because I could report on my channel and stuff. Sergeant Davis, yeah, that's including the and then she says independent journalism, right? Like your TikTok and all that. No, that's not what we're allowing in. We're doing just media. Like, yeah, Demetria, because I've seen a couple of them. Not saying that you're not important. That's not a couple of them in there that are independent, and they got in first. Sergeant Davis, yeah, I'm not sure how that's all happening, but I know for sure we're trying to keep people out until 6 a.m. Even media, we were trying to do that, but some of them have gotten approval. Tamitra, okay. I don't know how. I don't know what from what. I know 4:30 is only media. 6 a.m. is what do you call it? The rest of the civilians, but that's so. And then Tamitra says, I'ma be me at that white car just drove off. We're gonna be the first ones. And it I'm hoping that there don't be a line, because yesterday I was like, how did they even get in? Yeah, so I'm guessing. Sergeant Davis, we're trying to hold off people leaving, lining up there. She said, okay. So, sorry if y'all can't understand, but since I was there, I kind of understand what's happening in this conversation. She's telling them, y'all letting people sneak on the lot and y'all ain't doing nothing about it. That's basically what she's telling this sergeant. And the sergeant is like, well, I don't know how they sneaking, but you got to stay over there. That's basically what's happening. It says that's our biggest issue, okay? Because they were lining up before 6 a.m. And then Demetria says, what happened? Sergeant Davis, right. So we're gonna keep them off. Okay, the pathway. And everybody's gonna have to line up. At six, and you guys get there. Demetria said, see, that's the point. That's what we're shooting for. Like, everybody remain in their car until 6, and we can run up there and see who gets there first. But hopefully nobody gets trampled over, right? So you see, this is what I'm talking about. We had to wait at the end of the line, outside of the court, and it was based on who ran to the front first. Not who came first, not first come first serve. It was who ran to the thing first. So Demetria said, see, that's the point that we're shooting for. Like, everybody remain in their car until 6, and we can run up there and see who gets there first. But hopefully nobody gets trampled over. And then it says, yeah, no pushing, no shoving. Sergeant Davis, right, exactly, Demetria, we're not going to do that and then Sergeant Davis, let's hope not, right. But yes, I would recommend, hey, going up, yeah, Demetria, that window don't go down. Sergeant Davis, you're fine. Record anywhere else if you need to drive up and down periodically, by all means. I'll stay back there. Sergeant Davis, yes. Demetria, either way. All right, that's fine. Yeah, I'll stay there at the and then it's Sergeant Davis Church, but there's plenty of places for you to park. Just hang out there, and then yes, ma'am. Sergeant Davis, you can even drive by and make a look and be like, okay, well, they're letting cars in, whatever it is. I don't. Yes, ma'am. 6 a.m. is when it's supposed to be, but I don't. Again, I'm just following the rules as well. You see this bullshit? This is what we was dealing with. She telling her the lot is closed. She telling her, drive over there, but keep on looking and keep on driving over here to check if we start letting people in. If we start letting people in, then you come in, but it's supposed to be till 6. But in the meantime, stay over there. That's basically what she's telling her. This is the bullshit that we was dealing with. And I think this is Pretty Girl. I'm not sure if it's Pretty Girl, but I think because she did TikTok. I'm not a TikToker. But anyways, so Sergeant, she said, ma'am, okay, that's, and then fine, and then thank you so much. I will, you're welcome. Demetria, okay, so they got me lining up doing the same thing that they claimed that we did yesterday, the same thing. So I'm hopping I'm hoping I get in. It was a white Jeep that was parked in Kylie Jenner parking lot like me, but y'all heard what she said. So now today it's supposed to be no lining up till 6. So I'm going to go up there around 5:30 and I'm going to ask her, so where we lining up? Are we lining up in the courthouse or at that little walkway like we did yesterday? If it's the walkway, I'm shooting there fast as I can. I'm going to try to run real fast. I'm sure I can run faster than some people, I'm sure. This is the chaos that they were creating. Instead of her coming and they giving her like a ticket or something for her coming first and then giving people the ticket as they arrived, they made it to where you got to wait and then you got to run to the entrance to get in. Somebody said, so basically they're trying to pick and choose who they will let. Right. Yep. You got it. You got it. You got it. And then it says, I'm hopeful. So I'm going to try to be one of the first ones in the parking lot so I can get the closest parking. So yeah, we'll see. Oops. Sorry, y'all. This was the last page. All right. This was what I was just reading. And then this one, if y'all didn't see it. All right. All right. So affidavit of Tamitra Carter authenticating video recording and transcript of conversation with Sergeant Davis. Before me, this is them authenticating her in the transcript of that. All right. Affidavit of trial counsel Mike Howard. All right. So this is exhibit 10. So this is what Mike Howard said happened in the Karmelo Anthony trial. So let me get comfortable, child, and read this because I have not read this yet. I'm reading all of this with y'all for the first time. Somebody said, my heart would have been beating so fast every day. Your heart would have been beating fast and you would have been on low amounts of sleep. It was so intense. The court, you had to get there between 4 and 5 because they were not honoring the curfew like they were supposed to. The court didn't start till 9 a.m. So you had to stay in. Once court started, you can't leave out. You had to stay there from 9 a.m. until whenever the judge decided to do a break. You get a quick, maybe 10-minute break, and you got to come right back and be in until lunch. Once we were in at lunch, we did not get a full hour for lunch. We got maybe, it was supposed to be 45 minutes, but it never really was 45 minutes for real. Like it seemed like it was always less than that. Then you had to be back in before court started. So if court started and you were not back, you were cut out. Then court went till 5 or 6, depending on the day. Then you had to, if you were a content creator, relay everything that happened that day. So you had to compile 9 a.m. to 6 p.m. testimony and reiterate everything that you could to your audience. To relay all those hours, it normally would take like 2 hours on a live. Then you got to prepare for the next day. You got to also eat. You got to make time to eat, get food, all of those things. So it was nonstop. All right. So let's read what Mike Howard, his affidavit says. All right. The state of Texas versus Karmelo Sincere Anthony. Affidavit of Mike Howard. Before me, the undersigned notary public on this day personally appeared Mike Howard, who being by me duly sworn, deposed, and state as follow. I, Mike Howard, and those of you guys who don't know who Mike Howard is, this is the lawyer that represented Karmelo Anthony during the trial. I, Mike Howard, am at least 18 years of age, of sound mind, and I am competent and qualified to make this affidavit. I have personal knowledge of the facts stated herein, and that they are true and correct. I declare that. I was the trial counsel supported by second chair co-counsel Toby Shook, third chair counsel Tasha Gupta. Who was she? And where was she? I ain't never seen her. Who was Tasha? Third chair. I don't ever remember seeing no damn third chair. Third chair counsel Tasha. Oh wait, there was other people. My bad. They did have 4 people at their table when they did jury selection, but it was only 2 people when the trial started. But they did have other people. My bad. I did. Anyways, all right. Okay. Third chair co-counsel Tasha Gupta and briefing appellate co-counsel Michael Mola, who represented Karmelo in the case number blah, 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 leading up to June 1st. Trial of this case, the defense and prosecution reached an agreement where the prosecution and defense jointly agreed to not raise any alleged character, reputation, and strenuous offenses / bad act evidence relating to Mr. Anthony, as well as Austin Metcalf and Hunter Metcalf during the trial herein after referred to as the agreement. The lead prosecutor in the case, Bill Werski, brought up the possibility of the agreement a number of times well before the agreement was discussed in detail, and eventually reached when mentioning a proposed agreement. Mr. Werski proposed that we try the case clean, which he defined as based only on what happened under the tent that day, under the Memorial High School tent at Kirkendall Stadium on April 2nd, 2025, and not go into character, reputation, or a strenuous offense and or bad act evidence applicable to either Austin and Hunter or Karmelo. On May 5th, 2026, Mr. Shook and Mr. Werski discussed this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Werski discussed the evidence of character, reputation, and extraneous offense / bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Now, it's important to note that Mr. Shook and Mr. Werski used to work together. So the 2 people who used to work together made this agreement on the phone. Interesting. The 2 people who used to work together because Toby Shook used to be a prosecutor, and so is Bill Werski, and they worked together. The 2 people that worked together made this deal on the phone. It stinks. It all stinks. On May 5th, 2026, Mr. Shook and Mr. Werski discussed this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Werski discussed the evidence of character, reputation, and extraneous offense / bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Werski reiterated that he would be happy to try this without getting into character at all, just on what happened the day of the track meet. On May 8th, 2026, the defense and prosecution teams met in Collins County grand jury room. The prosecution team gave us a document entitled State's Notice of Intent to use extraneous offenses hereinafter, State's Notice, and we gave to them a document entitled Anthony's Motion in Limine regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor rule, and evidence under the Texas Code, whatever that is. After tendering to each other our respective extraneous filing/briefings, we then discussed the proposed agreement, which Mr. Worski referred to as a gentleman's agreement. Mr. Worski outlined the proposed agreement as follows. Both sides try the case without character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony, and just try the case based on what happened under the tent and during another description during that meeting. What happened on the day of the incident? Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses/acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins' school records within this framework, as well as racism. In exchange, the prosecution would not go into character, reputation, and extraneous offenses/acts, evidence relating to Karmelo Anthony, inclusive of the contents of Karmelo Anthony's cell phone and school disciplinary records. At this meeting, I sought clarification on how this agreement would work practically, specifically how to handle the possibility of opening the door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected, etc. Mr. Worski eventually agreed that questions narrowly tailored to ask specific statements the witnesses made to police about the incident under the tent on April 2nd, 2025, including statements just described about the mindset and actions of the parties involved in the incident, would not constitute kicking open your own door, and thus would not violate our proposed agreement. During this meeting, we discussed the terms of the agreement, being that testimony from eyewitnesses from under the memorial tent on April 2nd, 2025, and who were discussing the facts of what happened under the memorial tent on April 2nd, 2025, would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of the defense calling experts. The prosecutors only discussed how the agreement would apply to the defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt/innocent phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt and innocence phase. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extraneous offense/act evidence. On May 11, 2026, Mr. Worski, Dewey Mitchell, Mr. Shook, and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and with his parents to confirm the final agreement. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of trial as well. Mr. Worski said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if such a thing occurred, he would respond by going into character, reputation, and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother testifying to the standard. I love my son, please show him mercy type of testimony, but no further. What? Somebody said this gotta be fake. No, this is in his motion. This is what Mike Howard is testifying to. Who says, I love my son, please show him mercy, and that's all you can say? If you guys don't see that this was a true railroad through and through, again, it shows that you are biased. I don't care what you think about the outcome of the case and how you feel like it should go. Nothing about this was fair. Nothing about this was just. In my opinion, all of this shows corruption all the way through it. Somebody said, was this before the trial? Yes. The trial started June 1st, 2026. This is talking about communications that they had May 11th. And then the next paragraph shows communication they had May 21st. The trial started June 1st. On May 21st, 2026, the defense and prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, extraneous evidence as it applies to both sides during both guilt and innocence and sentencing phases, as long as no doors are open or false impressions given. We agreed that the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony. But if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. On May 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worski by email. It was hand-delivered to the judge on opening day of trial. The defense understanding of the agreement. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025. As every description by Mr. Worski described the agreement to allow for testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would any other eyewitness to the incident under the tent on April 2nd, 2025. Following the plain meaning of Mr. Worski's words in describing the agreement, the defense understood the agreement to cover testimony by eyewitnesses such as memorial students underneath the tent at the time of the incident, Hunter Metcalf, students outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony. This understanding of the agreement was further confirmed by events that occurred after the motion in limine memorializing the agreement was drafted and tendered to the prosecution on May 29, 2026, after a meeting with Judge Roach, the prosecution, and the defense to discuss how trial security would be handled. The parties discussed the timing of the state's case in chief and when the defense case in chief would start. Mr. Worski informed the court and the defense that he estimated it would take 3 days for the state to present its case in chief, which would have ended sometime on Saturday, June 6, 2026. In response, I voiced concern to the judge in front of the prosecution's team that some of the witnesses the defense anticipated calling to testify were unavailable on Saturday, June 6th. I explained that, like in any case, I would not know until the final moment whether we would call our client for sure, but that if the prosecution rested sometime Saturday and the judge forced us to call witnesses immediately on Saturday, I may not have enough witnesses available to fill up the full day of testimony Saturday. I explained that if this happened, it would force me to call my client out of order. The defense plan was to call all our fact witnesses first to establish facts and then conclude by calling our client to testify as our last witness. On Friday, June 5th, 2026, the second day of testimony during the state's case in chief, I checked in with Mr. Worski about how he was proceeding on whether he would end up taking more or less time to present his case in chief than he had initially estimated. Mr. Worski informed me that he was moving more quickly than he had initially estimated, so the prosecution was on track to rest its case in chief midday Saturday. In this conversation with Mr. Worski, I again brought up the fact that several defense witnesses were unavailable on Saturday. And if the judge proceeded with this plan to force the defense to call witnesses immediately upon the prosecution resting in order to have a full day of testimony on Saturday, we might be forced to call our client out of order. This time, I did not preface this statement with the perfunctory, like in any case. I won't know if I'm going to call my client at the last minute because I was not on the record and I was speaking to call my client at the I was not on the record and was speaking frankly with opposing counsel. I was very plain about the defense intention to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June 5th, this conversation with Mr. Worski occurred, but it must have occurred just before noon because I then sent an email to Michael Mola describing the problem we were facing and asking Mr. Mola to draft a brief for us to argue to the judge that he couldn't force us to call our client out of order. Throughout the morning and early afternoon, let me change the page for y'all. Throughout the morning and early afternoon on Saturday, June 6th, Mr. Shook and I repeatedly checked in with Mr. Worski to get updated estimates of when he might rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Besides the defense team repeatedly mentioning in front of Mr. Worski and the rest of the prosecution team that we intended to call our client to testify, even if it meant it would be out of order, Mr. Worski's own actions and arguments made it clear that he knew full and well that we intended to call Mr. Anthony to testify. Even before both sides tendered their notices of and arguments in favor of the admissibility of character, reputation, and extraneous evidence pertaining to the other side's witnesses, Mr. Worski made references to understanding that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf that was uncommunicated / unknown to Mr. Anthony via the ambiguous aggressor rule. From Torres v. State, blah, 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 the ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in a murder case are all part of a self-defense argument. Torres discusses in depth how the ambiguous aggressor rule allows the defense to put on uncommunicated character and reputation evidence before or after the defendant testifies. Mr. Worski repeatedly brought up Torres in discussion with the defense team in the months leading up to the trial, stating that while he thought the judge would rule correctly and not allow the evidence, he conceded that character evidence could be allowed. This repeated discussion of Torres and how it may apply to the trial showed that Mr. Worski was well aware of at least the possibility of Mr. Anthony testifying in order to argue self-defense. This was the entire purpose of the agreement, in that it provided value to the prosecution, limiting the defense from presenting damaging character and reputation evidence against Austin and Hunter Metcalf. And the defense from the defense's perspective, the entire agreement centered around the defendant testifying without impeachment by character, reputation, and extraneous evidence in exchange for the defense not seeking to introduce character, reputation, and extraneous evidence against the Metcalf twins. Furthermore, any competent criminal trial lawyer knows that for a self-defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood the agreement to include Mr. Anthony's testimony free of impeachment by character, reputation, and extraneous offense / bad act evidence, just like every other witness either side could call to testify about what happened under the tent that day. The defense's reliance on the agreement. Throughout the trial, the defense revised the trial strategy in reliance upon the agreement. Absent the agreement, the defense intended to cross-examine each memorial student witness the prosecution called about Austin and Hunter Metcalf's character and reputation for violence, for being bullies, and for racism. The defense also intended to cross-examine these witnesses about various statements they had made to the police on April 2nd, 2025 regarding Austin and Hunter Metcalf being easily triggered, having a loud mouth, being passionate, and not allowing themselves to be disrespected. What do y'all think so far to Mike Howard's affidavit, to what he went through behind the scenes as it pertains to this case? I dropped the link down below. If y'all want to come up and talk about what we are hearing so far, let me know. If not, I'll continue to read. But let me see what y'all say. Crystal Destiny says this is very telling. She said the call is coming from inside the house. I'm glad his parents kept it cool and kept their systems brief. Head to Mike Howard law page and child, I'm not gonna say do that because child, I'm gonna be holding some people accountable, so I can't, you know what I'm saying? But that's what y'all saying to do. I'm not gonna say do that. Because child. Anyways, click the link. Somebody said, how do I join? Click the link. I'm gonna post the link again. Click the link. You can come and enter. Let me know your thoughts so far. And then I'll continue reading. You keep saying this. I guess you want me to acknowledge that you keep saying, damn, you still live. I done seen you type that several times. Somebody said this is bad but good at the same time. Another person says it's also scary. I don't even know how you deal with this one. Child. Yeah, you laughing because you know you done typed this several times. Damn, you still live? Like, how you like what you gonna keep writing that until I to respond? Child, I keep starting to look shiny. Like, what the heck? I can't believe I've been on here talking to y'all for 7 hours. We cannot be shiny, girl. But anyways, all right. So somebody said this is crazy. Thank you for your hard work. Thank you for realizing my hard work. But I'm trying to figure out, child. If you can't go to Bella Noche's, I'm gonna need y'all to support the stream. Like, we've been here for most people would have been shut the stream down because baby, y'all have not supported like that. But I'm keeping the stream going because again, we are going to break down the live. But y'all could support by giving a little, $1, $2, $20, $10 holla in my Cash App, Nika Night Media, because baby, we are on a roll. All right, so let's continue. So it says, where we at? These witnesses, let's see. The defense also intended to cross-examine these witnesses about various statements they had made to the police on April 2nd regarding Austin Hunter being easily triggered, having a loud mouth, being passionate, not allowing themselves to be disrespected. Some specific examples include Austin's a really big guy, and he's the kind of like aggressive guy on the team. Austin got the same way that he got during the altercation is the same way he got with some of us. And the mellow kid, something or whatever, and then Austin kind of got triggered. Austin and Hunter, they're not going to let you disrespect them. And Austin, he's like a big guy, so nobody really wants to fight him. And Austin's really a passionate guy. And Jose told police about Austin's history of fighting and almost getting kicked off the football team for fighting. Another statement, I've known Austin for a while, and if Austin is about to get into a fight, you can tell. Another statement, Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense case in chief and question them as hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter Metcalf's reputation for violence and bullying. The defense intended to call witnesses who themselves were victims of the Metcalf twins, violence and bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti in good faith reliance upon the agreement. The defense did none of this. The defense even limited its questioning of witnesses about statements they had made about the Metcalf twins being triggered, having a loud mouth, being passionate, etc. That had been deemed to be allowed under the agreement in an abundance of caution to avoid opening the door. Furthermore, related expert would open the door to character, reputation, and extraneous evidence pertaining to Karmelo. The defense chose not to designate any experts and ultimately chose not to call as a witness a neuropsychologist to discuss how Mr. Anthony's epilepsy impacted his perception of threat and response, as that is relevant to self-defense, and a forensic psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it applied to Mr. Anthony's actions. Y'all want to tell me that they didn't railroad this boy? Y'all want to claim that he got a fair trial? If you see all of this evidence and you think that he got a fair trial, you're full of shit. You're full of shit. You're full of shit. There's no way that you can see this information and not see how they totally screwed Karmelo. Michi, what's your thoughts?
Hey, good to speak to you, Nick.
Hey.
I've joined a bit late. I'm just curious about this door. So if we open this door, what happens?
Then they would tell whatever bad information they had about Karmelo. They haven't mentioned what that is, but it would open the door to bad information about Karmelo.
I say open the door. How bad can it be? You know, in
Right.
relation to what's going on. I say let's open all the doors. Let's put everything on the table. I don't
I
understand
agree.
why that agreement was why that was agreed to. It doesn't make any sense.
Right. Like if he didn't kill somebody, which, you know, if he just got into a fight with another student, let's put it all out there.
Exactly. I mean, it seems like everyone's got a bit of a history, so let's put it all out there. And, you know, in relation to all of that, then let's look at the case again.
I agree. I that's why I want to know, like, what is this bad information that they have on Karmelo that they keep saying that they didn't want the door to be open, and they're not even saying it here. So it's like, what is it? There's rumors, but I don't want to go off of rumors. I want to go off of facts. So let's put it all out there. I say,
Absolutely.
if they did racist graffiti, if they had a reputation for bullying, if they were thugs that they sound like they were, put it all out there.
Absolutely.
Put it all out
Absolutely.
there.
And at the end of the day, the aggressors were them. I mean, Karmelo was sitting down. They approached him. I don't know why that's not taken into account. He didn't approach them and attack them. They approached him. So how can that be
And
straight murder? It just doesn't make sense. I'm in the UK, and even in the UK, that makes no sense.
right.
But anyway,
Somebody said pictures of him with guns. Well, there was pictures of both of them with guns. If they're gonna use pictures of Carmelo with guns, there was pictures of Austin and his brother with guns too.
okay, but is there evidence that he used the guns?
No,
That
this
he's
was in a
hurt
gun
someone with the
case.
guns? Okay, so a picture with a gun means nothing, but records of the brothers having a reputation of fighting regularly, being racist regularly, I think that holds more weight than a picture of Carmelo with a gun that he hasn't caused any harm to anyone with.
Right. I agree
People
with
just want to
you.
throw things out of there. Oh, he had a picture with a gun. So what?
Yeah, I agree. But I think that, they were weighing it on, they know that that's a racist ass county,
Hmm.
and they know, you know, but still put it all out there. Put it all
Absolutely.
out there.
I'm not sure why
Um,
his defense chose to agree with those conditions, but I think considering that this is his life on the line, then I think they should have just opened all the doors, all the windows, and let's air everything out.
yeah, I agree. Bro man, what's your thoughts?
Hey, thank you. I just wanted to know, like, I was trying to find out too, what is the benefit for Carmelo for them to make this kind of agreement? Because it just, screams to me inadequate counsel. He
Right.
wasn't able to get a good defense because now, if I'm right or not, I'm not sure. But when they talk about character, right, that's both good and bad.
Hmm.
So
Right.
the good character of Carmelo can't come out. And the negative of them can't come out. Now, also, I had heard when with the gun. I apologize, but
While you talk, I'm gonna listen, but I'm gonna go tinkles. But go ahead. Don't say nothing that you ain't supposed to. Don't say nothing crazy or none of that.
okay,
All right.
okay, I got you. Yes, y'all subscribe. Hit the like button, bro. What's wrong with y'all? This is great content. Support the channel, bro. Subscribe, like, and share. But yeah, I was hearing that it was a prop that he was posing with, not necessarily an authentic, real tool. So um, I just think that kind of like what she's saying with the county that they, already had their mind made up the day that it happened, and that they were not into doing the investigation. And then also when we see that the corruption with the prosecutor, the state guy Paxton, whatever office he had, he's also trying to get political favors, from them, So I just, like it just screams of political corruption, and I think that we as a country deserve better, and I think that we all know that if the roles was reversed and Carmelo was the Caucasian kid, bro, that they would not have gave him 35 years for trying to defend himself against a mob, bro. And
Absolutely
like
not.
my thing was also, if you got 21 witnesses and none of them can witness him possessing it or using it, I mean, like, come on, bro. And then where are the adults? You mean that this tent canopy, whatever, is ran by the students? There's no
Yeah.
adult supervision anywhere. I just think that that's a mistake by the school district, and whoever was hosting the event, and even the people that was in charge of that canopy. I mean, because nobody knows what happened. It turned into a he said, she said. They're giving us grainy video. I mean, how are we supposed to be able to make our minds up with that? And then people who aren't really paying attention, they're just going to accept whatever, and go on to the next thing. So I just think that we gotta move the best way we can, man, because we know that the deck is stacked against us. So I
Mhm.
just want people to think before you do an action, bro. Make sure that you can live with the consequences of your action because it might feel good in the moment, but in the long run, was it worth it? And in this case, it's hard to to kind of determine if it was worth it in the long run. But I do believe this: if you were to ask the Anthonys or the Metcalfs if they wish their son would not have done what they done, that the Metcalf family would definitely wish that their son would not have done that.
I think they would still justify it personally. I still think
Okay,
they
go
would
ahead.
still say, I think they would still say, well, he had the right to, which he had no right to. He's a student, just like Carmelo was. It's like, how is it okay for a student to go to another student and demand that they move?
Absolutely. But now I'm saying that I believe that his parents would prefer to have him here
Oh, absolutely.
than
But
to
I still
say,
think
oh, well,
the
he
dad
made
would
a
still
stand for a great
justify.
cause. Go ahead, Queen.
I think he would still justify that the arrogance of that family is unreal, in my opinion. Their sons can do no wrong, although the mum has slipped up in things that she has said.
Yeah, the mom would
She's shown
justify
her
it
son's
and the
character.
father.
Yeah, they will always, even if they could change it, they will still feel that their sons were right, and it's disgusting.
But I'm saying, but so if they would have had a chance to be able to talk in his ear, they wouldn't have said, "Son, don't do that. We love you way more than any kind of thing that you're trying to stand up for right now."
Yeah, if they knew it was going to cost his life, yeah, but if they didn't think it was
Right.
going to cost
Okay.
his
Then.
life,
So then that's the person that, to me, had made the biggest mistake. But go ahead. I
yeah.
apologize.
No, 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 no. No need to apologize. I hear what you're saying 100%. But I think knowing the outcome, yeah, they would have a word. But I still feel that they don't think there was anything wrong with their son's behavior. Do you get what I mean? I still think
Oh,
that they would
absolutely.
justify his actions. They
They
wouldn't want it
would
to end
both
that way.
justify it because you see the mom justifying Hunter, like even down to her describing how Hunter was at the court the day of the verdict. She justified him going to Austin's girlfriend's house for 30 days. Oh, he didn't want to be at home, so he found comfort with Austin's girlfriend, but that was completely innocent. Like, girl, you make excuses for your kids. There's no
Yeah.
reason that he should have been laid up at Austin's girlfriend's house for 30 damn days.
Hmm. Enablers.
What?
And
They're
then
enablers.
and then she was trying to shame the cheerleaders who were bullied by her fucking thugs,
Yeah.
and
Yeah.
she tried to justify that the parent that released the evidence that her children bullied her daughter, that they were wrong. Oh, they were
Yeah.
just trying to get clout off of my son. They were trying to just get clout off of him. No, how about they were trying to tell their truth, that your son is a damn thug and a bully,
Hmm.
and according to what Mike Howard says, a racist.
Hmm.
Hey, can I ask you a couple more questions, please? Is there anything in that paperwork talking about them not presenting the weapon, the tool in court? No
They did
DNA, no
present
fingerprints of Carmelo. Go ahead.
they did present the tool in court.
Okay. So did they have fingerprint evidence or DNA or?
I never heard them say that we got his DNA, but they presented it in court and they had testimony of kids who said that that was his knife.
Okay, because I was hearing somebody say that it was a replica, not actually the official one. So I wasn't for sure.
They showed
And
both.
and so did they ever uh, do his jacket? Because I think they said there was a couple drops on there. So did they ever come back and test his jacket to see if that was his, Austin, or anybody else's?
Whose jacket?
Carmelo. The hoodie he was wearing on, it had a splat, a drop in on the front and on the back, as well as it having a little bit on his finger.
It's irrelevant.
And go ahead. I'm sorry.
Is
These are
that
irrelevant pieces of evidence, fam. He done that.
he admitted to it? So maybe that's why they didn't
Yeah, they
He
didn't.
admitted to what?
provide that. He
To
admitted
being
that he did it.
he admitted to being a alleged suspect.
Mm-hmm.
That's
He
not a
admitted
crime,
to.
and that's not an admission of guilt or of a crime. Though, go ahead.
I don't think there's any doubt that what happened happened. I think the issue is the circumstances surrounding it. It's not as simple as he just took somebody's life. Do you get what I mean? And that's where my issue lies. We're not saying he's innocent and he didn't do that. He didn't produce what he produced and caused harm. He did, but it's surrounding the whole thing. You know, why did that happen? He didn't go there with that intent. That was brought to
Okay,
him.
Queen, but let me ask you this then. So you're saying that it was proven to you beyond a reasonable doubt that he did that?
He admitted to it.
I wasn't in the court, but yeah, he admitted to it. But I mean, I didn't hear all the evidence in the court. We can
He
only go
admitted to
by what's
being
been
an
relayed.
alleged suspect.
He said
No,
he
So
did
that's
it.
just like if the police are looking for me and they're saying, we think we found an alleged suspect, and I say, no, I'm not alleged suspect. I am the suspect that you're looking for, but that doesn't mean that I admitted that I broke any law or crime. I was just wondering because I've not heard,
and add me.
you know, go ahead.
A freight
Add
train.
me.
Go ahead. You on here? Go ahead.
Oh, okay, listen, man. He didn't admit to being an alleged suspect. When they said we got the alleged suspect, the man said I did that. And he was supposed to do that. They talking about they got pictures of him with guns. Black people need guns. Everybody need a gun. If you on here, you need a gun. Get a gun. Get a lot of them. Because they got guns. When you see them like white boys with guns, you don't see a thug. You don't see a criminal. But
Mhm.
that's exactly what them twins were.
Mhm.
Carmelo is a American. That means he has the right to have guns. I learned how to shoot guns at 9. This is not ain't nothing criminal about that. What you do with them makes you what you supposed to be or what you ain't. All that extra they need to. They talking about they don't want to open up the. They don't want to bring up this about Carmelo and don't want to bring up that about the twins. That is not to protect Carmelo on the defense side. That is
Mhm.
to protect the twins on the defense and the prosecution side. See, people,
100.
this the thing, right? Scientifically proven. Melanin makes you more compassionate. So y'all getting this wrong, black people. I love y'all, but y'all getting this, y'all looking at this all wrong. Y'all looking at this like the defense made a mistake. They didn't make no mistake. They did exactly what they plan to do. They did exactly what they plan to do. They are friends. They are on the same team. Do you see that march they just did in DC with all them folks with the masks on? Ain't no telling how many of them was police officers and judges and lawyers, defense attorneys. Just gonna have you thinking they your friend when they smile in your face and gonna hang you, gonna trade you like a basketball card. Them folks don't care about you, man. So looking at it like, oh man, they messed up. No, they were never on your side.
Yeah.
They don't have nothing to put up on that boy. That boy saves. If they won't pull up something, that boy save somebody's life within the newspaper. If they won't pull up something, he was a straight A student and the captain on the sports team. If they won't
Mhm.
pull up something, it can't be nothing too bad. Whatever,
Right.
he had a
That's why
fight
I
or something in
say
school.
open it
So
all
what?
up.
Yeah, you can't have nothing too bad on that boy. You just the fact is, Toby Shook and Mike Howard and every other face in that courtroom, except for his parents and the black people who was crying for him, was on them folks' side, man, from the jump. This is Collin County we talking about. They have listen, the Klan ain't even leading uh what you call it, white nationalists, whatever they want. They not even the leading bigots no more. But they still have national meetings right there in Collin County. They
Mm-hmm.
still have meetings right there. They don't bring their ass to Dallas. They not coming to Dallas. They know better. But they have meetings right there in Collin County. And the mother folks, you see they got their masks on, man. Them folks probably criminal. They probably got all kind of charges and whatnot. If what's his name? What's the little boy that got the signs, got beat, slapped out upside his head in L.A. What's his name? Jake Lane.
Who? Oh,
Jake
I was
Lane.
like, who?
Yeah. If he decide once he get off this ankle monitor, or even if he own it, because they ain't gonna enforce it on him, they on his side too. But if he decide that he want to march around with a gun with some white supremacists, then all he gotta do is put a mask on. Who gonna bother him? Ain't nobody gonna bother this boy. You know who they gonna bother? Us. But we don't put no mask on. And we don't care what you got to say. Because we know the law. We read the law. Word for word. We know exactly what we doing. Yeah, they don't want the law to stand for us. That's when they start talking about guns. When they see us with them. Yeah, but we're Americans too. Matter of fact, we more American. We made this motherfucker. I'm sorry. I'm cutting. I'm
All
sorry.
right. Nah,
Yeah.
you good. Well, thank you so much. Stay backstage. Don't hang up. I'm gonna read some more of this this affidavit. Do not click off. I'm gonna bring you guys back up once I read a little bit more, and then I want you guys to chime in. So don't go anywhere. I'm gonna just finish reading what this says. I don't know what part I left off on because y'all been getting into some things, but let's finish this out. All right, so it says, as a result of this revision, the defense did not go into these subjects during voir dire or opening statement. Without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored these subjects during voir dire and would have introduced these topics during its opening statement. In sentencing, in reliance upon the agreement, the defense did not designate an expert who was ready to testify regarding mitigation, i.e., a risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to just 3 questions of Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Other than general character testimony and pleas for mercy, in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been a victim of in his home. Notification of breach of agreement. On Saturday, June 6, 2026, after the prosecution rested its case in chief, the defense called witness Adam Linwood and then these others before ending the day in the late afternoon/early evening. On Monday, June 8th, 2026, the defense resumed its case in chief, calling Brendan Steffens and these other defendants. The defense next planned witness, blank, had been avoiding the defense's subpoena and kept changing the time he told us he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if blank had arrived. During the 10:50 a.m. break in the back hallway outside the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the next witness the defense had planned to call was a Centennial High School coach. Mr. Worski asked that the coach would testify to that did not pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his personal knowledge. Mr. Worski then argued that testimony about epilepsy was irrelevant at guilt/innocence, and to the extent it was relevant would open the door to character, reputation, and extraneous evidence against Mr. Anthony. In plain terms, it would breach the agreement, which I believe, and I'm ad-libbing for myself, that's bullshit, because a medical diagnosis is not the same as character evidence. So, Mike, you were supposed to get this ruled on by a judge because a medical condition is not the same as character evidence. Like, what are you talking about? Like, what? So it says, Mr. Worski then argued that testimony about epilepsy was irrelevant at guilt/innocence, and to the extent it was relevant, would open the door to character, reputation, and extraneous evidence against Mr. Anthony. In plain terms, it would breach the agreement. I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind pertaining to self-defense, and that it did not relate to character, reputation, or extraneous evidence. Good. I mean, but also a medical condition is not the same thing. But Judge Roach agreed with Mr. Worski that he thought testimony about epilepsy was not relevant during guilt/innocence and would open the door. How? That's how you know this judge, it was corrupt, in my opinion. Again, that's not a fact, but in my opinion, Judge Roach is corrupt. Like, what? How is his medical condition character testimony? It says, Judge Roach agreed with Mr. Worski that he thought testimony about epilepsy was not relevant during guilt/innocence and would open the door to character, reputation, and extraneous evidence based on this. I informed the court that I would not call the coach and that I anticipated having one or two more witnesses before I would call Mr. Anthony. In response to the judge's question about likelihood of Mr. Anthony testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decision regarding testifying, but I was 99% sure that he would, in fact, testify. After the break, back in court before the jury to give blank more time to arrive at court, we then called Frisco Police Department Detective Riley to testify. After Detective Riley finished testifying, then decided not to call blank as a witness as we broke for lunch early around 11:17 a.m. And this is when I seen the guy, the goon, the thug recording me, and then they parked next to my car. This was this that day or was this a different day? I can't recall. But child, what day we on? What day they talking about? Anyways, maybe this wasn't that day. I don't know. All right, so let me see. It says, on the way back to chambers, Mr. Worski mentioned to Mr. Shook that from his perspective, I had already opened. Oh, this is June 8th. No, this ain't the day. June 5th was the day they was recording me getting my car and then parking next to me. This is June 8th they're talking about. All right. So it says, I had already opened the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club during my opening statement. I did not say anything about chess club at any time during my opening. I said that Mr. Anthony played chess during my background description of him and his hobbies. Mr. Worski also stated that from his perspective, the agreement did not cover a testifying defendant. Mr. Shook alerted me and Mr. Worski and Mr. Mitchell. Mr. Shook and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony to testify. Back in the judge's chamber, Mr. Worski repeated his assertion that the agreement between the prosecution and the defense never contemplated a testifying defendant. He elaborated, stating that he never thought that we were calling Mr. Anthony as a witness. He also repeated his claim that I had already violated the agreement during my opening statement by saying that Mr. Anthony was a member of the chess club. It is important to note that that was the first time Mr. Worski mentioned that he believed I had violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening statement. Although the prosecution and defense team had conferred, many times throughout the prosecution case in chief about various issues. This was the first time Mr. Worski brought up this assertion. Judge Roach told both the prosecution and defense teams that my mentioning chess during the opening statement definitely did not open the door to character, reputation, and extraneous evidence applicable to Mr. Anthony. The parties argued about whether the agreement between the parties covered Mr. Anthony's testifying. The prosecution repeated their position, and extraneous evidence pertaining to Mr. Anthony were in play. Furthermore, Mr. Worski stated that time that the prosecution already had rested, character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. When Mr. Shook and I mentioned the ambiguous aggressor rule from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was. That the first aggressor was clearly Austin Metcalf. At this point, the discussion devolved into a shouting match. Impact on the defense case. After the breakdown of the agreement, the defense and prosecution teams agreed to take 10 minutes to cool off before attempting to renegotiate parameters of how the agreement could extend to Mr. Anthony's testimony. Should the defense now choose to call him, after the 10-minute cooling off period, Mr. Worski and I met in open court, outside the presence of the jury and without public in the room. Now, this I remember being outside wondering what's going on, what's happening. This was right after I broke down on stream, and there was all these thugs that came up there to intimidate me. And we just were waiting and waiting and waiting and waiting inside the court, wondering what was going on, while white supremacists were telling people to intimidate Black journalists. Yeah, I remember this part because we were waiting. So it says that where was I at? Okay. I read the wait. Okay, let me go back up to the top, because where was I at? Child, I was like, it was putting me back there, like all this going on. We outside, they got white supremacists out here, all this stuff. So anyways, it says, given Mr. Worski's expansive view of what he considered would open the door to character, reputation. Wait, did I skip a part? Let me just start back at the top. Okay, after the breakdown of the agreement, the defense and prosecution teams agreed to take 10 minutes to cool off before attempting to renegotiate parameters for how the agreement could extend to Mr. Anthony's testimony. Prior to this, I guess the lawyers were arguing. It says, and they were having a shouting match or whatever. So it says that Mr. Worski and I met in open court outside the presence of the jury without public in the room to discuss possible parameters for the agreement covering Mr. Anthony's testimony. Given Mr. Worski's expansive view of what he considered would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony, especially his repeated claim, even after the judge stated otherwise, that even my mention of playing chess opened the door to character, I resolved that my only choice was to go over my planned outline of Mr. Anthony's direct examination line by line with Mr. Worski to determine what would and would not, in Mr. Worski's view, open the door. I have never taken such a drastic step of previewing my strategy and even my questions with a prosecutor. But as a defense team, we agreed that we had no other option. We wanted to try to reach an agreement, understanding with Mr. Worski of how the renegotiated agreement would cover Mr. Anthony's testimony. As I went through my outline with Mr. Worski, standing reading the outline over my shoulder, Mr. Worski declared various subjects that, in his view, would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony. During this discussion, Mr. Worski repeated his claim that my earlier mention of chess opened the door. While I disagree with all of Mr. Worski's assertion of subjects that would open the door, I agreed to cut them from questioning in the hopes of salvaging the agreement to keep Mr. Anthony's strenuous offenses out if he testified. At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal through certain aspects of the testimony, in an abundance of caution to avoid opening the door, Mr. Worski and I informed Judge Roach that we had to come to an agreement as to how the renegotiated agreement would cover Mr. Anthony's testimony. We then summarized the process we had just gone through and had our renegotiated agreement on the record. Prior to breaking to allow the defense to retire the defense room to discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being open. What? Dirty. That is, if this don't show you corruption, I don't know what does. How do you make an agreement with the lawyer? You say, okay, I'm going to take these things out to make sure that I don't open the door, and then the judge backdoors the agreement that you just made with the prosecution to keep everything copacetic, and then say, you know what? I think it's still going to open the door if he testifies. Dirty, corrupt ass court, in my opinion. So where was I at? Okay. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being open. For example, if he said that he brought the knife by accident or said that he was scared, etc., that this would almost certainly open the door to character, reputation, and extraneous evidence of some sort to clarify the issue. I proposed the hypothetical scenario that if Mr. Worski claimed that the agreement had been breached in some way, if I and even the judge felt that Mr. Worski was operating in bad faith, that the judge was stating that he could not enforce the agreement, would have to make a ruling based on the Texas Rules of Evidence alone. Let me go to the next slide. And that in all likelihood, the door would have been open. Judge Roach confirmed that this was the case. We then broke to discuss the issue with our client. Judge Roach gave us approximately 10 minutes to explain the breakdown of the agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for an on-the-record admonishment. During the trial pre-admonishment meeting with Mr. Anthony and his parents, I did my best to explain everything that just happened. With the help of Mr. Shook and Miss Gupta, we then returned to the courtroom for Judge Roach to admonish Mr. Anthony about his Fifth Amendment rights and also to explain that if he testifies, Judge Roach believed that he had no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been open. Judge Roach then gave us 10 minutes to discuss his Fifth Amendment rights with Mr. Anthony and help him ultimately decide whether he would testify. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life, but Judge Roach declined to extend our time beyond 10 minutes again. We did our best to explain everything, the pros and cons of testifying versus not testifying, the likelihood of winning on a self-defense if he testified versus if he did not, the likelihood of whether we would get instruction in the jury charge on the lesser included charge of manslaughter and criminally negligent homicide if he did and if he did not testify, and the likelihood of whether we could get instruction in the sentencing jury charge if we got there on sudden passion if he did and if he did not testify. During this discussion, beyond all of the above, the most complicating factor of all was whether Mr. Worski would claim that we had opened the door and then bring in Mr. Anthony's extraneous offenses / bad act characters or in reputation based on his actions and claims. Specifically, his repeated assertions, even after the judge had firmly disagreed that I had opened the door by even mentioning chess, as well as his general claim that the agreement had never been contemplated. Mr. Anthony testifying despite the plain meaning of the words Mr. Worski himself repeatedly used to describe the agreement. The defense team felt strongly that the risk of Mr. Worski claiming the door had been open was too high. This was amplified by the fact that Judge Roach made it clear that should Mr. Worski claim a breach of the agreement, he felt he was unable to enforce it and that in all likelihood the door would have been open. At the end of 10 minutes, despite our request for additional time, Judge Roach called us back to the courtroom to announce Mr. Anthony's decision and proceed with the trial. Ultimately, Mr. Anthony chose not to testify. This 180-degree change in the defense strategy was the direct consequence of the breach of the agreement. The breach of the agreement affected all aspects of the defense case. By the time that the agreement was breached, it was too late to change our approach in voir dire and opening, too late to ask different questions of the prosecution witnesses, and too risky to recall those witnesses. Okay, by the time that agreement was breached, it was too late to change our approach in voir dire and opening, too late to ask different questions of the prosecution's witnesses, and too risky to recall those witnesses. To ask questions that would risk the prosecution deciding that we had opened the door. It greatly hampered our strategy during sentencing, causing us to decide not to call witnesses we otherwise would have called and severely limiting the questions asked of one of the witnesses we did in fact call. The prosecution breach of the agreement directly and significantly undermined the defense's ability to present a complete defense. And this was signed by Mike Howard. And it was notarized, and it's going to be notarized until August of next year. All right. What's your thoughts, Freight Train?
Man, them folks misled that boy on purpose, man.
Do you want to be seen by the people? You're the only person in camera backstage. Do you want me to show you your thing?
I ain't got to be seen. I ain't gonna lie, I don't know how to turn the camera up. I thought I had it.
Okay, go ahead. You don't have to show yourself. Go ahead.
Yeah, I'm a little under the weather anyway. You can probably hear it in my voice. But yeah, I don't like how it was done, how it played out, because them folks misled Karmelo on purpose, told him not to testify. Fam, if I'm saying I defended myself, I already said it's not alleged I did it. I got to tell you how and why I did it. I got to tell you from my mouth why I did it. Won't nothing help you more than that. So,
right.
I mean, that the whole situation, all the, the judge saying if he testifies, gonna be brought up and all that. I mean, the folks corroborated to make sure that boy didn't get on the stand. The lawyer told him, like he was on his side, that this is best for you not to get on the stand. Whole time it's best for the prosecution. And the prosecution they not trying to uphold the law. Them folks is
Mm.
them folks is literally trying to help them little old white boys over there who hate niggas. I mean hate us. I'm sorry. But this ain't the whole situation, man. It ain't wasn't nothing in his favor at all. And then the family is so trusting that they just went along with it because I mean they can't really be blamed. They don't
Right.
know it. They don't know where they at. They ain't from here. They from Louisiana. They can't really be blamed. They done paid this man their money. They done been pointed. Somebody that they trust again pointed them to this man. So they figured he was on their side. Whole time he against them too. I'm gonna take your money and I'm gonna hang your son and I'm gonna watch your mama cry and I don't care. That's what the lawyers thought in his whole head. That ain't nothing right about them people, and they know ain't nothing right about them, and they still don't care.
All right.
So
Anybody Oh, go ahead. Sorry.
I'm sorry.
Go
Uh,
ahead.
yeah. So now that he got the dream team, as they call him, boy got 6 lawyers, 6 fantastic lawyers, and they moving to get away from that judge and that court. The whole situation gonna change. He gonna come home free. It's not gonna be time served. Time served is not an option because that's still on his record. That still hinders him in his life moving forward. He didn't commit a crime. He defended himself. You don't get to put your hands on me and tell me how to defend myself. Not in Texas. That don't work like that. If you put your hands on me and I'm in fear for my life, which he had every reason to be, it's raining. We on bleachers. I got epilepsy. I might have a seizure out here. And
Right.
you way bigger than me. If you put your hands on me, I got every right to defend myself. And he didn't keep on going when he poked Buddy. He poked Buddy one time and moved out the way. It ain't his fault he died. Hey, yeah, it kind of, but you know what I mean. That ain't he defended himself, and self-defense is the only option.
Yeah. Bro man, do you have any thoughts?
Yes, I do. First off, I would like to say the prosecutor said that there was a breach in the defense attorney's opening, right? As far as him being a chess player.
Yes.
That is the most ridiculous thing I've ever heard. But now here's the thing, though, right? As far as I'm aware, he didn't object at the time, and then the defense attorney is saying that the breach occurred so late that he wasn't able to, you know, make up for it. And I'm just like, that's like how is Carmelo supposed to win with that? You know what I mean? Like it happened in the opening, and it was, in my opinion, ignored until it became a point of Carmelo potentially getting on the stand. Now, also, I wanted to ask you a couple things. Well, because it seemed like the prosecution was able to determine which witnesses the defense had, the jury, and then with the judge saying that he's not able to enforce the agreement. So I mean, for me, that just means that there there is no agreement. You know what I mean? Like, um,
And I
it's
think
almost like. Go ahead.
what Carmelo Anthony's lawyers were trying to convey is at that point when they found out that it was no agreement, it was too late. The jury already heard all of that, but at that time it was up to uh Mike Howard to declare mistrial. He was supposed to at this very moment declare mistrial.
Absolutely, I agree with you. And the last thing I would like to know from you, right, is that if Carmelo gave an interview, would it hurt his opportunity and a chance for an appeal? Because for me, I don't think an appeal is going to happen anytime soon. I think they're going to try to delay it as long as possible because we see that they're not really trying to do anything to help Carmelo's case. Like for me, I like to play chess, right? And it's almost like They took Carmelo's queen off the board, both his rooks, and like pretty much he only had pawns out there, and so his team had to play checkers why the prosecution got to play chess, and I just think that it's sad, and for me, you know, let the evidence fall where it may. Just don't try to taint it and prejudice it because that's kind of what it seems like happen. But I'd like to thank you once again. I know that you working hard, and I appreciate you giving us this information and case because everybody is pulled up because we interested in the way you break down this content. So thank you very much. I appreciate you. God bless you. And we all praying that nothing what I mean, is going to happen because of people trying to get the truth out in this case. Because that's the First Amendment in the Constitution is the freedom of the press. And when you have people trying to intimidate people so they can't get out the facts, and nobody is coming to the defense of the journalists, I just think that that's a sad, sad day in America. Thank you once again. I appreciate you. Free Carmelo.
Thank you
America
so
had a
much,
lot of
bro,
sad
man.
days.
I appreciate you coming up. Just to answer one of your questions, I don't think that he should do any interviews. I think that he should wait until his appeals go through or what however the process is, whether they deny it, whatever, until those are exhausted. Don't say nothing because anything you say can and will be used against you. Michael 90 and OG Patrice, welcome. Michi, is there anything that you wanted to say?
Oh, yes, darling. I just wanted to touch on a few things really. Like in regards to his seizures and things like that. Um, I think that's a really important point because, people have different triggers for seizures. He was in a situation where he felt intimidated and fearful. So he may feel that being in that stressful situation could have caused a seizure. And to have a seizure in a position where you're very vulnerable, I think is an important factor in his way of thinking at the time. That's one thing I was thinking about, but also this this whole thing about the character and his character being brought in, or talking about the character and opening doors and all this kind of nonsense.
Mm-hmm.
I feel like the prosecution based or they used his character at that time to push for his conviction, because from what I hear, every witness that came up was led to imply that his character was aggressive and that he was the aggressor. That's talking about someone's character, but they only want to base it on the character at that instance. But what about the brother's character in that instance? Do you get what I mean? It's like you can't pick and
Yes.
choose when you want to talk about character. Character is a big part of the whole situation. So for them to push back, obviously they had a fear of what bringing out everyone's character might do to their prosecution case. Do you get what I mean?
Yeah. Yep.
And also, I think giving him just the 10 minutes to decide on whether he would take the stand or not is shocking. Like his lawyer was saying, it's 10 minutes. That 10-minute decision cost him potentially 35 years of his life. You
Yeah.
give this young boy 10 minutes to make a big decision whether he's going to speak up for himself or not, because that's basically what it is. And his thing is, if I speak up for myself, I have the fear of bringing out my character, which the prosecution will use against me. It's a
And to
horrible.
digest what just happened, they said that it was a screaming match. The prosecution and defense were in a shouting match. They had to have a 10-minute cool off period. The stakes are high. They can't get one of the witnesses there. They're saying that they're going to be there this time. They're not there. Then they're knocking out what certain witnesses can say and testify to, and this person can't talk about the seizures and all of these things, and nothing is really going right in his favor at that moment. And it's just like everything is going against me right now.
It seems to
He
me
didn't
the
have time
prosecution.
to digest it.
it seems the prosecution was more scared about characters coming out than the defense, because for some reason that was a big focus for them and a big pushback for them. Well, if you do this, then we're going to do that. I think they were more scared of
You're
what would come out.
somebody's echoing.
It's not me.
That was me. I just muted my mic.
Yeah. So yeah, that's basically what I wanted to say on that, on what you
All
just read.
right. Patrice or Michael 90, which one of y'all somebody said, Nick, did you get my cash out? Let me check. Hello?
Yeah, I'll go because I kind of wanted to piggyback off of what she was saying in regards to the epilepsy thing. I think the reason why they probably the defense probably didn't move forward with if it was going to open up a Pandora's box, as if if the defense was going to try to use it to say, okay, Carmelo was afraid that he would, get a epilepsy attack, or if he get hit kind of way, it could bring on a epilepsy seizure. But I think that the prosecution would have came back with the fact that Carmelo plays a very, very high powered contact sport, and that's football. I think that they would have came back with that, saying, "Oh, he worried about getting hit, but he plays football, which is a hard contact sport, where if he gets hit in his head or paralyzed or something, it's the same thing." So I think that's the only thing I can think of is where the defense didn't try to push back on the epilepsy situation. But I think anything else other than that, I don't think it could have been as bad as anything that the Metcalf boys has done. Playing, because it is dangerous playing football or contact sports. So I think that that's where the prosecution would have pushed back on and say, well, he don't want to fight, but he can get hit, playing this hard contact sport and blah blah blah. So I think maybe that's why. But anything else, I don't know. It's got to be something else that they're not saying there, that's not being mentioned. But at this point in time, when you're fighting for your life, I feel, and I don't understand why the defense did not prep Carmelo while he was out of jail for that whole year while he was out. Why wasn't the defense attorney prepping him then to take the stand? You're fighting for your life. And in 95% of self-defense cases, you should take the stand, good, bad, ugly, or indifferent. You should take the stand because they need to see that human side of you. They need to see the vulnerability in you. They need to see why you fear for your life. They need to see, yes, answer the question, why you had that poker with you, like whatever the case may have
But he
been.
was under the impression, it sounds like he was under the impression that whatever bad act they had on him would be detrimental to his case. So it sounded like he was in a position where it was a lose-lose, because they said that if he testified, it would open the door to these bad acts. Whatever that bad act is, they felt that it was so detrimental that they decided that they would just cease and not give him a full defense. So I'm sure that they advised him, oh, this is so bad thing that you did that you'll go to jail and you'll be guilty if this comes in. It sounds like that was the impression that they gave him.
Right, but the question is, it would have been on
Man, that football and fighting situation, that don't go together.
as well as Carmelo.
Patrice, you cutting in and out.
Oh, okay. No, he was in. Now, somebody has a back.
Patrice, go out and come back in or something. There's interference.
It's not me. He has his TV on. He has background on.
No, it is you. You're going in and out too. Like when you're talking, it's like going in and out.
Okay, no, but that's all I wanted to say, those points there. But thank you. I appreciate you letting me up.
That part just came through clear. But you can stay on. Michael 90.
Okay.
I feel like it's just like it was fixed for him all around. There was nothing that he could do, if you ask me.
Elaborate. Go ahead.
I mean, they screwed him over from the start. Even from the beginning with the Dominique guy, if you ask me. And I just think that no matter what he did, they were just gonna they inside the court system, they were gonna screw him over. His family didn't know anything about the court system. So what could you do about it? That's what I'm thinking.
Okay. You want to elaborate any further, or?
That pretty much be it. I'm kind of sleepy, so I might go to sleep. So, but I thank you for being up and like this because I probably would have went to sleep, but you know.
Well, I appreciate y'all. It's some of y'all who've been on here for the whole 8 hours with me. So
Yeah,
shout out to
I
y'all.
know.
OG Patrice been on here for the full stream.
Time and I
Shout out to y'all who been
I did it.
What you say? You cut
But
out.
no, I said I done cooked and cleaned and short and everything. You and jumped on here to watch. I just
Wait, Patrice, go out and come back in. Click the link again. Freight Train, you got her echoing. You got it playing in the back. You got to listen to us only through the thing. Patrice, click the link again so we can hear you.
My bad, that was me again. I can't hear her for some reason. I heard dude.
Oh, yeah, it's because she was going in and out. So hopefully she'll click the link again and maybe she'll come through clear now. Patrice?
Yeah, I'm here. Can you hear me okay?
Yeah, go ahead.
No, I was just saying, I don't know, you guys. If I'm fighting for my life, I mean, we've seen like court cases right on TV where and I know it's not television, it's real life, but we've seen where some ugly things have came out about a person, right? That mistakes or whatever, or a past that they've had where it may flaw you. But I just don't think anything that young man at 17 years old could have done that would be so bad that he wouldn't risk that, or his parents wouldn't want him to risk that. I would have wanted to shown my humility. I would have wanted to shown my fight in me, my fight for my life. And who is better to get up there and tell your story better than you? Good, bad, ugly, or indifference. Tell your story. Let people relate to you being human. Other than the fact that the prosecution would have came back with the football thing against the epilepsy thing. He's 17. Like in his whole life, what could he have done so bad? You know what I'm saying? That it would have painted this picture of this mad guilt on him at 17 years old. So I think to see a vulnerable 17-year-old, well, 19 now, kid, and where his frame of mind was then at 17, and then to have an expert witness like a psychiatrist get up there and talk about the frame of mind of a 17-year-old whose brain isn't fully developed. There's so many other things that I felt like could have been a part of the defense that just wasn't. I just feel like there wasn't enough fight. There wasn't enough. When you're fighting for your life, all bets are off, like everything's off the table. This young man is fighting for his life. Whatever comes out, comes out. But it does not negate the fact that I defended myself. I was afraid for my life. And this is the position I was in then at that time. Has nothing to do with the fact that I had done something when I was 10 or 12 or 15.
Yeah.
We're talking about now. What presidents does that set? I want the jury needed to see the vulnerability, the humility, the frightened, the scaredness. They needed to hear his voice, his humbleness, all those things. And they needed to hear the great things about him. They didn't hear those things. No character witnesses were called. The woman whose child he saved. It's levels and sides to all us in life. We've all done things, we regret. He's 17 years old at the time this happened. What in
Right.
the world could he have done so bad? That's all I'm
Right.
saying. I would have took a chance. I would have rolled the dice. I really would have. I would have rolled that dice. And I
Yeah.
think maybe given a new trial, it may just happen. If he gets a
Hopefully.
new trial, new witnesses, possibly, new evidence, possibly, and possibly Karmelo can get up there and tell his story in his own words. I really do believe that would make a difference from the jury,
Facts.
right?
Yeah.
Yeah, to make
All
a
I'm
difference.
right.
like, I'm
Okay.
laying my plane there.
All right. Thank you. All right.
You're
So
welcome.
we ended on page, and I'm already starting to lose my voice, y'all. So I'm gonna call it. But we stopped at page 145, and I'll just go over just really quickly what the rest of the affidavits are. So Mike Howard's um affidavit ended on page 145. On exhibit 11 is a certification of the counsel that one of the says Rissa Wilson makes a certification as certifying the next affidavits. Exhibit 12 is an affidavit of a woman who was excluded from the trial. She gave her affidavit. She said that let's see, on June 1st, the day jury selection, she went to Collin County's courthouse and sought entry to the courtroom to proceed the proceedings. She was denied entry. I was told by head security Hammock that the area was restricted only to jury members. There was no signs posted, restrictions, or written policy supporting this claim. When I asked for clarification on supervisory review, Officer Hammock/Hammond refused to identify or contact an administrative supervisor. I filed a complaint documenting misrepresentation of the courthouse policy, enforcement of non-existent rules, refusal to provide supervisory access, and improper use of authority by a courthouse. There was no overflow room, alternative viewing room location, audio feed, or video feed was made available to members of the public who cannot be seated. Had an overflow room been provided, I would have used it to observe the proceedings. I returned to seek access on June 6, 2026 and gained entry, but was later physically removed by Officer Hunt, a police officer assigned to the courthouse security. I was removed after making a non-violent, factual, and protected statement inside the courtroom. Officer Hunt falsely accused me of inciting violence, but I did not raise my voice, threaten anyone, or engage in any disruptive behavior. My removal occurred publicly in view of multiple courthouse police officers and staff. I filed a complaint documenting removal without lawful cause, false allegations made against me, failure to recognize protected speech, retaliatory enforcement, inconsistent with courthouse policy, and public removal intended to intimidate and silence an observer. After my removal, my son also attempted to enter the courthouse on June 6, 2026. He was wearing a shirt with expressive content. He was asked to turn his shirt inside out by a courthouse security officer. After passing through the security area, he attempted to use the restroom but was denied access by head security officer Hammock/Hammond. There was no signage restricting restroom use, no posted policy, and no legitimate security concern. My son was denied by the same officer who denied me access on June 1st, 2026. I filed a complaint documenting this as retaliation towards a minor and misuse of authority. During the time I was present, I observed a pattern of targeted behavior by courthouse security police officers, including inconsistent enforcement of rules, retaliatory conduct, personal hostility, attempts to restrict access without cause, and targeting both my son and me. During the time I was present at and around the courthouse, I observed no disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the proceedings. And that was Key West. There was another affidavit that was by Jacqueline. I am over the age of 18. It says, I arrived in Dallas on June 3rd, 2026. I hope to attend the trial beginning with the first day of testimony after jury selection on June 4th. The first day of testimony, I went to Collin County Courthouse to observe the proceedings. July 4th, 2026, only approximately 27 members of the public were admitted. I arrived at the courthouse approximately at 8 to 8:30 a.m. There was no line outside the courthouse, so I went inside and upstairs where I found a long line of members of the public, approximately 80 to 100 people. I took my place in the back of the line and others continued to line up behind me. I briefly left the line to use the restroom and returned at approximately 9 a.m. When I returned, I saw that the line was dispersing. Only approximately 27 members of the public were admitted into the courtroom, and I was not among them. An overflow room had been used, but the rule changed that morning. Before June 4th, I was informed by friends who attended the court staff had admitted members of the public into an overflow room and have been letting in as many people as there were seats available. On June 4th, the practice changed. I understood that rule had been changed that morning so that only approximately 27 people would be admitted and no overflow room was made available to many others who sought to attend. I was unable to attend and the restriction continued. I remained at the courthouse but was unable to gain entry on June 4th, 2026. I spoke with a couple of sheriff deputies to ask why more members of the public were not being admitted. I was told that this was simply the rule for that day. As far as I was able to determine, the same restriction remained in place for the rest of the week. The deputies told me that if a person left after lunch, recess, and did not return, another person might be admitted in their place. But given how strict the rules were, I did not attempt to gain entry in that manner. Because of these conditions, I decided to spend the remainder of the week outside the courthouse with the other members of the public who had gathered there and were unable to get in. I was informed by other members of the public that some of them had arrived at the courthouse as early as 3 or 4 a.m. and still had not been able to gain entry. During the times I was present at and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the courthouse. The thugs that they let in the court, they let the thugs in the court. Shit. Another affidavit from Tara Allen. Let me put this on. What page am I on? I told y'all I was done and I'm still reading. I'm on page 157. Hold on. I'm gonna read a couple more, then I'm gonna go make me some tea, child. Okay. Tara Allen. I'm over the age of 18, sound mind and body, blah, blah. I'm a member of the public. I flew in from Arizona on Saturday, May 30th, 2026 to attend the trial in State versus Karmelo Sincere Anthony, a matter of substantial public interest. I had no role in the case. Because the trial schedule changed and because it was difficult to gain entry to the courthouse, I changed my return airline ticket 3 times, from Tuesday to Thursday and finally to Saturday, to coincide with the proceedings I hope to observe. The statements below are based on my own observation during my efforts to attend the proceedings, except where I state that I was informed of a fact by others. On Monday, June 1st, 2026, I attended and was able to watch the jury selection proceedings from an additional viewing room, which I understood to be referred to as the Oval Room. On Wednesday, June 3rd, 2026, I again attended and was able to observe jury selection voir dire proceedings. Thursday, June 4th, the first day of testimony and the elimination of the Overflow Room. On Thursday, June 4th, 2026, on the first day of testimony, I arrived at the courthouse at approximately 6:30 a.m. I was told that based on the judge's instruction that the deputies were not permitting anyone into the courthouse parking lot until 6 a.m. When I arrived at 6:30 a.m., members of the public were already lined up inside the building. When I asked others what time they arrived, some people near the front of the line said they had lined up outside the courthouse approximately by 5:45 a.m. before the 6 a.m. time the judge instructions had set for access to the property. I pointed this out to two deputies whose names I understood to be Hunt and I believe Holcomb. I stayed in line that day but was not able to get inside the courtroom. Hold on, let me go to the next page for y'all. I stayed in line that day, but was not able to get inside the courtroom. When I asked about an overflow room, I was told that the courtroom where the trial was taking place was the only room that did not have video conferencing Zoom capability or ability to record, and that this was given as the reason no overflow feed was provided. Jury selection had taken place in a different courtroom. Other attendees and I asked whether we could be seated in the room we had used on Monday and Wednesday in order to listen to the proceedings, but we were told no, that the judge had said there was no overflow room. On Friday, June 5th, an uncontrolled line and claims of media status. On Friday, June 5th, 2026, I arrived at the courthouse at approximately 6:04 a.m. There was no direction given to arriving members of the public. I asked the deputies how they were controlling the line because people were walking up and joining others they knew who were already in line. And some people were displaying a badge and claiming to be media, even though credentialed media should not have been standing in the public line. The deputies told me that they did not have instructions on how to control the line, that it was up to the attendees how they lined up, and that they were only to keep things calm each day. A group of people claimed to be media, but did not appear to be credentialed media. They may have operated social media platforms, but did not have a media pass. The 9 individuals who held designated media passes would arrive later, obtain their passes, and go directly into the courthouse without waiting in the public line. I was excluded on Thursday and Friday. On both Thursday, June 4th, and Friday, June 5th, I was not able to gain entry to the courtroom. On each day, I waited until after the lunch recess, but I remained too far down the line to have any realistic opportunity to be admitted. Saturday, June 6, 2026, a public number system that was not honored. On Saturday, June 6, 2026, I was at the courthouse approximately 4 a.m. waiting and driving around the property. The parking lot was barricaded so that cars could not enter. They had before. At approximately 5:30 to 5:40 a.m., I noticed a line beginning to form outside the entrance of the courthouse. So I was dropped off at the corner in order to join the line. The officers told another attendee that if the attendees created a number system, the officers would honor it, and that this was how attendees would be admitted. The attendees then created a number system, and under it, I was number 15. When we were told we could enter, however, everyone ran to the courthouse, and the number system was not honored. Court staff admitted the first 27 people. I was the person immediately after the 27th. I was ultimately able to get in after lunch recess. From my understanding, there were 9 media passes and 27 passes for members of the public. Credentialed media, press, and news personnel had designated passes and did not have to stand in line. On multiple occasions, individuals who operated social media platforms told the deputies they were media and were allowed to move in front of the line. Facts. Ahead of members of the public. Attendees objected to the deputies that persons claiming to be media should not be standing in the public line, and that if they were in the public line, they should not be permitted to cut ahead. Each time, the deputies responded that they had been instructed only to keep things calm and did not know how to control the line. Exactly what I experienced. During the times I was present at and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public inside the courthouse that would explain or justify excluding the public from the courtroom. This was signed by a Tara Allen. I don't know who she was, but child, that's exactly what happened. All right, Exhibit 15 is Tamitra Carter. My name is Tamitra Carter. I'm the over. Oh, let me drink some water, child. I need some tea. Why y'all bringing up Cuff Boys in the chat? What y'all talking about? Okay. I'm not sure what y'all talking about. All right. So this is the affidavit of Tamitra Carter. My name is Tamitra Carter. I'm over the 18. I'm competent, yada, yada, yada. It says, I went to Collin County's courthouse on June 4th, June 5th, and June 6th in an effort to observe the trial proceedings. On June 4th, 2026, I arrived at approximately 6 a.m. There was already a line of members of the public waiting to enter the courthouse because of the limited number of public seats available. I was unable to obtain a seat in the courtroom that day. I understood that the court's order set a specific time for admission of general public. On June 5th, 2026, I arrived at approximately 4:30 a.m. and was among the first members of the public to arrive. When I arrived, I was informed that I could not remain at the courthouse because it would not open until approximately 6 a.m. Members of the public were directed to wait at a nearby church until we were allowed to return. Before leaving the courthouse area, a member of the media recorded my initials and advised me that I was number 7 on the personal list he was maintaining of early arrivals. At approximately 5:30 a.m., members of the public returned to the courthouse. I was the first vehicle waiting to enter the parking lot, and additional vehicles lined up behind me. Before 6 a.m., the sheriff deputies temporarily moved away from the entrance. After hearing the vehicles behind me honk, I believed we were being allowed to enter and slowly pulled forward. When I saw the deputies returning, I immediately stopped because I did not want to enter before I was authorized to do so. After I stopped, 2 vehicles behind me were involved in a traffic collision near the entrance of the courthouse parking lot. Law enforcement responded to the collision, and afterward, we were instructed to proceed into the parking lot. After parking, I attempted to approach the courthouse, but was instructed to return to a stop sign and line up there. By the time I reached that location, approximately 20 or more people were already standing ahead of me. even though I had arrived among the first members of the public that morning. I ultimately found myself approximately 35th in line. I explained to one of the sheriff's deputies that I had arrived early and did not understand how I lost my space in line. I asked whether the line could be organized according to the order in which people had arrived, but my concerns were not addressed. I then spoke with the same media representative who had recorded my initials earlier that morning. He confirmed that I was number 7 on the list that he had created. He attempted to explain this to the lead sheriff deputy, whom I believe name was Brasco or Brasco. The deputy did not recognize the list and directed that I be removed from the line after believing that I had skipped ahead. Because only approximately 27 seats were available to members of the public, being removed from the line prevented me from observing the morning proceedings on June 5th, 2026. On June 6, 2026, I arrived at approximately 3 a.m. because there was no official numbering system maintained by the court. Members of the public created and maintained our own numbering system while waiting in line in effort to preserve the order in which people had arrived. To the best of my knowledge, I still possess a photograph documenting the public numbering system that was used that morning. Members of the public were instructed to walk, not run. When approaching the courthouse on June 6, 2026, I was admitted into the courtroom and was able to observe the proceedings. Oh, I think I know who this is. I think this is the girl who had the purple headband that day that had got kicked out the day before. Based on my personal observation, there was no official system in place to preserve the order in which members of the public arrived at the courthouse on June 5th. As a result, despite arriving amongst the first members of the public and being identified as number 7 by the media representative list, I lost my place in line and was unable to observe the morning's proceedings. On June 6th, members of the public created and maintained our own numbering system while waiting in line because no official numbering system had been established. Yes, this is facts. This was by Tamitra Carter. I think this is again, I think this is the girl who had the purple, because what this sounds like what happened with her. But anyways, I don't know for sure. I don't know her real name. But did anybody want to say anything?
So they just had y'all in the wild, wild west, huh?
That's how it was. Every day. Every day. It was chaos. Like, in order to get in that courtroom, you had to, like, before they started telling us that we couldn't run to the front, at first they was telling us whoever make it to the front, that's the order. They was telling us every single day that they could not honor first come, first serve, that we just have to make it to the front. And it was survival of the fittest. And we would have to literally run to the front. And then they stopped us from running after there was accident. And the people got into an accident. Then they were like, oh, y'all can't run. But they would not enforce first come, first serve. They would not. Like, it was chaotic every single day. Like, every single day, it was chaos.
It's like, their tactics, though. They like to sow chaos, because if it's chaos, they can orchestrate what they want to orchestrate and bring in who they want to bring in while you in chaos.
Mm-hmm.
That ain't. I bet the other folks will get text messages
and try to justify unjust rulings and restrictions and secret filings and gag orders, and use all of that. They created chaos to try to justify that kind of stuff.
Yeah, it's crazy what the lady in the red hair could get in. That is crazy.
Mm-hmm.
She probably got a text message.
She's able to get in with the red hair and everything, but she's the main one creating all the problems outside.
That's how it
It was
went.
probably about instruction though. That's the situation. That's what I think people expected Collin County to be like the rest of America's courts. It ain't like that, man. It's still the 1800s over there. They just nice about it. They might not burn a cross in your yard, but they wish they could.
Right. That's definitely what it seemed like. All right. I'm gonna read through a couple more of these and then I'm gonna for real call. I said I was gonna call it at 8 hours, child. I'm still going.
Do you think it's odd that that white media is not calling out the dad or the mom about the racist stuff that they've been saying online or in interviews?
No, I mean, we saw in Chud the Builder case, the guy who he shot was a veteran. None of the reports said veteran, victim, anything. We saw in Florida how the white man who was the aggressor is labeled veteran father is fatally wounded in parking lot. You know, they shape it those type of ways on purpose. They always, whether the black individual is the victim, they always color the headline for white people who are alleged to be the victim or the whatever, even if they are the aggressor. That's what they do.
I mean, I'm just saying that because they went on all these the dads went on all these platforms. They didn't say nothing about him calling Karmelo a watermelon felon or anything like them well, him being racist towards other minority groups as well. It was just weird to me.
It can't be weird to you like that though, because let's say I'm a fighter, fam. So let's say I'm in your corner and you having a fight, right? And you break the rule. You think I'm gonna tell them folks you broke the rule? You think I'm gonna tell them you hit if the ref didn't see it, the ref didn't see it. And if the other corner calling it out, that's the other corner business if the ref don't respect it. That's basically the situation, man. Them folks is on them folks' side. They don't care nothing about us.
All right, I'm gonna read a few more and then for real, I'm gonna call it. All right, so where we at? This is the affidavit of Bridget. It says, I went to Collin County Courthouse to observe the proceedings on June 1st, 4th, and June 5th, and June 6th. On June 1st, 2026, I attended the jury questionnaire session. I understood that the questionnaires would be completed that day and that jury selection would begin later the week. When I arrived, I asked the court coordinator where members of the public would be permitted to observe and whether any accommodations would be available given the significant public interest in the case. Officers led us to a room to sit, and it was my understanding and everyone else's that we would be able to view the jury selection from there. We sat in the room for about an hour and began to ask questions, and someone came in and told us that jury selection was being held upstairs. While we were all downstairs, we got up to see for ourselves and found a room full of people down the hallway out of what appeared to be roughly 600 people. We saw only a handful of Black people. One of the officers from the room where we had been seated came and told us we could not be down there, and then we needed to go back because they did not want us to taint the jury pool. I responded that if that was the concern, I did not understand why White Lives Matter had been allowed to pass out propaganda about the case to people going in. A paper using the wording Austin's murder, which I was concerned would already taint the pool. We were sent back to the room where we were not permitted even to view the proceeding on a television. We were told we would not be seeing anything. In effect, we would be sitting in the room the entire day for no reason, and no one was going to notify the people sitting there. We let the others know that most people left, deciding to return on Wednesday or Thursday. I understood that the court's order set a specific time for the admission of the general public. We were told we had time to get into the room and that we could not bring phones in, and people were even moved around in seating. only for us to learn on our own that they were going to allow us to sit all day and view nothing. The court house was closed on June 2nd. Jury selection began on June 3rd. On June 3rd, 2026, I decided not to attend jury selection, but to attend on the first day of opening argument, which was Thursday. On June 4th, 2026, the first day of testimony, the court eliminated the additional viewing location. From that point forward, public access was limited to approximately 27 seats inside the courtroom. No overflow room, alternative viewing area, audio feed, video feed, or other accommodation was provided. When we arrived, there was a very long line of people in two lines. One for the people on the media list and the other for everyone else. When they cut it off at 27 people, we asked whether there was an overflow room, and we were told no. Public seating inside the courtroom was limited to approximately 27 seats. Although the court order stated a time for public admission, in practice, admission was determined by how early a person arrived, that person's place in an informal line, not by the time stated in the order. Members of the public began arriving as early as 4 a.m. to 5 a.m. to compete for the few available seats. And those who arrived after the line had formed often had little to no realistic opportunity to be admitted. On June 4th, 2026, I was unable to gain entry to the courtroom and was excluded from that day's proceedings. I stayed in the parking lot with others who had been turned away. Some people left. Some people had driven in from other states and deciding they would not have an opportunity to observe, made plans to travel back home. On June 5th, 2026, I again attempted to attend and was again unable to gain entry because of the limited seating and the admission process. We learned that when people took breaks, they were told someone else could take their spots. So we went up to try to obtain a spot, but only about 6 or 7 seats were available for passes. As a result, some of those who had been waiting were unable to go in, while some people had left on their breaks were not able to regain access. On June 6, 2026, I did not make it into the courthouse, but other people who had come with us decided to go and keep us updated. Conditions I observed. During the times I was present in and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the courtroom. Yet I watched the court personnel remove people to whom they had given passes over small, petty matters. One of the male reporters from South Carolina, who had been present from the beginning, was made to leave, as was another woman who had been inside. In my observation, neither of them did anything to warrant removal. And I believe the reporter's rights were violated because they attempted to tell him what he could and could not say. And when he tried to assert his rights in the public courthouse, they told him to leave. On June 4th, June 5th, and the morning of June 6, 2026, I and other members of the public were unable to observe the proceedings. The seats available to the public were few. The additional viewing location used during the jury selection was discontinued once testimony began, and my ability to observe the proceedings was significantly curtailed as a result of the limited seating, the elimination of the overflow room, and the manner in which access was administered. So they have other affidavits. That was 16. They got 17, 18. What is this? Correspondent between Thelma and Steve. I think this is the jury instructions. Okay, they have the jury instructions in here, the verdict sheet, the affidavit of Nakia. The what is it? Okay, so that's it. Um,
You know
yeah,
you're going live again. You ain't got to read it all at once anyway.
yeah. I mean, that's pretty much Nakia's affidavit is long. She got like paragraphs, but I was trying to get it all out the way so that I could just clip, clip up the
Makes
the
sense.
different parts instead of going live again. Just
Somebody just
make
asked a crazy question in the comments.
oh, what they say.
Talking about, but who brings a knife to a high school match? Nobody. First of all, everybody I know, every man I know, takes a knife everywhere. Ain't no telling what you might need it for. You go to your mama house, she might want to cut a box open and ain't got nothing to do it with. You go somewhere you might need to, like I was doing, you might need to help somebody set up a tent. You never
Yeah.
know what you might need a knife for. A pocket knife is just that, a pocket knife. It's for your pocket. It's for anything. It's for utility. And it ain't meant to kill nobody. So that's a stupid question. That's just not smart to ask. And that just shows where you at. You know, if you don't, and I guarantee this person who asked this question, I guarantee somebody in their family carry a knife everywhere they go.
Mm-hmm.
It's a crazy situation, man. It's the whole situation is them folks. Okay, testosterone got these boys into an altercation. Testosterone and what I think was a little bit of hate behind old boy anyway. But because after hearing his daddy talk, we know how he viewed Karmelo anyway. And then Karmelo was small, so he felt like it was easy prey. So anyway, but
Mm-hmm.
any teenage boys could have got into this altercation though. So we gonna just say testosterone is what got these boys into this altercation. But if you picking on somebody and you walking up on them and you put your hands on them and they ain't did nothing but say words to you, and they told you leave me alone. Touch me, I'ma defend myself. And you still went on and did that. You thought you were bad. Hey man, listen, man. You deserve everything coming to you. And that's just what that is. And I don't care what color you is, what race you is, where you from, who your creed is, what you believe in, who you pray to. They ain't got nothing to do with the situation. If you put your hands on somebody and they defend themselves, you got what you deserve, however that happens. So, all the disingenuous questions, and then and people in the comments talking about Jesus. Hey man, I love Jesus too, but we ain't talking about him right now. Jesus see you. Why you talk? Why you speaking the name? If you speaking the
Um,
name for the wrong reason,
I
that's your
want to
business.
address this person right here. They said the county he is from is 45 minutes away from me. Trust, no knife was needed in that white county.
Yeah,
What
that's
does
that
it
person.
being a white county have to do with anything? You guys have violent histories as well. There's a lot of SA in your community and all of that. How are you going to say what's needed in a white county? Are you saying that no white people
Yep.
ever commit crimes? Are
That's
you
the same
saying that
person.
only black people commit crimes? I
Oh,
mean, the racism in that county just exudes. On
we
that
can
note,
go through the statistics.
yeah, we can go through the statistics. They have the highest rate of SA.
It's a different rule book
They
for
got the highest
black
rate of
people and white
every
people.
crime.
That's what, in so many words, that's what that person just said.
You know the only
Right.
thing they don't lead in wrongful convictions. That's us. They got the highest rate of everything else though. Yeah, they ain't that we can't. Out in that white county, they let you know where you at with it, man. And the whole situation is everybody on that jury, everybody in that courthouse, other than their boy parents, believe how that little old demon right there believe. That ain't got nothing to do with this situation, man. The situation is you want to uphold the law when it's in your favor, but when it ain't in your favor, who brings a knife? That
But
ain't
it
your
comes off to me as like a lot of the black, a lot of the black kids that was in that that trial knew how to go along to get along, and they pretty much been doing that their whole life. I mean, going to school with the Medcab boys and all the other racist kids that they went to school with, so they wasn't going to stand up for Carmelo.
Yeah, see, that's the problem. That's what bothers me about black folks. And you know, I love my people, but this the thing, right? We do a lot of going along to get along. We decide that it's a better education, it's a better living, it's a better life over there with them folks. Whole time that is not the situation, man. You got black suburbs, you got great black schools. The best Southwest is one of the best areas you can live in for anybody. But you know, we decide we want to go with them folks. That's how you get Nolan disappearing on the trip with his little partners. That's how you get that lady that disappeared on her trip with her little old friends, so-called friends, in quotations. You know, it's
Yep.
asterisk next to that. That's how you get this situation, because black people, I mean, for the most part, we don't see color. And that's crazy. Like, we see the content of your character, or at least what the character that you show us. That's how we judge you. But the whole time, these folks been judging you by your color since they met you, and just been smiling in your face, because that's what they get. That's how they get what they want at you. Yeah, they need black friends, so they say they not racist. They got black friends. Yeah, all of those extra. So, you know, if you get around them folks and the snake bite, hey, it's a snake. Now, don't get it twisted. I got white friends. I'm not going on a trip with just them, though. You know, it's I got people of all kinds of races and creeds that I'm cool with, but I'm judging you off the content of your character, like I just said, but I'm not going along to get along. I also been in Carmelo's shoes. I went to Mojo. It's a whole, it was the school on Friday Night Lights. It's a whole different situation over there. And black folks make up 3% of that little old town. And for the most part, they go along to get along, or they all the way out there and don't go along at all. And it's a very few of them. And you know, me being me, I always been a hard head, so I didn't go along with nothing. I'm gonna be me, regardless, and you gonna deal with it or stand in front of it. But them folks don't understand you or your plight because they don't want to. And when you go along to get along, they call you one of the good ones. You know what I'm saying? Until they decide to get rid of you, and then they use the law to get away from get away with it. So you know,
The token black person, the token black person.
yeah, absolutely, they need those. So going along to get along is not a situation that we supposed to ever be in, man. I don't do no code switching in the professional sense, none of that. If you, man, listen, if you got to change who you are to do something, it's probably not something you should be doing.
All
That's
right.
just,
So we're gonna end on that note because I'm over here, eyes getting low.
yeah,
It's
go
2:30
go ahead there.
a.m. for me. My voice is going. I gotta go make me some tea or something. But thank you so much, Freight Train. Thank you so much, Michael. Thank you so much, OG, Patrice, and everybody who came
Yeah,
up
because I
here.
gotta be at work at a 1, so I'm gonna get some sleep in.
All right,
I'm
go
gonna
ahead
go
and get you
run.
some sleep. Thank you for coming up. Thank you again, Freight Train. And I'll catch you guys all on the next video. If you guys see clips of this in shorter form, definitely still engage in the content, share, comment, because I have to break up some of this live into smaller segments. So definitely check out the re-uploads that I'm going to have after that. All right, let me go get me some tea, y'all. Good night.